And just like that, we're back from lunch. Hopefully, now that I'm well fed and a little more rested, there'll be no more technical difficulties as far as the video. Like an amateur, I did set the broadcast to start at 1:55 instead of 11:55, but we'll pretend that didn't happen. Don't tell anyone. And hopefully, I can only say hopefully since this is a sovereign citizen trial. Nothing yet. I just had a nice sauerkraut lunch, leftovers from Sunday. My oma taught me how to make sauerkraut, so I actually do make it pretty good. Um, I was just saying before you hopped on, hopefully I did the video right this afternoon. I did set the broadcast to start at 1:55 accidentally, but luckily I could just hit go live and start it at 11:55 like I meant to. And preschool got out for the day during my lunch. So hopefully there's not too much distraction because in the backyard, my dad, my sister, my sister in law, and my two youngest nephews, one's 4 and one's about to turn 4, are having donuts. So hopefully they're not too loud. And I'll probably have a mid-afternoon snack, my of my own donut. Uh, my sister went to Banbury Cross. You're probably the only one that will appreciate that, unless we miraculously, in the exponential growth, get another Uton in the stream this afternoon. um, and I was about to say, hopefully, the title of the afternoon stream isn't accidental clickbait like this morning's stream, where I named it opening statements and they didn't quite get to it. But that's the risk you take when you live stream another live stream. And sovereign citizens aren't exactly worried about other people's schedules. Their delay tactics are to be expected. So, and by my clock, it's exactly noon now. So I would expect the court should come back from its recess imminently, because I believe the judge said 1 o'clock, which is noon here. And unlike me, Law and Crime has kept the morning's live stream running. So when it returns, hopefully it just comes back live and I don't have to do anything. Which I think they do tend to do it that way. They looking at their past streams, their live trials do tend to be 8-ish hour streams. So, I think sovereign and inconsiderate are synonyms, aren't they? At least in this context, they certainly are, along with certain other words like obstinate, childish, obnoxious. I can't complain about that one. I try to be childish too. I think misinformed is accurate, but I think it's also too mild a word because th- there's an element of intent that I think misinformed could be a rather low level, but there's a major intent to their misinformation. So definitely intentionally misinformed. It I think they've actually purchased the Brooklyn Bridge. That's the level of gullibility and misinformation that is involved. At least that's my take. Did you have a good lunch? Like I said, I had leftover sauerkraut. Due to my nocturnal nature, I don't actually tend to eat lunch very often either. I tend to sort of graze, but other than my mid-afternoon donut, I figure it's probably best not to eat too much on stream, so I did get some food in me. And while I love good sauerkraut, with a special emphasis on the word good, because most people don't make good sauerkraut, it does have the ability sometimes. I I don't know if it's the acidity of it or just the fact that the cabbage is pure fiber, but it can get my stomach turning in knots. So hopefully that doesn't happen. Of course, this is other than Tuesday, I've had sauerkraut at least once a day since Sunday when I made it, so it's almost gone. All right. Well, I'm glad you're back. I'm glad Static's back. I'm back. Now we just need the judge and jury back. I've been explaining to Static how I had leftover sauerkraut for lunch, and my sister-in-law, dad, and two nephews are out in the backyard eating donuts, and so I stole one to have for my mid-afternoon snack. I hope you had a good lunch break, John. I don't actually know where you are, so it might have been a dinner break. And if we get her back with a charged phone, Miss Starlight might be coming in eating breakfast there in New Zealand. Georgia. I I don't know if I count this as being to Georgia or not. I tend to say if I've left the airport, I've been in a state, but if I'm just passing through, I don't really count it. And so, like, I've been to JFK Airport, but I didn't leave it. So I've never been to New York. Georgia is a funny thing because, as you know, Atlanta is the home of Delta. I have two uncles who work for Delta here in Salt Lake, so I fly on their buddy passes relatively frequently, which means I've had to spend the night in Georgia due to not getting on a flight. And so I left the airport, spent the night in a motel, went straight back to the airport in the morning and got on a flight. So that's kind of in a gray area. But I need to go at some point. My dad's cousin, who is closer in age to me than to my dad, lives in Peachtree City, south of Atlanta. And I don't get to harass her nearly enough. So I need to go harass her in Georgia. And I can't say I'm familiar with the gun law. I I'm not a huge gun person myself, so I don't follow gun laws very closely. I I do have a 22 rifle, but I view that more as an heirloom than as a firearm. I've never used it. I've never owned any ammunition. I just it's something I inherited from my opa. I think I may have heard of that, and I say I may have because I think you might not be completely unique. Utah has had some funny laws like that, and I wouldn't be surprised if some southern Utah town has passed that. There's there are Utah towns with absolutely great names, and one of them way down south near St. George, if you know where that is. It's on I-15 right before you cross into Arizona on the drive from Salt Lake to Vegas. And it's in a region that's referred to as Utah's Dixie. And I'll get to you, Static. But close to St. George is a small town called Laverton, which at the time they made the news, my friend mistook Laverton for Merkin, which is a, shall we say, it's a downstairs wig, if you don't know what that. what a merkin is. And Laverkin declared itself a UN free zone. So the United Nations was not allowed in Laverkin. Not that they'd have any reason to ever go.
Thank you, everyone. I wanted to put one back on the record. I wanted to put
I have friends who passing through Beaver, which is the home of Butch Cassidy. He was born in Beaver,
given
Utah.
The number of victims,
but they sell hearts. They sell T-shirts. I heart Beaver.
Behind the prosecution table for victims. They will no longer be available for media or the public. From my perspective, there's ample room on the other side of the courtroom. I'll ask the district court administrator to assist me in modifying the trial administration order, but that was my observation throughout. Ample seating, that does take away a bench from the media, but from my perspective, they've been watching, I think, from the media room based upon the full feed, and they no longer need the 2 benches.
Oh, you mean the city of Beaver?
Really appreciate that. You're welcome. All right, then I'll have the jurors brought out momentarily. I just want to get confirmation from the bailiffs who are with Mr. Brooks.
My opa is from Spring City,
based on my direction.
Other side of the range from Beaver, pretty much.
Here. I don't know what his response was. Mr. Brooks, I'll
Sanpete County.
Ask you and advise you, you are welcome to come back to this courtroom. You've been conducting yourself in that courtroom at least prior to the break.
I understand Beaver is a good place to follow the speed limit notes, on the interstate.
Perhaps even following along with the written jury instructions. I know you filed 2 objections. Those were addressed earlier. Mr. Brooks, if you're willing to abide by the rules of courtesy and decorum, you are welcome to come back. Would you like to come back to the main courtroom?
He's not willing to follow the rules.
You're on the record. Would you like to come back to the main courtroom? And if I could just get confirmation from the bailiffs. I know the audio was tested. I was under the impression it was working, both audio and visual.
Once again, I'll do my best to mute coughing fits.
Do you know if anything what I said was picked up? Okay, thank you. Looks like Mr. Brooks is.
Did you ever spend winters
them to see if they
there enough to try out the
I don't believe
Eagle
he had
Point
those on prior to the break?
I've never been, but it looks like a beautiful ski resort. Tiny by Utah standards, but it looks beautiful.
The last hour of the morning session, he was not wearing the headphones, Your Honor.
Thank you. I believe those headsets do need to be charged on occasion, so there are other headsets that can be provided if that one is not working. Looks like a new battery pack, charger pack for that.
Hopefully, once she finishes the jury instructions,
attachment that gets charged, so
they go straight into the opening statements. But once again, with sovereign citizens, you never know.
Mr. Brooks, I am offering you an opportunity to come back to the main courtroom. Would you like to do that?
He doesn't consent. But he also doesn't consent to not return.
Can you repeat that again?
I say yes.
You'd like to come back? All right, we'll have you brought back then. Thank you. We'll be in recess until that is accomplished.
All right. What are the bets? How long does he last? I I want to see your guys' bets before I give mine. And I'm not dreading it. I'm looking forward to his opening statements. It is going to be a mess. "25 minutes," says Static. What do you say, John? 5 minutes? My guess is it's going to be closer to John's. And I'm going from when the jury returns. I should clarify. My guess is 7. I'll even put it in the live chat. Since sovereign citizens and auditors demand everything in writing, I'd have it notarized if I could. But all right, we'll we'll take note. I imagine the jury comes back in pretty quickly once he's back, because I think most of the afternoon business is in front of the jury. I wonder if there's a court order that recesses need to go to the title page, or if this is just law and crimes choice. Because I think, in a way, I understand why they do it, but I also think even if the audio feed is cut during recess, there still could be interesting commotion during the recess. E- If you get what I mean. Because even just seeing how people are shuffling around can be interesting. When it comes to adding things or drinking things for a meal, I really find ginger ale is about as refreshing as it gets. That or nice cold water. My my grandpa on my mom's side, on the very Mormon side, grew up in Plain City, Utah, which is northern Utah, kind of in the Ogden area, um, near the Great Salt Lake. And he he had a pretty distinct rural, old-timey Utah accent. And like I said, very, very, very Mormon. Uh, I don't think he looked at alcohol in his life, let alone drink it. But he was a man of few words. But we'd always tease him about this because he'd take a sip of cold water and say, that's good water. And I think to a lot of people, water's water. But 20-ish years ago, there was a publication that had sommeliers try out water, municipal tap water.
122.
And they
the
judged
record to reflect
Salt
that
Lake
Mr.
as having the
Brooks is
best
back in the
municipal
courtroom.
tap water.
I do want to make a further record that
And I can
he
see
still
why.
remains in his jail attire. Prior to the break, I did advise the captain and to let Mr. Brooks know that he certainly could take the opportunity during the lunch hour to.
Of course, there are
put on
areas where it's
street
pretty
clothes.
terrible here. Looking at you, Magna.
So it's his choice. He is here in the jail attire. He's at the table, continues to be masked. Welcome back, Mr. Brooks.
They never asked me during the break because I had so much other stuff going on. I'm not sure. I'm not saying it was intentional on their part, but I was never asked. I just want to make that clear for the record.
Thank you. I appreciate that clarification. Nonetheless, I provided
In
you with
high
that
school,
opportunity, and here
I
you are.
volunteered with the training
Please
room.
Be mindful, sir, that the
Medical
right to
staff.
be here can, of course, be
And
lost if you engage in disruptive.
We had a player
discourteous,
injured when we were playing at Cypress
behavior
High
if you
in Magna.
interrupt the
And
decorum and do
The
not show
injured player
respect
had a flat
for the
pad around his
judicial
kidneys.
proceedings. You would, of
And
course, be subject to
The trainer asked me to
removal and
unscrew it
forfeiting your right to be
to give it
present
to
in
another
this
player, and my hands
courtroom.
just were sweaty and gross from the player
All right, is
from
there?
dealing with
I'd
his
like to
pads.
bring the jury.
Went in
out,
at
Mr.
halftime to
Brooks.
wash my
We
hands.
are,
I felt
or
dirtier
I am
after the
still
Magna
going through
water
the
than
preliminary
from
jury instructions.
the sweat.
I know you filed some objections. Those have been noted for the record, as I advised
Of course, I blame
earlier
Kennecott,
this
not
morning.
Magna
Because
itself.
I've approved of them, there should be no objections. You had ample opportunity to do that. So I'm instructing you at this point
There
not
should
to
be no objections.
object, because I will consider whether that's being done for disruption. If you have an objection, write it down on a piece of paper, pass it to the bailiff, and I'll take it up outside the presence of the jury.
Just so I'm clear, are we talking about objections to strictly jury instructions or the filings that I filed on the 3rd?
I'm not addressing those at this point,
I
sir.
was just asking for clarification. I didn't know which one you were speaking on as far as the objections.
I'm talking about objections during this court hearing to the court going through the preliminary jury instructions.
Okay, I was just asking for clarification.
Right, I'm not addressing any of those filings. I previously addressed those. It may not be to your satisfaction, but
He'll never be
and I'm
satisfied.
not going to repeat myself. So the record speaks for itself. Your objections in those filings, to the extent, whatever they are noted. They're part of the record, and they will be available for you at a later point in time should you be convicted and on appeal to make whatever arguments that you need to or want to regarding those. But from my perspective, that is something I'm not going to take up any further. And any attempt by you to do that, I will have to consider whether that's being done to disrupt the proceedings and not for legitimate
I'll mark the
reasons.
time.
Reason for bringing it up was to make sure that they are offered into evidence.
Sir, we're not at the evidentiary phase. They're part of the record. They've been received. So at this point, there's no evidence to be taken.
It's not evidence. The jury
We're
will
not
never
at that
see
stage
these
of the
motions.
proceedings. So you will have an opportunity after the state presents their case in chief and they rest to then present your case and to present evidence that's relevant to the issues before the court and the jury. So I'm not going to go through any further on what that means. That would be for me to provide you with an explanation of the law or procedure, but I expect you to not bring that up at this point in time or going forward.
I don't understand, though, Your Honor.
Mr. Brooks, I've already addressed them. I'm going to bring the jury out.
Does he
Please
not
do
understand
not
or comprehend?
Disrupt as the jury comes in and as I complete reading the preliminary instructions. I am, just for reference for everyone, I've read through 44 pages of 69. And so I still have
Nice.
a ways to go. My
I think that's obligatory,
intention would
isn't
be
it?
to finish
And
with
that's
the
good water.
preliminary jury instructions.
From
Take
my
a short break
U-Law
for all,
thermos.
including the jurors, and then come back with opening statements. And that's, you have a choice, sir, at that point, whether you want to give one, but the state goes first because they obviously have the burden of proof. And then you would have an opportunity to give an opening statement as
He
well.
can
That's my
defer
plan, at least
his
for the
opening
afternoon.
statement
I'd like to
and
go
give
back
it
over there, Your Honor.
after
You would like
the
to
prosecution rests its case and before he
you're
presents his
asking
case
that
in chief.
to voluntarily be taken to that courtroom.
I'm trying to seek to understand how the testimony evidence that was given.
No
Mr. Brooks,
testimony
I've
has
already
been
dealt with that. I'm
given.
not going to deal with it. If you want to go to that courtroom, are you waiving your right to be present right now?
Can I at least raise the issue of subject matter jurisdiction? That's
No, there's no lawful motion before the court. You may not.
And the court has already ruled it has
Mr. Brooks,
jurisdiction.
I'm going to bring the jury out. I'd like you to stay. That's my preference that you stay. You've certainly demonstrated throughout these proceedings that you have the capacity to follow the rules, that you have the intellect to make cogent, coherent, articulate, responsive arguments when you so choose. But when you start doing what you're starting to do right now, going back to filings I've already addressed, and start talking about subject matter jurisdiction, that is a tactic by you that I believe is to disrupt and to delay the proceedings.
It's a good thing the jury's
Accurate, Your Honor.
still not quite
The
in
objection to
yet.
my characterization of that is noted.
I would like to make a motion for finding the fact then.
Your request is denied.
On what basis?
Your request is denied, sir.
Your Honor, I'm merely seeking to understand on what.
Mr. Brooks, I refer you once again to document 244 that you signed, that you acknowledged, dealing with the right to waiver of right to attorney. We went through all of the advantages, the
They spent
disadvantages.
2
You were
whole
advised of
hearings over
things,
2 days.
including the charges that you face, the penalties that go along with them. We
The
discussed
peril
the
he
difficulty
faced.
of representing yourself. You made a deliberate choice to waive your right to an attorney, which this court honored.
And I'm assuming that
And
because I
you,
both
Mr. Brooks, don't interrupt
my audio
me,
and
okay?
the
Now,
video's audio are
that's at least the
both coming
second
through.
time. So don't interrupt me. I'm going to continue with these proceedings.
I'm assuming
Even
since
though
you
you're
haven't
mild-mannered,
chastised me about it,
even though
not.
you're speaking in a soft tone of voice, the conduct still has the same effect. And that's to disrupt, to delay, and to show disrespect for the court proceedings.
It is not. It's not my
Mr.
intent.
Brooks,
It's not my
please,
intent.
I'm not going to force you to sit down. You're welcome to sit down, but I am instructing the jury to come out. You, at your peril, run the risk of me admonishing you in front of them at this point. I don't want to do that, sir.
I'm seeking to merely understand.
Sir, I cannot give you legal advice. I cannot give you the understanding that you want.
I'm
all
not
right?
asking for legal advice.
I cannot explain court procedures or the law to you. So with that, Mr. Brooks, that's
As you
another
often hear
interruption.
in
You keep
sovereign
going.
citizen
Stop.
videos,
Really to understand, Your Honor.
it's
I
not
got
the court's
understanding
job
nature
to
and
answer
cause of the
questions.
charges.
It's
Mr.
your
Brooks,
it's
I've
your
already dealt with
attorney's
these.
job
Your-
to answer questions.
Subject matter.
Mr. Brooks,
jurisdiction.
if you keep
Unfortunately,
interrupting me,
he has
then
no
you will
attorney.
forfeit your right to be present because you're showing through your conduct that you will not follow the most simplest rule of civility in a courtroom, and that's by not interrupting. You continue to interrupt. It's been a couple of minutes since we've been on the record, and there's been a number of times you've already interrupted me. You claiming to not understand.
It's hard to count the number because it is constant.
Matter jurisdiction. Do not. It's just a tactic by you. The fact that you are doing that demonstrates to me that you came back over here, right, with absolutely no intention of following the rules.
If that's what you want to say, that's your assessment. It's not accurate.
Well, my assessment will stand on the record, sir. It's based on my observations. So at this point, Mr. Brooks,
I respectfully object
stop
to
interrupting me, please.
There's nothing
Stop
respectful
interrupting me, sir.
about what he's doing.
If you have an objection, write it down.
I thought that applied to me being.
It's applying right now since you keep interrupting me while I'm talking.
So what is the purpose of me being present if I'm not able to ask simple questions that I do not understand? I'm
Mr.
just
Brooks,
seeking.
I've been
I'm not
more
asking for
than
legal
patient
advice
with you. And the issues that you keep trying to raise every time we're in here are not issues I'm going to raise at this juncture or address at this juncture in the proceedings.
Is there
All
a
right,
reason why?
I'm not giving you advice. I'm not explaining the law. I don't need to do any of that, sir. All right, you filed what you needed to file. I've addressed every single filing on the record. It may not be to your satisfaction, but I have addressed them.
That's inaccurate,
all right,
Your Honor.
some of your
With all
filings,
respect.
sir, you're interrupting me yet again because you're not letting me finish with my explanation. Some of your filings do not require a specific line by line response by the court. I've addressed them in the way that I believe the law requires me to do. Again, that may not be to your satisfaction, and that is simply the way that it's going to be. But we are continuing on with the reading of jury instructions. It's important. They're going to come in, and it will be up to you whether you can demonstrate respect and courtesy, not only for these proceedings, but for the jurors that have been selected to hear this case. Madam Clerk, have the jurors brought in, please.
What you're doing is judicial misconduct. You're making the judicial determination, and I'm not allowed to ask questions.
It's her
And I'm
job
not allowed
as a
to question
judge
Your Honor,
to make
which is my right.
judicial
I've
determinations.
merely brought up subject matter
Imagine that.
jurisdiction because it has merit. I've merely
It has no merit.
tried to seek to understand the proceedings. That
She's
I do not
already
understand.
denied his
You're
jurisdiction
rushing me to
arguments.
judgment by constantly removing me from the court when I should be present for all proceedings, and I should be able to understand, which I do not. Once again, I
Then
do
get
not
an attorney.
understand the charges, the nature
Get
of the
an
charges
attorney.
against me. I do not understand why Your Honor will not answer mere questions that would give me clarification on understanding.
That's an attorney's
I'm
job, not a
attempting
judge's.
Purposely to be disruptive, disrespectful in any manner.
And yet, you're
But if I don't
succeeding at
understand
it.
something, it benefits me to ask so that I can have clarity. The waiver that you speak of with the attorney, I gave the right the waiver back in the way that I felt that it should be altered, and you said so yourself on the record that the word understanding was taken off of that paperwork that I sent back to you. That
Probably because
right
you're
there
using it in the
further that I did
sovereign
not
citizen
understand the
stand
proceedings,
under
and that was some of the issues
as
that I'm
opposed to
bringing
the
up now. It's
comprehend.
merely just clarification, Your Honor. I don't understand what is going on. It's not to be disrespectful. It is not
Mr.
to
Brooks,
prolong the proceedings.
do
It
you
is
understand when I tell you not to interrupt me?
No,
Do you
no, I do not.
understand when I tell you you need to follow the rules of decorum? I believe you do. Please sit down. The jury's coming in.
By now, she should realize she should use
I still
comprehend
would like to
instead
ask
of
a question.
understand.
Stop talking. We are proceeding with the continued advisement to the jury of these preliminary jury instructions. Do not interrupt me The record should reflect that the jurors are entering the courtroom.
Your Honor, with all due respect.
All
Mr.
right,
Brooks,
12:37.
stop talking. It's not appropriate at this point in time. You'll have opportunity
I disagree.
later to raise other issues, but the issues that you seek to engage with this court are issues I've already addressed.
You have not shown proof.
Mr.
that
Brooks,
You have
the
not
jury
shown.
is in the court.
Judges
I
don't
understand that.
You
present
continue
proof.
to talk despite being told to sit down and to pay respect to this court, to these jurors, to the process.
It is my right to stand or to sit, Your Honor. It's my right.
Mr.
I'm
Brooks,
merely
you
exercising
can
my right.
stand, you need to be quiet. Thank
Your
you.
Honor, Your
Mr.
Honor.
Brooks, please stop. I'm going to continue with the instructions. If you interrupt me, you will run the risk of
I guess
being
maybe we
taken
should
to the
say
courtroom next door.
when she says something to the effect of,
Mr. Brooks,
welcome back.
final warning.
I'm seeking to understand, Your Honor. It must be some clarification.
Mr. Brooks, I want you here.
I want to
Stop
be here.
interrupting me.
You were quiet. I didn't.
Mr. Brooks, stop talking so I can read through the instructions.
Your Honor, can I?
Ladies and gentlemen of
You
the
can-
jury,
you can
I'm going
move
to
me to the other
continue
team.
with the jury instructions. I'm on count 38. If you are satisfied beyond a reasonable
All right,
doubt
well, they're
that all
definitely
three
in now.
elements of first degree recklessly endangering safety have been proved as to count 38, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 38. If you are not so satisfied, you must find the defendant not guilty as to count 38. If you find the defendant guilty of count 38, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly
If I
endangering
were a
safety while
fancy
using a
streamer, I'd add
dangerous
the
weapon?
Jeopardy music.
If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 39, you should find the defendant guilty of first degree reckless endangering safety as charged in count 39. If you are not so satisfied, you must find the defendant not guilty as to count 39. If you find the defendant guilty of count 39, you must answer the following question.
If I
yes
were
or
a
no.
juror in there,
Did the defendant
I'd
commit
find
the
it
crime of first degree
unnerving
recklessly
that
endangering
he's
safety while using
standing
a dangerous
and no
weapon?
one else is.
If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 40, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 40.
The gag would come out
If you are not so
a
satisfied,
lot
you
sooner
must
than
find the
25
defendant
minutes if I were a
not
judge.
guilty as to count 40. If you find the defendant guilty of count 40, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree
Of
recklessly
course, I'd
endangering
only do it
safety
like
have been
once
proved
through
as to
for the
count
meme
41,
effect.
you should find the defendant guilty of first degree recklessly endangering safety as charged in count
And
41.
promptly get the stream
If
taken
you are
down for
not so
copyright
satisfied, you
violation.
must find the defendant not guilty as to count 41. If you find the defendant guilty of count 41, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements
right.
of first
We're
degree
about
recklessly
two-thirds
endangering
through.
safety have been proved as to count 42, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 42. If you are not so satisfied, you must find the defendant
One of these
not
days I'll
guilty
figure out
as to
how to
count
use
42.
OBS
If you
or
find the defendant guilty of count 42, you must answer the following
one of
question,
the
yes or no.
more advanced
Did the defendant commit the
streaming
crime of first degree
platforms.
reckless endangering safety while using a dangerous
I
weapon?
think StreamYard is based on OBS, but basically
If you are satisfied beyond a reasonable
Makes
doubt
it
that all
easier.
three elements of first degree recklessly endangering safety have been proved as to count 43, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 43. If you are not so satisfied, you must find the defendant not guilty as to count 43. If you find the defendant guilty of count 43, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon?
Yes.
If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 44, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 44. If you are not so satisfied, you must find the defendant not guilty as to count 44. If you find the defendant guilty of count 44, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 45, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 45. If you are not so satisfied, you must find the defendant not guilty as to count 45.
Say moo to them for me.
If you find the defendant guilty of count 45, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 46, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 46. If you are not so satisfied, you must find the defendant not guilty as to count 46. If you find the defendant guilty of count 46, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree reckless endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 47, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 47. If you are not so satisfied, you must find the defendant not guilty as to count 47. If you find the defendant guilty of count 47, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon?
I'm a minute away.
If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 48,
for a minute I thought that
you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 48. If you are not so satisfied, you must find the defendant not guilty as to count 48. If you find the defendant guilty of count 48, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 49, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 49. If you are not so satisfied, you must find the defendant not guilty as to count 49. If you find the defendant guilty of count 49, you must answer the following question, yes or no.
Traveling.
Did the defendant commit the crime of first-degree reckless endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree reckless endangering safety have been proved as to count 50, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 50. If you are not so satisfied, you must find the defendant not guilty of count 50. Sorry, I lost my place. I hope that was all related to count 50 because it was. I'll just start at the top of that again. If you are satisfied beyond a
It's a lot
reasonable
to
doubt that
read.
all three elements of first degree recklessly endangering safety have been proved as to count 50, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 50. If you are not so satisfied, you must find the defendant not guilty as to count 50. If you find the defendant guilty of count 50,
I
you
might
must
have to
answer the following
customize
question, yes
if I
or
ever
no.
get a classic
Did the
car
defendant
again with
commit the
a
crime of first degree
gear
recklessly
shift that you
endangering
can
safety while using a dangerous weapon?
easily screw on a alternate
If you
knob.
are satisfied beyond a reasonable
I-
doubt that all
I might
three
have to
elements
do,
of first degree recklessly
like,
endangering
The
safety
shift
have
pattern
been proved as to count 51,
TRAVEL.
you should find the defendant guilty of first degree
Hey, it
recklessly
works
endangering
great for a
safety as
6-speed
charged in
or a
count
5-speed with
51.
reverse.
If you are not so satisfied, you must find the defendant not guilty as to count 51. If you find the defendant guilty of count 51, you must answer the following question, yes or no. Did the defendant commit the crime of first degree
For a
recklessly endangering
nonprofit,
safety while using a dangerous
I don't
weapon?
know.
If you are satisfied beyond a reasonable doubt that all three
It would be
elements of first degree recklessly endangering
commercial-ish,
safety have been proved
although
as
you
to count
definitely engage in
52,
commerce when,
you should
you
find the
know,
defendant
buying
guilty
cow
of
feed,
first
buying
degree recklessly endangering safety as charged in count 52. If you are
commerce
not
is
so
a lot
satisfied, you
broader
must find the
than
defendant not
sovereign
guilty
citizens would like
as
to
to
admit.
count 52. If you find the defendant guilty of count 52, you must
In
answer the
fact,
following question,
I could make a
yes or
very
no.
credible argument
Did the
that
defendant
all
commit the
driving
crime of
is an
first degree
inherently commercial
recklessly endangering
activity.
safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 53, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 53. If you are not so satisfied, you must find the defendant not guilty as to count 53. If you find the defendant guilty of count 53, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three
If I
elements
were a
of first
defendant
degree recklessly endangering
and I
safety
had
have
a
been proved as to
private
count
attorney,
54,
as
you
in
should
not a
find the
public
defendant
defender,
guilty of first degree recklessly
I'd be
endangering
so mad
safety
to be
as charged
paying
in count 54.
400,
If you are
500
not so
bucks an hour
satisfied, you must find the
during all
defendant
of
not
this.
guilty as to count 54. If you find the defendant guilty of count 54, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 55, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 55. If you are not so satisfied, you must find the defendant not guilty as to count 55. If you find the defendant guilty of count 55, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 56, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 56. If you are not so satisfied, you must find the defendant not guilty as to count 56. If you find the defendant guilty of count 56, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first
Don't
degree
imagine a
recklessly
court would
endangering
allow it.
safety
I see
have
you're
been
kidding,
proved as to count 57,
but I don't think it would be
you should
allowed.
find the defendant guilty of first degree recklessly endangering safety as charged in count 57.
Because once again, it would be
If you are
grounds for
not so
appeal.
satisfied, you must find the defendant
Malpractice.
not guilty as to count 57. If you find the defendant guilty of count 57, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 58, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 58. If you are not so satisfied, you must find the defendant not guilty as to count 58. If you find the defendant guilty of count 58, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 59, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 59. If you are not so satisfied,
This is putting
you
me
must
into
find
a
the defendant
trance.
not guilty as to count 59.
It's like Groundhog Day.
If you find the defendant guilty of count 59, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 60, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty of count 60,
I'm
you
sure
must
the
answer
jury's
following
feeling it
question,
too.
yes or no.
Even
Did
without
the
sovereign
defendant
citizen
commit the crime
antics,
of first
there is a
degree
lot of
recklessly
redundancy
endangering
in the
safety
law.
while using a dangerous weapon?
In legal procedure, I should say.
If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 61, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 61. If you are not so satisfied, you must find the defendant not guilty as to count 61. If you find the
I think I
defendant
would have
guilty
tried
of count
proposing
61, you must answer the
instructions
following
that
question, yes or no.
sort of
Did the
consolidated
defendant commit
this
the crime
section
of
with
first degree
the
recklessly
previous
endangering
section when
safety
they
while using a
named the
dangerous weapon?
victims of each of these counts. Because I think
If you are satisfied
that
beyond a
could have been more
reasonable
efficient.
doubt that, oh darn it, I
He
think I
objects.
skipped a few numbers. Maybe not. I think I'm okay. Did anyone think I skipped any numbers? Okay, good. Sorry, it's a lot of numbers. And I do the
Lawyers
best that I
don't like
can, and
numbers.
I was a little distracted by a piece of paper that was put in front of me. So we are on 61. If you find the defendant guilty of count 61, you must answer the following question, yes or no.
You have tax
Did the defendant
attorneys
commit the crime of first
and then
degree
attorneys that
recklessly
went to law
endangering
school
safety while
to
using
avoid
a
math.
dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 62, you should find the defendant guilty of first degree recklessly
They would have
endangering safety as charged in count 62.
Been great if they had gone to,
If you are not
if
so
they had
satisfied,
received their
you
Hogwarts
must
letter.
find the defendant not guilty as to count 62.
Because
If you find the defendant guilty
magical
of
thinking
count
would have
62,
served
you
them
must
well.
answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 63, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 63. If you are not so satisfied, you must find the defendant not guilty as to count 63. If you find the defendant guilty of count 63, you must answer
we're
the
getting
following
close.
question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 64, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 64. If you are not so satisfied, you must find the defendant not
All right, it's
guilty
been
as
20
to count
minutes.
64. If you find the defendant guilty of count 64, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 65,
I've never
you
actually
should
read
find the
it.
defendant
the
guilty of first
diagnosis
degree
manual.
recklessly endangering safety as
What-
charged in count 65.
What's it called?
If you are not so satisfied, you must find
If
the
you
defendant
remember.
not guilty as to count 65. If you find the defendant guilty of count 65, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 66, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 66. If you are not so satisfied, you must find the defendant not guilty as to count 66. If you find the defendant guilty of count 66, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 67, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 67. If you are not so satisfied, you must find the defendant not guilty as to count 67. If you find the defendant guilty of count 67, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? And just for a moment, since I'm going on to a next section, let's just stand for a minute.
I do like how she does this. Sitting too long can be a health hazard.
All right, please be seated. The defendant is charged with 6 separate counts of violating a duty after being involved in an accident resulting in death. The 68th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Virginia Sorensen and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person, and failed to stop the vehicle he was operating as close to the scene of the accident as possible, and remain at the scene of the accident until he did all of the following: give his name, address, and the registration number of the vehicle, he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with, and render reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person.
Do you remember what the condition
to a
was, though?
physician,
If not,
surgeon,
don't go
or
out of your way.
hospital for medical or
it's not a
surgical
big deal.
treatment if it is apparent that medical or surgical
'Cause in
treatment
my
is
mind,
necessary or if
it's
requested by the injured
Hogwarts-itis.
person. Contrary to sections 346.
Or Harry Potterosis.
7 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The 69th count of the information in this case charges that Darrell E. Brooks, on or about Sunday,
Oh, so
November
it is
21
actually
of
called
2021.
magical thinking.
On Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Leanna Owen and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person and failed to stop the vehicle he was operating as close to the scene of the accident as possible and remain at the scene of the accident until he did all of the following: give his name, address, and the registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with, and render reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person to a physician, surgeon, hospital, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or if requested by the injured person. Contrary to sections 346.67 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The 70th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Tamara Durand and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person and failed to stop the vehicle he was operating as close to the scene of the accident as possible and remain at the scene of the accident until he did all of the following: give his name, address, and the registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with, and render reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person to a
I wouldn't
physician,
have wanted to receive
surgeon,
aid
or hospital for medical or
from
surgical
Mr. Brooks.
treatment if it is apparent that medical or surgical treatment is necessary or if requested by the injured person.
But I still think you
Contrary
should be
to
punished for it.
Sections 346.67 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The 71st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Jane Coolidge and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person.
But is it Bob
and failed to
Barker
stop
rules
the
or
vehicle
Drew
he was
Carey
operating
rules?
as close to the scene of the accident as possible and remain at the scene of the accident until he did all of the following: give his name, address, and the registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with, and render reasonable assistance to any person injured in the accident, including transport arrangements to transport the person to a physician, a surgeon, or hospital for medical or surgical treatment, if it is apparent that medical or surgical treatment is necessary, or if requested by the injured person, contrary to sections 346.67 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The 72nd count of the information in this case charges that
These
Darrell
are
E. Brooks,
Class D
on or about
felonies,
Sunday, November 21 of 2021, on Main Street in the city of
which,
Waukesha,
if I remember,
Waukesha
are
County, Wisconsin, did
25
operate
year
a vehicle
max.
involved in an accident that resulted in the death of Wilhelm Hospital and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person, and failed to stop the vehicle he was operating as close to the scene of the accident as possible, and remain at the scene of the accident until he did all of the following: give his name, address,
I've
and the
been
registration
looking
number of
at
the
my other
vehicle
screen
he was
for
operating
at the
to
statutes,
the operator
but I was
or
about to come
occupant
say that.
of or person attending any vehicle
We all
collided
lose.
with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with, and render reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment, if it is apparent that medical or surgical treatment is necessary, or if requested by the injured person, contrary to sections 346.67 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The 73rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Jackson Sparks and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person, and failed to stop the vehicle he was operating as close to the scene of the accident as possible, and remain at the scene of the accident until he did all of the following: give his name, address, and the registration number of the vehicle he was operating
Yes,
to the operator
these are Class
or
Ds,
occupant of or
and
person attending any vehicle
like I thought,
collided with, and upon
they're
request
up
and
to
if
25
available,
years.
exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with,
So I
and
haven't
render
added any of
reasonable
this up, but
assistance to
he's
any
facing
person
6
injured
life
in the
sentences
accident,
plus
including
about 500
transporting
extra
or
years on
making
top.
arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary, or if requested by the injured person, contrary to sections 346.667 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The defendant has entered a plea of not guilty to each of these charges, which means the state must prove every element of each offense charge beyond a reasonable doubt. Section 346.67 of the Wisconsin statutes, commonly referred to as hit and run, is violated when the operator of any vehicle involved in an accident on a highway fails to reasonably investigate what was struck.
I'm
And
guessing
if
we
the
don't get
operator
any
knows or
witnesses
has
after
reason
the
to know
opening
that the
statements.
accident resulted in death of a person,
Testimony
fails
starts
to
tomorrow.
stop the vehicle,
is
he
my
is
guess.
operating as close to the scene of the accident as possible and remain at the scene of the accident until the operator has given information and rendered reasonable assistance to any person injured in the accident. Before you may find the defendant guilty of any count of hit and run, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 4 elements were present with respect to that count. 1, as to each count, the defendant operated a vehicle involved in an accident on a highway. A vehicle is operated when it is set in motion.
Oh,
2,
she's
as
defining
to each
driving.
count,
She's
the
defining driving.
defendant knew that the
He didn't
vehicle he
object.
operated was involved in an accident on a highway. 3, as to each count, the defendant violated a duty after being involved in an
Duty.
accident. A driver who is involved in an accident has 2 duties. The state is required to satisfy you beyond a reasonable doubt that the defendant violated at least one of the 2 duties, but you are not required to agree as to which duty was violated. The first duty is to reasonably investigate what was struck. The second duty is that a driver involved in an accident involving a person must stop and provide information and render aid. To prove a violation of this duty, the state must prove the following beyond a reasonable doubt.
Usually
That the
duty is
defendant knew or had reason to know
discussed in
that the
tort
vehicle
law,
he was operating
not-
was involved in an
not as often
accident
in
involving
criminal
a
law.
person, and that the accident resulted in death of a person, and
since
that the
usually crimes
defendant
are
did not
affirmative
immediately stop his
actions
vehicle
as
as close
opposed
to the scene
to
of the accident as
failure
possible
to act.
and remain at the scene until he had done all of the following: gave his name, address, and the registration number of the vehicle he was driving to the person struck. And if it was requested and was available, exhibited his operator's license to the person struck, and rendered reasonable assistance to any person injured in the accident, including the transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or is requested by the injured person. 4, the defendant was physically capable of complying with these requirements. You cannot look into a person's mind to find knowledge. What a person
I
knows
can.
or has reason to know must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon knowledge. The information alleges not only that the defendant committed the crimes of hit and run, but also that the accident resulted in death to a person. If you find the defendant guilty of a count of hit and run, you must answer the following question, yes or no. Did the accident involve death to a person? Before you may answer yes, you must be satisfied beyond a reasonable doubt that the answer
From
to
what I
that
understand,
question
he
is
attempted
yes.
to run her
If you are
down
not so
before
satisfied, you must answer the question
going to the parade.
no.
So they were
If you are
separate incidents,
satisfied
and
beyond
I
a
don't think he
reasonable doubt
succeeded
that all
in
four
the
elements
first.
of hit and run have been
Thank
proved
goodness.
as to count 68, you should find the defendant guilty of hit and run as charged in count 68. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Virginia Sorensen? If you are satisfied beyond a reasonable doubt that all four elements of hit and run have been proved as to count 69, you should find the defendant guilty of hit and run as charged in count 69. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Leanna Owen? If you are satisfied beyond a reasonable doubt that all four elements of hit and run have been proved as to count 70, you should find the defendant guilty of hit and run as charged in count 70. If you are not so satisfied, you must find the defendant not guilty. If you
From
find
what
the
I'm seeing,
defendant
it
guilty,
wasn't
you
his
must
wife,
answer the
it
following
was a
question, yes or no.
ex-girlfriend.
Did the accident involve death to Tamara Durand? If you are satisfied beyond a reasonable doubt that all four elements of hit and run have been proved as to count 68, you should find the defendant guilty of hit and run as charged in count 68. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Jane Coolidge?
Accident.
If you are satisfied beyond a reasonable doubt that all four elements of hit and run have been proved as to count 72,
Accident.
you should find the defendant guilty of hit and run as charged in count 72. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Wilhelm Hospital? If you are satisfied beyond a reasonable doubt that all four elements of hit and run have been proved as to count 73, you should find the defendant guilty of hit and run as charged in count 73. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Jackson Sparks? The defendant is charged with two separate counts of bail jumping. The 74th count of the information in this case charges that Darrell E. Brooks,
All right,
on or
we're down
about
to the
Sunday,
last two.
November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, having been charged with a felony and having been released from custody under Chapter 969 of the Wisconsin statutes, did intentionally fail to comply with the terms of his bond, contrary to Section 946.49 sub 1 sub B and 939.50 sub 3 sub H of the Wisconsin statutes. The 75th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, having been charged with a felony and having been released from custody under Chapter 969 of the Wisconsin statutes, did intentionally fail to comply with the terms of his bond, contrary to Sections 946.49 sub 1 sub B and 939.50 sub 3 sub H of the Wisconsin statutes. Bail jumping, as defined in Section 946.49 sub 1 of the Criminal Code of Wisconsin, is committed by one who has been released from custody on bond and intentionally fails to comply with the terms of that bond. Before you may find the defendant guilty of any count of bail jumping, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present with respect to that count. 1, as to each count, the defendant was charged with a felony. A felony is a crime punishable by imprisonment in the Wisconsin state prisons. 2, as to each count, the defendant was released from custody on bond. This requires that after being charged, the defendant was released from custody on bond under conditions established by a court commissioner. 3, as to each count, the defendant intentionally failed to comply with the terms of his bond. This requires that the defendant had the mental purpose to fail to comply with the terms of the bond. This also requires that the defendant knew of the terms of the bond and knew that his actions did not comply with those terms. The defendant is charged with violating a condition of bond that required that he not commit any crime. The state alleges that the defendant committed the crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, hit and run resulting in death, and battery. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant committed the crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, hit and run resulting in death, or battery. The state is required to satisfy you beyond a reasonable doubt that the defendant committed a crime, but you are not required to agree on which one. The crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, and hit and run resulting in death have already been defined for you, and you should apply the same definitions here. You cannot look into a person's mind
His
to find
constant
intent
movement
or
would
knowledge.
distract me
Intent and
if I were a
knowledge
juror.
must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent and knowledge. If you are satisfied beyond a reasonable doubt that all three elements of bail jumping have been proved as to count 74, you should find the defendant guilty of bail jumping as charged in count 74. If you are not so satisfied, you must find the defendant not guilty as to count 74. If you are satisfied beyond a reasonable doubt that all three elements of bail jumping have been proved as to count 75, you should find the defendant guilty of bail jumping as charged in count 75. If you are not so satisfied, you must find the defendant not guilty as to count 75. The 76th
He
count
has
of the information
quite a
charges
menacing
that
look sometimes.
Darrell E. Brooks, on or about Sunday, November 21 of 2021, at Frame Park in the city of Waukesha, Waukesha County, Wisconsin, did cause bodily harm to Erica Patterson by an act done with intent to cause bodily harm to that person without that person's consent, contrary to sections 940.19 sub 1, 939.51 sub 3 sub A, 968.075 sub 1 sub A all of the Wisconsin statutes. Battery, as defined in section 940.19 sub 1 of the Criminal Code of Wisconsin, is committed by one who causes bodily harm to another by an act done with intent to cause bodily harm to that person or another without the consent of the person so harmed. Before you may find the defendant guilty of battery, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 4 elements were present. One, the defendant caused bodily harm to Erica Patterson. Cause means that the defendant's act was a substantial factor in producing the bodily harm. Bodily harm means physical pain or injury, illness, or any impairment of physical condition. 2, the defendant intended to cause bodily harm to Erica Patterson.
One area where sovereign citizens really do go get things wrong.
The defendant had the mental
they get
purpose
hung
to
up
cause
on
bodily harm to another
Black's
human
Law
being,
Dictionary,
or was aware that his conduct was practically certain to cause
especially
bodily harm
they
to
use
another
the
human being.
second edition.
3, the defendant caused bodily harm without the consent of
the judge
Erica
here
Patterson.
is defining
4,
every element.
The defendant knew that Erica Patterson did not.
These definitions
consent.
Are in the statutes. So even if
you
the Black's Law
look
Dictionary
into a
definition doesn't match,
to find intent
that's
and
completely
knowledge.
irrelevant because the
Intent
statute
and
says what it
must
is.
be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances
But once again,
in
magical
this
words.
case bearing upon intent and knowledge. If you are satisfied beyond a reasonable doubt that all 4 elements of battery have been proved as to count 76, you should find the defendant guilty of battery as charged in count 76. If you are not so satisfied, you must find the defendant not guilty. An information is nothing more than a written formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference.
I think he knows what he did. I think he understands what he did.
The parties will make opening statements.
I don't
the purpose
think
of an opening statement
he's
is to
capable
give
of feeling
the parties
shame.
an opportunity to tell you
I think
what
he
they
acts this
expect
way
the evidence
because
will show you, so that you will better understand the
it's
evidence as it is introduced
his way of
during the
asserting
trial.
power.
I must caution you, however, that the opening statements are not evidence. Before we have the parties, or before I give them the opportunity to make opening statements, I am going to excuse the jurors to address
Like
a
she
few
said,
legal matters, give
it's
you
not
an
evidence.
opportunity as well for a short
Only
comfort break.
testimony is evidence
We'll let
or
you know
exhibits.
when we bring you back in.
Well, I don't know that impressed is the right word. I'm surprised he made it through that whole session.
I think you'd be seated.
And I looked it up out of curiosity. The bail jumping charges, he was arrested about a week before the parade incident and charged with 2 counts of second-degree recklessly endangering safety and felon in possession of a firearm.
A number of pieces of paper that Mr. Brooks wrote on. I'm going to have them copied so the state can be aware of that and respond if necessary.
I
So just
wouldn't
take a
be
moment
surprised.
while those
The
papers are copied.
I also think the
You did call me. Did it not work? I called them. All right, I'll call again.
I'm pulling a blank what it's called, but the defiance, the obstructive
How
disorder,
many copies do you make?
I think
Okay.
would be a good
We'll
possibility.
make sure you have copies of the
I think he
findings as
was
well, so you know what will be
diagnosed,
discussed.
according to
or at
the
least
judge,
addressed in some
with a
fashion.
personality
But I need
disorder,
to provide
but I
copies
don't
to
know
the
that
state.
it was disclosed which personality disorder. But she did make a judicial finding based on his psychiatric
Black that's closest to the screen in that corner chair over there. I recognize
profiles
her from my initial
that
appearance.
he had a disorder.
She flipped me off coming in to my initial appearance and coming out. I know it's her for a fact. I seen her about like how I'm looking at you right
Wait,
now. So I
who
know for a
flipped him
fact
off?
that's her. I don't want that to end up being an issue. Is this some type of way that could be addressed by Your Honor?
Mr. Brooks, you had an opportunity to exercise preemptory strikes and even to question jurors about that. You chose not to. So at this point, any issue you have with that juror is waived.
Okay, you do remember that I was not present in the courtroom. I couldn't see. All I can see from that courtroom in there is just
That's
you, Your
his
Honor,
own
and
fault.
the prosecution's table.
His
I can't even see the
behavior
bailiffs.
waived his right
So
to
there was
be
no
in
way
the
for me to
jury
even
room.
see who the jury was. Obviously, I wouldn't know them by name. If I would have been able to see the jurors, I would have immediately addressed that.
I will make this one indulgence. I'll have the civilian bailiff ask that juror if she was in attendance at your initial appearance out of an abundance of caution. These are jurors, though, who with the jury questionnaires were also asked what
This is
knowledge
just
they
another
had
delay
about
tactic.
proceedings they watched or even attended. And no one, to my knowledge, has disclosed anything like that, but out of an abundance of caution, we will ask that juror if she was in attendance at your initial appearance. So for now, that's how I'll address it. I'll advise you of what her answer is later. Do you know the number of the jurors, sir? They have numbers.
I just know that I can't see the number from here. I just know the chair she was sitting in.
Which chair, sir? Top row or the top or the bottom row?
The bottom row, the last black chair. Black shirt. She had the black
They're
shirt
all
on.
black chairs, sir. So
The
the
last
chair
black
closest-
chair closest to the television.
Thank you, sir, because there are two sides, right? So it's the last chair on both sides. So I wanted to make clear. You're saying the chair closest to the television. Thank you.
I said that at the beginning, Your Honor.
Front row. All right. State have copies of the filings.
Yes.
I will take these in order. The first is a note from Mr. Brooks that was handed to Deputy Wittig at about 12:05. It says, "I would like my filings addressed, parenthesis, notice of special appearance, statement of particulars, both are by affidavit filed 10/3/22.
And it's all sovereign
Today
citizen
is deadline
nonsense.
to respond. Thank you, Mr. Brooks. I'm respectfully declining to respond to those filings." That's my decision, sir. Next
Are you
topic.
making a judicial determination that those have no merit?
Mr. Brooks, I have indicated to you on the record what
I'm
I will or
saying
will
for a
not
fact
do.
they
I would
have
like
no
to
merit.
motion for finding a fact.
Your request is denied. The next,
May Your Honor explain why?
Mr. Brooks, I'm gonna go through these one by one. If I feel the need to make more of a record, I will do so. The record will be available later on. If you think I've made an error, you can then raise that on appeal.
I know you're making an error, Your Honor.
Mr. Brooks, I'm not going to have a debate with you right now. We are continuing on. I'm giving you the courtesy to respond to each one of these things. That's how I've responded. I expect that you will, even if you disagree with my decision, sir, that you will respect it and we'll move forward. The next piece of paper filed at 1:52 p.m. says, are you making a judicial determination? I'm not allowed my right under the First Amendment to freedom of speech in this courtroom. Mr. Brooks, we have rules of decorum and courtesy. They have been provided to you multiple times. They are part of the materials that you have before you.
Do they fall under the First Amendment?
SCR Chapter 62 discusses just the standards of courtesy and decorum for the courts of Wisconsin.
As a sovereign citizen, is he sure the First Amendment applies?
Parties are able to file requests with the court. It's called a motion. A motion, however, is based in law. There is a citation to not only that law, but relevant facts, and there's a request for relief. While you have the right to present a defense, you do not have a right to disrupt the proceedings.
That was not disruption.
Mr. Brooks,
I was asking, will my First Amendment right, which is freedom of speech, and the right to be heard in court, will that be honored by Your Honor? That's a valid question.
Mr. Brooks,
that's a constitutional
I have
right.
given you ample opportunity to present information, evidence, to question when we've had witnesses on the stand, but I expect you to follow the rules of procedure, the rules of evidence when presenting your requests.
I can't even get these admitted
that
into
donut
evidence.
sure smells good right
That's
now.
Mr. Brooks. I cannot explain to you if you don't understand the basis in law for the denial.
You're right. I don't understand.
So get an attorney.
But that doesn't mean we're going to have a discussion or a debate about what it means, because we're not going to do that.
The rules that you set.
So the bottom line is, I don't feel, Mr. Brooks, stop talking. I do not feel.
I was following the rules when you said that I had to make all
and you
objections.
did, and I'm going through them.
Writing.
So give me the courtesy of replying or responding.
He's incapable.
To these. And please give me the courtesy
Gag him.
that even when you disagree with how I answer them, that you will not interrupt.
And get the objection
back. It's
back.
not about me trying to interrupt you, Your Honor.
Mr.
All
Brooks,
I'm saying is,
I'm going to address the next one. So please pay attention.
What you were saying about decorum, I was asking, does that fall under the First Amendment? Because the First Amendment, which is my constitutional right, says that I have the right to freedom of speech and to be heard in this court.
Mr. Brooks, again, you have the right to present a defense, but that right is not unfettered. That right, Mr. Brooks, you are interrupting me. Stop.
Because you're talking about
because you're purposely doing this, so I can't get my reasoning out. You make it incredibly difficult.
I'm not referring to the Sixth Amendment.
Mr. Brooks,
to the First Amendment, which clearly says that I have the right to freedom of speech and to be heard in the courtroom. Are you not going to honor my constitutional right, Your Honor? If not, that is judicial misconduct, and you're making a judicial determination to not honor my
First Amendment isn't
I just want to be
absolute in the courtroom.
Anyone else, which you said on the record that you
the
will be
court
fair
couldn't
and impartial.
function.
Mr. Brooks, you also have an obligation to treat this court fairly, and you have an obligation to follow the rules of courtesy and decorum, the rules of procedure, the rules of evidence. That's the playing field that you willingly entered into and made a deliberate decision to waive your right to an attorney and to appear in this case as your own attorney.
To represent myself pro per. The same paperwork that you gave me, you have, and I also have a copy of the same one where I scratched out what I did not agree.
Condescending. He's aggressively condescending.
Mr. Brooks, I made findings regarding that, and those findings stand. That despite you scratching out some of those words on there, I made very specific findings about your waiver of right to an attorney. So we're not going to relitigate
You
that
also,
here
you
right
also
now.
accepted the terms of the paperwork that I
Mr.
filed out.
Brooks, I'm not going to engage with you about whether you and I
She
have entered into some
absolutely
type of a
did not
contract
We did
accept
or
not.
his
engage in
terms.
We
any
did not.
type of
We
that
did not
kind of
enter into
dialogue,
any
because
contract.
that's what you're claiming through some
No,
of
I'm
these
not. I'm
filings, and
not
you've
claiming
said that
I
previously.
am not claiming that, Your Honor.
So,
In any way,
Mr.
shape, or
Brooks,
form,
I
do
am
not
giving you
consent to
some
any
leeway.
contract.
You continue to talk
All right,
over
kick
me.
him out. Kick him
You
out.
please, I'm asking you to follow the rules of civility.
He needs to be muted
Simple
for
rule,
the
sir. Don't interrupt
prosecution's
me.
opening.
Did I not just let you read the whole jury instructions and follow the rules that you said I have to write down?
You did.
Anything that I object to.
He was quiet
and then
then,
hand it
therefore
in.
he can
Except
be
now that we're
disrespectful now.
discussing them, it seems to me that the rules don't quite matter to you, sir.
No, that is not what's
So,
being asserted.
Here's
on my
what's
end.
happening, sir.
follow
I'm
the rules.
telling you,
All
I'm
I'm asking
advising
for-
you to respect the rules. I'm advising you that if you continue to interrupt, you risk forfeiting your right to be present in this courtroom.
Are you?
Because I still need to continue with these proceedings, sir. I need
There's
to
a
go through
massive
all of the
squirrel
documents that you filed,
out in the
and
garden.
you're not letting me do that.
Because we didn't
So
get
I'm
past
gonna,
the
if I
issue.
need to, I'll remove you to the other
And this isn't
courtroom
the
so that I can
ADHD
do this.
squirrel.
And yes,
It's
exercise
a
the mute
actual
button, sir.
real
This-
squirrel.
But, and
this
then
is
I'll bring
something
you
that was
back on the
filed, though.
jury's back.
This was filed, though, Your Honor, and it's
Oh,
Mr.
it
Brooks
was
is
filed.
clearly not
Therefore, it's official.
following the simple rule of civility that I have established.
That's
He
inaccurate,
continues
Your
to
Honor.
interrupt. He's not providing
That is
this court with
inaccurate, Your
ability to make rulings on the record without interruption. So this is your final warning, or you will be removed to the other courtroom.
Will Your honor my First Amendment right?
I'm
Or are
not
you
answering
making
that
it- or are
question,
you
sir,
making
because
it-
I've already addressed
So
it.
you're making a judicial determination to
That's
deprive
what
me of my
judges do.
I am
constitutional
not
right.
making any such determination,
So
sir.
you just said you're not going to answer the question about my First Amendment right, which says
Sir,
that
I've
I have
already
freedom
A
of
answered
speech.
the
judge is
question
not
that you have a
obligated
right
to
to
answer
present
any
the defense.
questions.
That is the
You have
Sixth
a right
Amendment,
to
not
be
the First.
present.
You're trying to
You
twist up the
have
amendments.
a right to present your defense, but your rights are not unfettered.
Yes, they
Your
are, Your
rights-
Honor. You're citing the Sixth Amendment, which I am not
Mr. Brooks,
questioning.
your
I'm-
First Amendment in some respects is circumscribed by the rules of evidence
He
and the
doesn't
rules of
understand
procedure.
big
Does it say
words.
that I have
So that
freedom
doesn't
of
mean you
speech?
get to say anything that you want in
No,
front of
I'm-
a jury.
Your
And
Honor,
it doesn't mean you get to put forth any kind of evidence that you want in
Your
front
Honor,
of a
am
jury.
am I
What it
being-
means, sir,
am
is
I being
that you
disrespectful?
must
Am I
follow.
calling you
Yes,
out your
you're being
name? Am I threatening
disrespectful because
anybody?
you're
I'm
not.
not doing anything of the sort.
All right, he is continuously talking over me. So at this point, I'm going to find that he's forfeited his right to be
I have
present as
not
I
forfeited
go
my right,
through
Your Honor. I have
his
not consented to any. I'm
his
simply trying
paperwork. He's to be
understand
removed to the other courtroom
I'm
until
simply
such
trying to
time as he
understand
can pledge to
why we're
follow
not
the
talking
rules
about
of
the First
decorum and
Amendment. I'm not
civility.
talking about the
We'll be
Sixth
in
Amendment.
recess until we have
Your Honor,
everything
I do
set
not
up.
agree to a
The record
estoppel.
to reflect, I'm stepping off. The
All right. That's 68 minutes. I realize we all vastly undershot, but 68 minutes. I'm struggling. I know there must be a word. I have a pretty decent vocabulary, but I'm struggling to think of the single best word to describe Mr. Brooks. Because I don't think obstinate is strong enough a word, but I think it also goes beyond. It's a wider issue. And I really I wish I could think what the right word is. Because there's got to be one. One of my best friends from my time in England. I mean, disruptive is a descriptive word, but I'm looking for that all-encompassing single word. And like I said, one of my best friends from my time in England, he was doing his PhD in English at the time, and he's from Yorkshire in England. There in England, same city as Jeremy Clarkson is from. If you're a Top Gear fan, but he now he married an American, lives in Minnesota now. But he he has a way with words, and I'm sure he could think of the right word. I think maybe you're onto something. I think that might be the right word to describe him, but then I think we need to get into a different word for his behavior. So maybe we do need two words. And disruption or disruptive. Like I said, I think it goes beyond that. I was mentioning the asshat word. But I think yours could be a good one too. I don't know that I've ever seen that word before. But I'm thinking it's probably in the ballpark. And I wonder how long this recess is going to take. Because it shouldn't take that long to get him set up in the other courtroom. But I guess if he's throwing a fit, which is why, like I said, even going to um in recess, I wish they kept the video feed up even if the sound is off, just so that we can see sort of the context and have the visual clues as to how long the recess is going to take. And with your definition, I do I do think it's a good description of his behavior. And I'm guessing with the camera off that behavior's continued. I'm imagining that he's throwing A massive fit. Ooh, hey, the squirrel's even closer now. Like I said, this is an actual squirrel. It's funny. We didn't have squirrels in my neighborhood for a long time. And then about 15, 20 years ago, we had little tiny tree squirrels show up and they took over. They're an absolute menace. But in the last 2 years, we've had great big bushy squirrels evict the little tiny scrawny squirrels. And my brother's corgi that thinks he owns the 3 yards, because like I said yesterday, my brother lives next door. My Oma lives next door on the other side, and so Menchie the corgi thinks he owns all 3 yards, and he's not a fan of the squirrels. But on the occasions he's been nose to nose with the squirrels, he just doesn't have the killer instinct. He's a herding dog, not a hunting dog. Whereas we had a Malamute that would follow underneath the
Michelle's not here,
squirrels,
so we are not on the
and
record. I just
she
want to test.
loved eating them. But you're muted, Judge. That's a Joe problem, not a court problem. I like how they zoom in on the court's installed camera there. It's a good setup for Zoom. I wonder if they had it before the plague started, or if it was installed specifically for Zoom. Because some courts have definitely upgraded in the last 2 years. You look at the sort of court security feeds from before. They were pretty bad.
The record should reflect that Mr. Brooks is now appearing from the other courtroom. Prior to the court taking the short break, the court was attempting to address the filings from Mr. Brooks that he made pursuant to my request, to write down if he had an objection. I have 5 different, what I will refer to as filings, one of which he provided to Deputy Wittig at 12:05. So that was right around the time we broke for lunch. The second one, 1:52 p.m., today's date, October 6th. And then there's another 1:58 p.m., October 6th, 2:03 p.m., October 6th. And then looks like the time is 14:28, so 2:28. The other one was received. Mr. Brooks, I'm going to make a record first as to why you've been removed, and then I will hopefully get to the
Once again,
filings.
avoiding that reversal.
At the moment. You are
make a
unmuted,
full
record. After the court completed the preliminary jury instructions and the reading that is to the jurors, I excused the jurors so that they could take a break, but also because I knew there were a number of what I will loosely refer to as objections that were raised by Mr. Brooks. I wanted to take an opportunity to address those first before moving on to opening statements. As I attempted to address those with Mr. Brooks, there was, from my observation and opinion, and I'll make a finding that it was pretty much a consistent talking over me by Mr. Brooks. I wasn't able to really go through any of these filings with any specificity. I attempted to go through the first one, which I did. I mean, I did tell him I wasn't going to address that. And then we were talking about his second one when really it kind of devolved from there. The record is very clear that Mr. Brooks has been advised on multiple occasions of my expectation regarding courtesy and decorum in this courtroom. I've referred to at many times that there's a very simple rule of civility I expect him to follow at a minimum, and that is to not interrupt. It shows a complete and utter lack of respect for the court process, the court proceedings. It interrupts the court as the court is attempting to make a record of what is happening and decisions that I am making. And after repeated warnings to him, the court made a determination that he had forfeited his right to be present in the courtroom while we discuss his filings. The record will reflect that Mr. Brooks did not give consent. I am still continuing with my findings, sir, so I'd ask that you not interrupt me.
You've got a mute button.
Mr. Brooks, I'm not done. I'm going to mute him because frankly, can be difficult to keep one's train of thought when you are consistently interrupted, which is why I believe he engages in the conduct that he does, because it's plain and simple. It is disruptive. It disrupts my thought process. It disrupts the proceedings. I was so pleased, Mr. Brooks, when you were able to follow the simple rules when the jury was here and I was going through the jury instructions. I know you had some objections. You wrote them all down. You followed that procedure. I told you I would take those up after I got through the jury instructions. I was attempting to do that, but then you started in with your antics, with your interruptions. It doesn't matter to this court if you're mild-mannered, if your tone of voice is a normal tone of voice, meaning it doesn't matter to me that you're not raising your voice, you're not making any threats or anything like that. That certainly would take things to the next level, in my opinion, but it's not necessary for this court to make a finding that your behavior is
appalling,
disruptive.
And disruptive.
And this obviously comes on the heels of your conduct this morning, where you spent the vast majority of the morning in the other courtroom based upon your conduct. And I'll once again rely on the decision in Illinois versus Allen, 397 U.S. 337, a U.S. Supreme Court case from 1970 on the options the court has constitutionally when faced
based on the
with
1970 ruling.
Defendant, someone like Mr. Brooks, who cannot conduct himself.
The existence of video technology now goes far beyond what the 1970 Supreme Court case required.
Proceedings. The consistent interruptions are not only disruptions, but it interferes with the proper administration of this trial. It disrupts the dignity, order, and decorum of this court. Those are the hallmarks of all court proceedings. I'll make a finding that he flagrantly disregards in the courtroom elementary standards of proper conduct by repeatedly interrupting this court.
But his First Amendment.
And therefore, he has forfeited his right to be present while we discuss all of these filings. I'll also make a finding that the technology that we are utilizing here today, we are Polycom to Polycom. The audio and video have been working very well. this afternoon. No issues with that, and that it's the functional equivalent of Mr. Brooks being in this courtroom. It gives him the opportunity and the ability to meaningfully participate while the court is still able to control his behavior by exercising the mute button, as I have repeatedly throughout these proceedings. I believe all of the documents speak for themselves, I should say. But what I will do is go through them one by one from the beginning.
They're never going to get to
they're
the
Mr.
opening
Brooks's
statements.
filings. His position has been made known. I'll ask the state to respond. If I feel any additional
Get him the
follow-up is
hat.
needed
Get him
from
the
Mr.
objection
Brooks,
hat.
I'll ask him for that, and then I'll make a decision. So even if that's backtracking a little bit, it's a little bit easier to do that with him in the other courtroom. So the first one that I will deal with is the one that's got today's date and 12:05. I addressed it earlier in terms of that I did not believe it was a filing that required any court response. And I'll ask the state if the state sees any of that differently.
No, Your Honor, and I would cite the court's United States versus Benabe, B-E-N-A-B-E.
That's a good name.
654 Fed 3rd 753. It's a Seventh Circuit case from 2011. Specifically, there's very instructive language on page 767. This case involved a defendant who identified himself as a sovereign citizen. The court goes into a nice discussion as to such claims having no merit whatsoever.
Yep.
The quote is, the proposed sovereign citizen defense has, quote, no conceivable validity in American law. I think that's applicable to several of these filings here, Your Honor, and I think that's relevant authority throughout the remainder of this trial that these sovereign citizen defenses have been attempted. There's a lot of cases on this. That's the most recent from the Seventh Circuit that I could find. In no way have any of these defenses, such as his name, the jurisdiction of the court, the fact that the state's an entity, any of these efforts that Mr. Brooks has tried to put forth have been soundly rejected by the courts, and there's significant case law on point, but that's the most recent and appears to fit really well with the facts of this case.
I would note the documents he refers to in this particular piece of paper references the notice of special appearance, the statement of particulars, both are by affidavit. Those are two of the common sovereign tactics.
Yep.
And I believe Benabe and the language that you cited is directly on point, and that is why I can simply deny the request to address those filings without any further discussion or hearing on them, even without giving Mr. Brooks an opportunity to further respond. The second statement, and I note he's raising the objection, and I'll indicate for the record he's objecting to what's being ruled upon. Then the second filing, we heard him discuss at length, so I'll just have the state respond to that, and that was his claim that his First Amendment rights to freedom of speech are not being honored in this courtroom.
So the court has been abundantly patient in allowing Mr. Brooks to make appropriate, relevant legal arguments. The court is 100% accurate that no constitutional rights is absolute, and there is they can be fettered under appropriate situations, and you've made an excellent record as to why that is appropriate in this case.
Mr. Brooks is raising his objection sign. Since he was given an opportunity to address this previously, I'm not going to give him further opportunity and simply indicate that he will be allowed at appropriate times under the rules of evidence, under the to present his defense It appears to me at times he may confuse the ability to file something into the record with the ability to present evidence. We have yet to start the evidentiary phase of this trial.
We'll never
in addition,
get to
any
the
of his
evidentiary
specific
phase
objections
at this point.
should be brought by
Or at this
motion.
pace.
Even if that's an oral motion, it should be based in law and fact and request specific relief. His filings make claims that have no underpinning in law or fact. It's really conclusory.
Once again,
This court is
objection.
under
I don't
no
like it.
obligation
Objection.
to address
It's devastating to my case.
conclusory statements by him that are not properly made, both in form and in substance. This record's replete with references and instances of Mr. Brooks just simply spouting various amendments or theories without those fully being established in the record. And again, no constitutional right is absolute. The First Amendment rights of an individual can certainly be fettered. That is especially true
when you've
in a
committed
court
a
of
crime.
law, where there are rules of evidence, rules of procedure, where we have the standards of courtesy and decorum. He can present his defense. He has a right to present a defense, but his rights
He has no
to
right
do
to
that
be disruptive.
must comport with the law. And that law is what I've already pointed out. So I'm not sure really how to address, are you making a judicial determination? Everything that I do when I rule on something is a decision that is made by this court. So I've answered this. We'll move on to the next one. And he is raising his objection, and that's fine. He can do that. His
Asking
objection will
about,
be
is
noted
this
for
a
the
judicial
record.
determination?
He also
Goes
raises
a-
in the next filing at 158. I
It-
still motion
It's
to
akin
prove
to the
jurisdiction.
sovereign
Please.
citizen.
Also motion
Are you
to
practicing
dismiss
law
no
from the
proof of
bench?
jurisdiction. Also motion for finding of fact. Again, none of these things cite to any legal authority or any factual basis, nor do they request any specific relief. Here's what I will rely
And
upon the
they're simply
Beneby
not
decision
based in
from the Seventh
reality.
Circuit, that these are just
It's Hogwarts
various
versus
arguments
Dumbledore.
raised
It's
by
magical
sovereigns that
thinking.
have been debunked and have been addressed that have no place in our justice system. And therefore, I will deny the requests in that piece of paper summarily without further consideration. I know he makes repeated objection to either how I say his name or how it's referenced in the caption. There's a continuing objection that I will note. His filings speak for themselves, how he wishes to be addressed. This court will refer to the name that is on the information in this case.
Pretty
That is
much.
the official charging document. And that is what I will do.
Of
If
course,
I mispronounce his first name at
legislating
times,
from the
my
bench,
apologies.
although that comes
I
from
know I said it,
courts of
his
appeals,
name repeatedly throughout
is
those
what
jury
makes the
instructions.
common law.
I know when I first
And we know sovereign
uh,
citizens love the common
had
law,
hearings
don't they?
on this case, even his own attorneys referred to him as
They hate
Darrell.
statutory
It
law,
was only
maritime
after
law,
I viewed his recorded
but they love
interview
common law,
that I learned it was
except they don't
Darrell. I
understand what
asked him
common
at
law
one
is.
hearing, how do I say your name? Is it Darrell? And he said, that's right, or words to that effect. I may not have the exact quote, and I'm not quoting him, but he confirmed for me on the record, at least at that point, what his first name was. So his continuing objection about his name is so noted. It's preserved in the record based upon his filings, and I'm not going to.
I don't know that she
further.
understands that his objection isn't to the pronunciation; it's
frankly, his last
to the sovereign
document,
citizen
which says a plea
BS.
is to argue facts. I don't intend to
his
do that,
name
and I never agreed
is a
to or
separate
consented
entity.
to a quote not guilty quote plea. My attorneys never got my consent for a not guilty plea. I don't understand. The law is very clear.
If you don't plead
that
guilty,
a plea of not guilty, even when
you
a defendant
plead
stands mute, is what the court proceeds
not
with.
guilty by default.
It is true in this particular case that plea was entered on his behalf, but the fact also remains that in order for that plea to be changed to something else, meaning a guilty plea or a no contest plea, the defendant would need to go through the
courts have
plea questionnaire
redundancies.
waiver of rights form.
If you do
and have
not
to
do
knowingly, freely,
something,
voluntarily,
it
and
will
intelligently
result
waive all of the rights that go
in a
along with that.
default
In other words, this
response.
court is simply constrained by the law to proceed as if not guilty pleas were entered on his behalf. So I've addressed that. I don't need any further argument from the parties.
They think a
I will
jury
note
of your
Mr.
peers
Brooks continues to
refers
have the
to
objection
other sovereign
sign
citizens.
raised.
Or this is more
The other thing I
common
want to make a
with
record
the
of, we
Moorish
did
sovereign
have the
citizens. They
civilian
think peers
jury
means
bailiffs check
only
with the juror that
Moors,
was identified by Mr. Brooks,
which
and that
of
juror
course is
confirmed
complete hogwash.
she has not attended any proceedings. So that issue is addressed now. He's holding up his objection sign. Mr. Brooks, I frankly did that for your benefit. You raised what really is an important issue, and I appreciate that. I was a little
The
surprised by
objection
it.
sign
But
loses
then when I
its
heard you
meaning if
explain
it's
further, I
constant.
thought, he's got a point there. He had been removed for some of those proceedings. You may not have seen her. I'm not making a finding on that. And so that's why I backtracked a little bit, said I would
only
look into it.
recognize the Magna
So I'm
Carta.
not sure why you're objecting at this point.
Of course.
I took an important piece of
Well, I guess
information that you were relaying, and
by being a
we
lawyer,
had
I'm an
in this
esquire,
case,
which
it was
is a step
confirmed that the
below
juror did
baron
not attend any
in the
proceedings, and so that will address
English
your
nobility. So the Magna Carta
issue
was
with
an
her.
agreement
All right,
between
now the next
the
step
king
would
and the
be opening
barons.
statements.
So
Mr.
even as an
Brooks,
esquire,
you have
I'm not
demonstrated in
bound
the
by
past,
it.
and I'm going to unmute you, that when the jury is present, you are able to
Of course,
maintain civility.
unlike the sovereign citizen
show them
argument,
respect. Show
esquire is
courts
not a
in
term of
process,
title of
respect, and
nobility in the
dignity. I
U.S.
certainly
So
am willing to have you brought back over while the state gives their opening statement, and certainly if you choose to make an opening statement, for you to do that in this courtroom in the presence of the jury. I know you're holding up your objection sign, sir, but I am giving you the opportunity to come back over here. Would you like to come back to this courtroom?
he objects.
Record should reflect he's holding up his objection sign. It appears that he's
Told
writing,
you.
I don't know what, of course. Mr. Brooks, I'm going to ask you again.
She
Would
did
you
unmute
like
him,
to
I
come
think.
back to this courtroom for opening statements?
So I'm on the record.
You are. If you would please address my question.
So you want me to come back over there just to get brought back over here?
That's not what I asked you, sir. I told you, I advised you, I would like you back here. It's always my preference that you're here.
Sovereign
You
citizens are
demonstrated
experts
previously
at
that you can follow some rules.
reframing
When the jury
questions
is
to what they
present,
want it
The
to
jury is
be.
going to be brought back in
And then
shortly
still
for
answering it
opening
wrong.
statements. The state will go first as they bear the burden of proof. And then you will be given an opportunity to also present an opening statement. So my
I'm not
question
sure.
to you is, do you want to come back to this courtroom, sir?
So I can get sent back over here, because as soon as I say something, I'm gonna get sent out.
Mr. Brooks, it's your conduct in this courtroom. It is what dictates the court's response. If you follow the rules of decorum and courtesy and civility, you will remain. But if you choose to
He's
You're
not
de
do that,
facto
then you run the
admitting
risk of
that
once
he's
again
not going to
forfeiting your right to be
behave.
present.
You say that even though I never consented to being taken out. You say that everything is about the decorum and all this. That's what you say. But when I'm raising issues of understanding, which I keep telling you I don't understand, then it's looked at as being
That's a you issue.
disruptive. It's looked at as intentionally trying to be disruptive.
Yes.
And I don't understand why everything I say has to have some type of disruption title to it. It's even been put on record numerous times with inaccuracy. Even what happened today. Nobody reported on record about me being bruised up and having to get bandaged up.
That's
and all
irrelevant
these
to the
things, but it was
record.
put on me, laid at my feet, as if me, quote unquote, being disruptive was deserving of what happened to me. I'm simply trying to have a fair trial. And if I don't, forgive me for being this way, Your Honor, but if I don't understand, I'm going to ask questions. That's the only way I can have clarity, is by asking questions. And you have refused
He's gonna
to
drive me
answer
nuts
anything, but I have to answer
over the course of
everything
a
you
month.
ask me. Where's the give and take? It should be fair. I'm not asking for legal advice. I'm not asking
Except you are. Every
for
time you
nothing
ask
like
her
that. I'm
to
asking to
help you
simply have
understand,
clarification so that I can understand.
that's
I
a
cannot
lawyer's
put on
job,
an adequate
not the
defense
judge's.
if I don't understand something. Do you see these boxes I got right here? Do you think I was able to go through everything in those
Mr.
boxes?
Brooks,
That's a you
I'm not
problem.
gonna go through this with you again, where you
She
attempt to
warned
put
you
on the record
when you
all
fired
of
your
these
attorney
issues that
last
you
week.
have when we're in the middle of a trial.
It's your
right?
fault.
You willingly waived your right to an attorney. I made all of those findings, so we will go
You made
forward.
those findings,
I
but
am
they're-
not obligated to answer questions.
made
When you
those
ask me
filings.
questions, I'm gonna mute him.
Yeah.
I am not obligated.
Obligated to answer questions that explain procedure or the law. I am obligated to address motions to address that are
The
based on
sign's
law
coming
and
out.
fact. I'm obligated to address objections, for example, whether it be
And he's
to
not listening.
testimony or evidence
He's
or
muted,
questions
but
posed to witnesses.
he's ranting.
But I'm not obligated, sir, to provide you with an explanation of the law, of the procedure. And with that, since
And not
I
only is
gave
she
him
not
two
obligated, it would
opportunities,
be
to
inappropriate
answer
for
a very
her to do
direct
so.
question, and that was, do you want to come back to this courtroom? And he chose not to answer it, but instead ask
And
a
he's still
question and then
ranting.
start making statements about his lack of understanding. I will find that his non-response, that he has not answered directly, which to me says he's not willing to follow the rules of decorum and courtesy and civility, and without such a pledge, he will remain in that courtroom. He's muted. The record should reflect. It appears he's talking as well. He's making hand gestures.
I don't think he's talking.
Lips are
I think
moving
he's
behind
shouting.
the mask. And I just wanted to make a record of that.
At least
All
his
right,
body language
then
would
we will
indicate
have the jurors
shouting.
brought in, and then the state can then proceed with its opening statement.
I'll be interested if they have the camera on him or a split screen during the opening statement. What portion of the prosecution's opening statement will have the objection sign? Like I said, it should just be tattooed across his forehead, or if he hadn't shaved his head, he could form his dreadlocks into some sort of objection, or at least an indication of objection. Or, as we discussed earlier, he could just get the objection bag and along with the gag. As much as he hates being removed from the courtroom, I do think it's both less prejudicial in the eyes of the jury, and it's better for him to be muted next door than to be gagged, because that's just, that has to look terrible in the eyes of the jury. But as she said, what was it, Illinois versus Allen, the 1970 case, the Supreme Court ruled it is not undue prejudice to gag a defendant if they're disruptive. All right, here comes the jury. So let's go. Been looking forward to this part all day. Some, what is it, 5.5 hours of streaming? And we're finally getting down to business. He's going to be standing and pacing.
All right, at this time, we will give the parties the opportunity to make opening statements. Does the state have an opening statement?
Yes.
And just for the record, Mr. Brooks is appearing from the other courtroom. That should not influence your verdict in any way, ladies and gentlemen of the jury. Go ahead.
I do like that she admonished the jury not to take that into account.
When we do that, make sure we confirm it should transmit, but we'll make sure it's transmitting over there as well. And if that's okay, if it happens, we may lose video of Mr. Brooks for the time being, as the state is using what appears to be a PowerPoint. Just confirm with me, Deputy Wittig, that when it starts, that it is able to be viewed and heard over there. Go ahead.
I think it should come up on our screen too. Maybe.
It was a cold.
They can't see it? All right, hold on.
And I'm kind of surprised. This is the least experienced of the three prosecutors. I think they determined last week he's been a prosecutor for 7 years.
No one needs to leave.
The other
off
two,
record, though,
more than
so
20
that I
each.
can set up another way to do this so that there's a share screen capability. Okay.
But it's possible that this means the more experienced prosecutors, one will do the closing arguments, and then after Mr. Brooks makes his closing arguments, the state gets the final word with their rebuttal closing arguments. And so it could be 3 sections. They gave the opening to the least experienced, because the truth of the matter is, while the opening is important, it's laying the foundation. It's telling the jury what to expect. But it's a statement. It's not argument. The close is the argument, and it's far more important. And I think most trial attorneys would agree it's more fun, it's more enjoyable. And so it could be that it's not strategic, but that the other two pulled rank and said, we want this part, you take the opening. And I don't know, I haven't heard any discussion about limitations as far as length, time length. So I don't know if it's going to be limited, although it's 3:30 almost. They're in Wisconsin. So if they want both of them to be done today, they certainly shouldn't go over 45 minutes each, depending on how long this technology break lasts. As much as technology is a blessing, it can also be a curse when there's technical difficulties. Of course, one of the issues with the stream is, that there's 6 murder charges, but the 70 other charges, although some of them are also the victim of them are the murder victims as well. But you look and there's 60, almost potentially 70 other victims, and they all have a right to watch the trial. And they can't all fit in the courtroom. So for that reason, technology is definitely a blessing in this case. And she sent him back as soon as the jury instructions were finished. They were trying to finish a few last minute motions that he brought, which were the standard sovereign citizen. He tried claiming
We
his
have
First
the
Amendment was
technology
being
problem solved. So go ahead, the state may present its
violated,
opening statement.
and he just would not stop interrupting. So
Sunday afternoon
he's out.
in November. Thousands of people were bundling up and going downtown to watch the annual Waukesha Christmas parade.
But they've got it working.
The event started off normal. There were dance teams, high school marching bands, local community groups, local businesses, all making their way
Speaking
down the
of
parade route.
object,
The streets were lined with friends and family members and neighbors, people there to soak up the atmosphere. Kids ran into the street to
like I
grab
said,
candy
this
from
is
people who were throwing it
setting the
in parades.
scene.
It sounds corny, but I think you'll see
It's a
from the
story,
videos,
not an argument.
there was a true sense of joy in the air. Darrell Brooks killed that joy. He replaced it with terror, trauma.
He killed a lot more than joy.
The evidence is going to show that Mr. Brooks left behind a trail of carnage and chaos as he made his way down Main Street through the parade route. The evidence will show that he left that crime scene, created that crime scene, in fact, because he was fleeing from another one where he had laid his hands on a woman,
That's the
and where
X.
police involvement became inevitable. So as he careened down Main Street, swerving from curb to curb, hands glued to the steering wheel, eyes fixed on the road in front of him with a silent rage on his face, he hit the gas with his red Ford Escape
He's really
and used it
painting a
as a
picture
battering
here.
ram over and over again, striking men, women.
Oh, I hope the
kids.
jury saw him roll his eyes there.
In the end, Mr. Brooks killed 6 people. He injured dozens more and left a permanent scar on this community. We are going to present evidence to you over the next several days in
I've decided on the right
phases,
word for him.
in order of events,
Cretin.
from start to end. I'm going to take a few minutes. I'm going to lay out for you the table of
Abominable.
contents of this story. We're going to set the scene with Sergeant Dave Warner from the City of Waukesha Police Department. Sergeant Warner was the highest ranking police official working at the parade that day. He was the incident commander for the Waukesha Christmas Parade, and we are going to, with Sergeant Warner's help, take you through this, which is the first of 3 maps that we will refer to repeatedly throughout this trial. This map depicts the area that we're going to be talking about over the next couple of days.
What would you
parade
do
route.
without Google Maps?
Now, for those of you not entirely familiar with downtown Waukesha, this is going to look like a bunch of gibberish, but once we get going and we repeatedly refer to these street names and the business names and the groups that were involved in this parade, I think it'll become like a second language to you. Sergeant Wanner will describe for you how the parade route ran from, if you look closely at the screens in front of you, the intersection of Main Street and White Rock Avenue. White Rock was a staging area.
I
for the
was
parade
using it
groups
as a
and floats.
noun.
And they made their way southeast on White Rock until they came to Main Street, and then they would make a right turn and head southeast down Main Street through the parade route until the very end as it wraps around to the south and runs into Wisconsin Avenue. The parade route then would continue to the east, making a left-hand turn on Wisconsin, but nothing really happens on Wisconsin Avenue. You're not going to hear any testimony about that. As you can see from this map, it depicts or represents each intersection where a squad car or a police officer was stationed. They're denoted by the little badge shields in the intersections. If you look closely, you can see little red lines, and Sergeant Wanner will describe how those represent the barricades that were placed at each intersection for security and safety purposes. Once we've got that established, we're going to move into the first chapter of this story, and you're going to hear about the origin of Mr. Brooks's rage that day. A violent domestic argument with Erica Patterson, his former girlfriend and the mother of his child. Erica Patterson is going to testify either today or tomorrow, hopefully today. She's going to tell you that in November of 2021, she was staying at the Women's Center, which is a shelter here in Waukesha. And on the day in question, November 21st,
Those three-syllable words are pretty
the
difficult.
defendant showed up in Waukesha in his red Ford Escape that she knew he drove, and he argued with her, and he harassed her, and he punched her in the face. And the thing about a swollen eye is it's tough to fake.
Objection.
You're going to hear evidence about how after,
That's a swollen eye.
You're going to hear evidence about how the defendant took Erica Patterson all over town that afternoon, from Frame Park, across the river, up Barstow Hill, back down to Frame Park. And at some point, after she was struck, after she sustained that injury, Erica called her friends because she needed help, and she had no one else to call. One of those friends is Corey Runkle. You're going to hear from Corey on the witness stand in this trial. Corey's going to say that she was Erica's roommate at the Women's Center. She had known Erica for a few weeks and they had grown close. And when she got the call from Erica that Erica needed help, Corey immediately responded to help. And she ended up finding Erica and Darrell Brooks in front of the White Rock School. If we go back, the White Rock School is on White Rock Avenue. It's on near the top right portion of the map. It's just south of Frame Park. And Corey is going to talk about how she found
I wish the
Erica and the
PowerPoint
defendant
map
at
were
this location.
higher resolution.
And she got into both a physical and a verbal altercation with Mr. Brooks. That altercation is captured on surveillance video, 2 surveillance videos actually. You're going to see both of them. You're going to see how the defendant was reacting that day. You're going to see what he looked like, what he was wearing, the red Ford Escape that he was driving.
That means the video's been
You're going to see
admitted to, well, will be admitted
how the
to
defendant
evidence.
reacted once Erica's
Hasn't
friend
been
showed up and
excluded
he
from
lost
evidence.
his physical advantage over a woman. Erica and Corey will also testify that at some point during this scuffle, the police were called. And you're going to see a separate video, a squad video from the responding officer that shows just down the block, there was a marked squad car with its lights flashing, marking the entrance to the parade. Something that people in front of White Rock School would have seen. So the evidence is going to show that the defendant must have known once things got loud and once there was more than just him and Erica on scene. The police were
Proving
gonna
knowledge is an element of
So he
proving
took the coward's
his
way out.
intent.
You're going to see him in the video get into the driver's seat of that red SUV. Corey and Erica will tell you that no one else was in the car. And you're going to see him pull off on White Rock towards Main Street. You're going to hear from law enforcement officers who were positioned along the parade route. The officers who made their initial contact with the defendant, the first ones who tried to stop him. And the first one is Detective Tom Casey, the lead detective in this case. He's sitting at the state's prosecution table right behind me. He's going to tell you that he was working that day as security for the parade. He was working at Main and White Rock. He's the first law enforcement officer to come into contact with the defendant during this incident, face to face, or I think better describe it as face to windshield. He tried to stop the defendant, but there's only so much a man can do against an SUV. But he's going to tell you that he got so close, he got such a good look at Darrell Brooks's face that from that witness stand,
So there's
he'll be able to say
no
to you
question of
definitively,
identity.
Darrell Brooks, the man in orange on the video screen, is the man who was driving the red SUV in this case. You're going to hear from a few more officers. Officer Bryce Butcher and Officer Sonia Schneider. They were positioned at the intersection of Main Street and East Avenue, just a little bit further south.
He's doing a great job
in that map.
Absolutely.
You're going to hear them
great
describe
job.
how they saw this red SUV approaching. They quickly realized it was not part of the parade. They quickly realized this was a problem. There were
Absolute
people,
pro.
children in the street, lining the street. And so they jumped into action. They tried to stop it. As the SUV started barreling towards them, Officer Butcher, again, tried to get in the way. He put himself at risk trying to get in front of the vehicle. Couldn't stop it. Officer Schneider tried to redirect the vehicle up Buckley Street, making a right-hand turn. She'll tell you, and you'll see in the video, there was room. There was space. She couldn't do it. The defendant blew past her.
He's an artist painting a
that's when
picture.
The screams in the police radio start.
I really like his style.
You're going to hear from Jim Hawkinson, a battalion chief for the Waukesha Fire Department. He's going to tell you about the massive scope of the emergency response to this tragedy. He was in charge of the fire department that day. He's going to tell you about all of the units that had to respond to the scene.
As I've pointed out in comment section on other people's trial videos,
transport all the victims. He's going to tell you about
the occasional
other
mispronounced word or even
mutual aid call that went out.
frequent
all the other communities that came to help out. He's going to tell you about how Waukesha Memorial Hospital, just up the hill from the parade route, quickly reached capacity. And so everybody,
it's the story that
diverted
counts.
to other medical facilities.
Although his presentation is just
We'll transition then
top-notch.
into the next chapter of this story, and you're going to hear from some of the people whose lives were forever changed by the defendant's terrible decisions that day. But I'll tell you right now, you're not going to hear from all of them.
Because 6 of them are dead.
It wouldn't make sense. It's not necessary. We intend to present the evidence to
Eventually,
you in an efficient and streamlined way.
An attorney
we will elicit
would give the
testimony and
objection.
introduce exhibits
This is
that cover
cumulative
every element
evidence. We've heard
of every
this.
single criminal charge in this case. But our goal is to avoid
It's
duplication
adding
of evidence
insult to injury.
and to avoid undue hardship on the victims and the witnesses who have already suffered.
Although sentencing, the victim
much.
impact statements, they all can give their
So the first
testimony
witness
if they
in this part of the
desire.
trial that you're going to hear from is Nicole White. She's the very first person, aside from Detective Casey, who was struck by the defendant on that day. She's going to tell you, as we look at this second of the 3 maps that we're going to repeatedly refer to, that she was marching with her coworkers and friends with Remax. You'll recognize the float, I think, in the videos, because just like the commercials for Remax, there's a giant hot air balloon that shoots fire out of the basket, which is pretty cool. And she's going to tell you she was marching with her friends and her coworkers when, without any warning, she was hit from behind
Remax
and
being
knocked over.
a
You're gonna see video
national
of that.
realty.
Nicole White has a special
Company.
significance in this case because, as the first person who was struck, she represents the point in time when Mr. Brooks was legally required to stop. You heard the judge read
I mean,
the
you'd
hit
think
and run
he'd
jury
be legally
instructions.
required to
To
stop
summarize,
when
in
he saw the
Wisconsin, anybody
police
who's operating a
cruiser
motor
with
vehicle who's
flashing
involved in
lights
some kind of accident, they have
indicating
a
a
duty to
closed
stop,
road.
to investigate, to exchange information.
But I get where he's going.
Not only did Darrell Brooks not stop, the evidence will show that he sped up. The evidence will
That's
show
more intent.
that as his body count increased, so did his motive to get away. Nicole White, I think, is a good point here for me to explain to you, or to summarize for you, the charge of first-degree recklessly endangering safety. Now, again, the judge read the law to you all morning and a lot of the afternoon, and she's going to read it to you again at the end of the case, and you're going to have a binder with all these instructions written down for you, so you do not need to memorize them, okay? But we're going to talk about first-degree recklessly endangering
reassuring.
safety. It's a crime where it's committed by someone who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. Let's talk about what the state's not required to prove with recklessly endangering safety. Not required to prove injury. This was a conscious decision in our charging decision. We're not going to get into medical records. We're not going to talk about the details of witnesses' injuries because it's not relevant, except to the extent
And
that
it's
it proves
just
that they
a
were
further
endangered
violation.
and resulted in injury. But we don't need to get into who was hit or how hard or how long they've suffered. We just are going to prove to you that their safety was endangered. So, after Nicole White, we are going to talk, you're going to hear evidence about the first of the larger groups that was affected by this incident, the Waukesha South High School Marching Band. 10 kids in that band got either hit or run over.
That's pure evil.
Here's the first example of our efficient presentation of evidence. You're not going to hear from any one of them. High school aged kids,
Pure
there's
evil.
video showing each and every one of them getting run over. So instead, you're going to hear from their band director, Sarah Waymire Aparicio. She's going to come in and she's going to look at some still shots of the video. She's going to identify each of the 10 kids for you. You're then going to watch and listen to the video, and it'll be clear as day who's getting run over or hit. It'll be clear as day whose safety was endangered by Mr. Brooks that day. As we move further down the parade route, you'll hear evidence about
as if
Burris
running through a
Logistics
parade
Group.
is
You'll
isn't
hear
bad enough.
testimony from Kelly Grabo about how she was marching with that group,
Running
along
down
with her young
kids.
daughter. You'll see video of them. They're dressed up like the Who's from Whoville. You'll see them get hit. As we move further down the parade route, you'll hear testimony about the Green family. They're spectators along the parade route. Charles Green is going to come in and talk about how he was there with his family. He was sitting on the southeast corner of Main and Gasper, across the street from Martha Merrill's Books. He'll talk about how his kids were seated on a portable bench, something that you bring to a parade to sit on, and how they got knocked off that bench when the defendant ran into them. The next point in the presentation of evidence will involve the Waukesha Blazers. I think it's important to point out you can't consider this evidence of each crime in a vacuum. You need to consider the entire incident. Because at this point, by the time we get to the Blazers, the defendant will have already hit or run over 15 people. You'll see in the video that at this point, the defendant has
And that was
actually
all in a
increased
blink
his
of an
speed.
eye.
And you'll hear from Detective Mike Carpenter with the Waukesha Police Department. He's going to come in and talk about speed analysis. He'll tell you that he's certified to use a software program that basically takes surveillance video, measures the amount of time it takes to travel a certain distance in that video, and calculates an average speed over that distance. And he'll tell you that in video obtained from Bosco's Social Club, which is right in front of where the Blazers got hit, he'll tell you that that video in that area right before the Blazers got hit, the defendant was traveling in excess of 33 miles an hour. There were 5 victims in the Blazers.
I wish he said who the Blazers
That
are.
includes Jackson Sparks, who was walking with his big brother Tucker. Cut down in the road before he had a chance to put any miles on his soul. Jackson was 8.
Keyword was.
He died 2 days later in the hospital. I think this is a good point to talk about the law of first-degree intentional homicide. Again, the judge
Brooks actually
provided the law
showing
to you.
emotion, regret.
It'll be provided to you again at the conclusion of the trial. I want you to take a look at that second element. I don't know what the defense in this case is going to be. In fact, the defendant isn't required to put one on at all. He can sit there
Reading the
and not say a
charges
word throughout this trial, and that's perfectly within his right, and you
can
can't hold that
certainly
against him.
seem clinical and detached.
And in fact, if
Putting Jackson
he does that and we
Sparks'
don't prove each and
photo
every one of these counts to you beyond a reasonable doubt,
adds
you
a
must find him
human
not guilty.
element. And
That's the law.
It
But
it's
if he
hard.
does choose to present a defense, if he does raise any issues, I expect that he will likely claim that he didn't mean to kill these people.
But he clearly
at that
didn't
second
care
bullet point.
if he hit them.
Keep that in mind as you're watching these videos, as you're learning about how this parade unfolded. Consider whether the defendant was aware that his conduct was practically certain to cause the death of another human being.
That's reckless disregard. That's at least
We're
second
going to move
degree
further
murder.
down the parade route, and the next group after the Blazers is the Extreme Dance Group. There were
I'm assuming
girls
that's
of really all
children
ages
as well.
in this group, from toddlers being pulled in strollers up to high school age teenage dancers.
All children.
15 victims, 15 people associated with this group either got hit or were very close to getting hit. That doesn't include 2 additional spectators who were watching the parade from the south side of Main Street near the 5 Points intersection, right in front of the Extreme Dance team as the defendant drove through.
I intentionally didn't read too much news coverage.
Girls in this dance group
I
suffered
wanted to
catastrophic
experience
injuries.
it like
The
the
group
jury
of
would.
victims also includes parents,
Well, kind of.
grandparents,
I've seen
siblings,
the
people marching
Other arguments.
with the group, but not necessarily as dancers.
But
you're not going to hear from everybody who got hit. You're going to hear from the 2 instructors.
this is hard.
The 2 young ladies who were tasked with teaching these girls these routines and marching with them and encouraging them.
I didn't realize how many were
and comforting
kids.
them after the fact. And they're going to, in the video, identify for you where all these girls are positioned, and it'll be very clear the path of travel of the vehicle as it goes through that group of young ladies, who was hit and who was nearly hit.
And even as a defense attorney, I
The next,
do take into
group
consideration
Down
crimes
the parade
against
route,
children are
the Citizens
are
Bank.
the worst
And
of the
here
worst.
we reach the second count of intentional homicide. Jane Kulik was marching with Citizens Bank with her friends, with her coworkers. This is the only count of homicide for which there is no clear video depicting how she died. So instead of watching video, you're going to hear evidence from her coworker and from the man who was driving the truck pulling this float.
You can hear the emotion in the court.
And they're really the ones who are in the best position to observe exactly what happened to Jane Kulik as the defendant plowed through that parade route. And they're going to describe for you how she was struck, how she was run over. The medical examiner will explain that Jane Kulik's cause of death was multiple blunt force traumatic injuries.
I mean, I'm 1,000+ miles away.
We'll move
Don't
further
know
down southwest
anyone
along the parade route,
from Waukesha.
and we'll learn about
No
a group
connection.
that was standing in front of the steaming cup. Spectators, again,
This
innocent people
is
have
hard.
nothing to do with anything. You're going to hear about 3 kids who were standing along with a bunch
I
of
imagine
others
I'm a little
along the curb in
glassy-eyed.
front of steaming cup. And as the defendant swerved from the left side of the street as he hit Jane, back to the right side of the street as he was avoiding the vehicle that was ahead of him,
Can't hit vehicles.
Flip the
Gotta
curb.
hit people.
and hit these 3 kids.
I should say, gotta hit kids instead
Then
of
we're going to move in
vehicles.
to the next group in the parade route,
Disgusting.
which is the dancing grannies. This is the deadliest point in the parade. 7 people in this group were struck. 4 of them died. You're going to hear from witnesses, members of the Dancing Grannies group, who will come in and they will describe being completely caught off guard. They will describe seeing pom-poms in the air. And the next thing they knew, there were bodies on the ground before the pom-poms hit the ground. You will learn about Bill Ospel, who was marching in a support capacity. He was there to support his wife
Wilhelm.
Lola and their friends.
There's that
the Dancing
good
Grannies,
Northern
walking along the
Midwest
parade route, trying to
German
be helpful.
influence.
And as the defendant swerved around the Dancing Grannies vehicle, which is a white SUV, you'll see it in the video, swerved around the right side, he hits Bill. And the medical examiner is going to tell you that Bill Ospel cause of death was multiple blunt force traumatic injuries. You'll learn about Tamara Durand marching with the Grannies. This is her first parade. You'll see a diagram of where she was positioned. You'll see video of her getting
She
struck.
doesn't look old enough to be a granny.
The medical examiner will tell you that Tamara Durand, cause of death, multiple blunt force traumatic injuries.
Not that that's what's important, of course.
You'll hear about Lee Owen, another dancing granny, positioned right next to Tamara, who had just begun one of her favorite routines, walking in a winter wonderland, when she got hit. You'll learn about Jenny Sorensen. You'll learn that Jenny was walking at the front of the group carrying the banner. You'll learn that Jenny was normally a coach for the group. Normally she rode in the vehicle in the back so that she could provide feedback and critique to her dance mates. But she filled in at the last moment today and helped carry the banner. You'll see video of Jenny getting struck. The medical examiner will tell you that Jenny Sorensen's cause of death was multiple blunt force traumatic injuries. You'll hear more speed analysis testimony at this point. You're going to hear from Mike Smith with the Wisconsin State Patrol, who's going to testify very similarly to how Detective Carpenter is going to testify about speed analysis. Basically, he takes surveillance video, this time from Curry Insurance, which is on the south side of Main Street. It shows the grannies getting struck. They measure point to point and measure the time between those 2 points and calculate an average speed over that distance, which is roughly from Clinton Street up until the camera cuts out. They'll tell you that at that point where the defendant crashed through the Dancing Grannies group, he was traveling at approximately 32 miles an hour.
He was at 33 when he struck
The
Jackson.
8th and final group that was struck by the defendant in this case is the Catholic Communities of Waukesha. This is a faith-based organization. It consists of members of multiple local Catholic churches who got together that Sunday afternoon to spread a little Christmas cheer. There is not great video, and perhaps that's for the best, of this group getting struck. In total, there were 19 victims in this group. In what little you can see from the video, you can see the defendant's taillights swerving from the left side of the street to the right. You can see them bouncing up and down. There are no speed bumps in that section of the road. The next phase of the evidence will involve the manhunt. How authorities found the defendant, took him into custody, and the statements he made after he was placed under arrest. You will hear from Officer Bryce Skolton, who was positioned, if you look at this third of the 3 maps I referenced, on the very top of this map at the intersection of Main Street and Wisconsin. Officer Skolton was positioned at that point to direct the parade route to make a left-hand turn from Main Street onto Wisconsin, to stop any traffic coming from the other directions. He saw the defendant come around that corner. He saw the defendant drive right at him as he's standing in the middle of the road. And as the defendant went around him to the left and went south, Officer Skolton fired 3 rounds from his service weapon. All 3 rounds hit the car. None of them hit the defendant. You will hear from another police officer who was not on duty that day. He just happens to be a police officer. His name is Officer Ralph Salyers. He's from the Waukesha Police Department. If you take a look at that map,
Wauwatosa.
he's going to describe
That's
to
a
you
good
being
Wisconsin name.
on the sidewalk, leaving the parade. He was walking past Les Paul Middle School. He's going to describe hearing a loud commotion. He's going to
That named
describe
after the
seeing
Les
a
Paul,
red
the
SUV
guitar manufacturer.
with just
Got a beautiful Les
utterly
Paul downstairs.
total front end damage coming to rest in a driveway at 338.
He deserves
Maple
a school
Avenue.
named after him.
You're going to see video of the defendant in the red SUV pulling into the alley behind 338 Maple. And then a few moments later, you'll see what appears to be the defendant coming back onto the screen and running away from the vehicle, apparently in a hurry, apparently aware that he had done something terribly wrong. You're going to hear from a series of witnesses between that point and the defendant's arrest, where they will describe the defendant approaching them, contacting them, asking them to use their phone. Because he was in such a rush when he ditched his SUV, he left his phones behind.
Which they can use to
Then you're going to hear from
determine
Daniel
it was
Ryder,
him.
and I think the
Not that
evidence will show
identification
Daniel
is a
Ryder really
problem.
a good embodiment of the spirit of Waukesha. Not knowing what Mr. Brooks had done, Daniel Ryder opened his home to the defendant. The defendant showed up at his front door without any shoes on, with a t-shirt, said he was cold, said he needed to use the phone. Daniel Ryder let him inside, gave him a sandwich, let him use the phone, and then gave him a coat. And a few minutes later, the police showed up.
I hope
You're going to
that
see body
was
cam video of
the
that
best
arrest.
sandwich ever. And that he
We're
choked
gonna hear from
on
Officer
every
Rebecca Carpenter
subsequent sandwich.
that she responded to that area around where Daniel Ryder lives because of reports of a man knocking on doors. She takes him into custody. He identifies himself on the body cam video. They search him, and in his pocket they find a key to the red Ford Escape used in this attack.
Once again, identification, not a
You're
problem.
going to hear from a series of officers who retraced the defendant's steps that night.
He's going to
Recovered
have a hard
surveillance
time
video
saying
showing the path
it wasn't
that he
me.
took. The path is depicted here in the third map that I'm showing you. You're going to hear how they recovered his sandal, his sweatshirt along the escape route. You're going to hear from Detective Jay Carpenter with the City of Waukesha Police Department, and he's going to talk to you about the defendant's statements after he was taken into custody. I'm going to let that interview speak for itself, other than pointing out for you that you will, I think, quickly learn a few main points about the defendant on the night that this happened. He was lucid. He was aware. He was intelligent. He was probing for information. And he was deceptive. We're going to then wrap up with testimony from people who plugged any of the remaining holes in the investigation. You'll hear from crime lab analysts about DNA evidence, about finding the defendant's DNA on the steering wheel of the red Ford Escape.
That's about the only
You're going to hear from
DNA
Wisconsin
evidence
State
that's
Patrol
possibly
Inspector
relevant.
Ryan Schultz. He's going to testify about the mechanical
Or at least
inspection that he did on
necessary.
this vehicle. In case you were wondering if there were any issues that would have prevented Mr. Brooks from stopping or from pulling over, he's going to quickly put those concerns to bed.
Brakes work, steering
Conducted that
work.
mechanical inspection. No problem with the brakes. The accelerator didn't stick. There were no mechanical problems that would have prevented Mr. Brooks from stopping.
The windshield
Finally,
wasn't
We're
blacked
going to
out.
close our presentation of the evidence, not with a witness, but with an experience for you. You are going to go to a secure location, and you're going to have a chance to see the murder weapon with your own eyes.
Can't exactly
able to
bring
see
that
that
as an
voice.
exhibit into the court.
I want to close now with a
Little
few points
big.
about how the evidence relates to the law in this case. There are, obviously, we've gone through the 6 counts of first-degree intentional homicide, But in addition to those homicide counts, there are 6 counts of hit and run involving death. Those are separate charges. The evidence will support convictions on all of them, all 12 counts, but they involve the same 6 victims.
Lesser included, like manslaughter.
Another point I
would
want to
be.
bring to your attention is that for each count of first-degree intentional homicide and each count of first-degree recklessly endangering safety, if you find the defendant guilty of any of those counts, you have to answer a second question. Did he commit that crime while using a dangerous weapon? And here the evidence
A
will show
Ford
that he didn't
Escape
use
is a
gun or
dangerous
knife
weapon
to commit these crimes.
used in the wrong
He
way.
used 3,500 pounds of steel, rubber, and glass.
Surely an escape weighs more than that.
The defendant's also charged with 2 counts of felony bail jumping. You'll hear evidence to support those charges, which includes the fact that the defendant was charged with a felony offense in a case in Milwaukee County and released from custody subject to conditions of bail. And then he was charged with another felony offense in a separate case in Milwaukee County and released from custody subject to conditions of bail. And those conditions of bail included requirements that he not commit any new crime.
Yeah, I guess he's right.
And those conditions of bail
That's a
were in
lightweight
effect
car.
on November 21st of 2021. We have dozens of video clips to show you. You're going to have notebooks and writing utensils while we present this evidence to you. It's a lot to keep track of. And when you go back into the deliberation room, it might be difficult while you're deliberating to remember which video was about which victim or which incident or which group. And so my suggestion to you is that as we go through these videos, you're free to do whatever you want with your notes, but my suggestion would be as we go through these videos, they each will be labeled with an exhibit number. And so I recommend that you keep track of which exhibit number corresponds with which video. That way, while you're deliberating, if you want to see those videos again, you can
This
ask
is
for them
good.
by exhibit number.
I
Can't guarantee
like
that you'll be
this.
able to see any or all of them, but you can ask.
This is good advice for the
I'm done now.
jury.
I want to close on one final point, and that is on behalf of the state of Wisconsin, I want to say thank you. We work, you're serving in what is the greatest criminal justice system in the history of the world, and that's because of the 16 of you. It's because a group of citizens,
4 of them
randomly
are
selected,
alternates.
come in and make the final ultimate determination between guilty and not guilty. That's unique in this world. It's special. And so we're going to go through this evidence. We're going to be mindful of your time. We know how valuable it is. We're going to be efficient, but we have a lot to get through. A lot. And at the conclusion of all that evidence, District Attorney Opper is going to stand up here and she's going to ask you to render verdicts consistent with
She's
the
the
evidence,
most experienced.
to find the defendant guilty of each and every count. Thank you.
Well, that
Mr.
was
Brooks, my first
powerful.
question to you is, will you be making an opening statement at this point or deferring until your
I absolutely give him an A+.
Case.
That was
the defense portion of the case?
so well
I will
done.
be deferring at this time, Your Honor. I need a little more adequate time to
Probably smart on
make
his
sure I go over
part.
the points that I need to make.
All right. then the court
That's
will,
actually a very good
honor that
decision on his
request,
part.
Advise the jury he's deferring his
Considering
opening statement until a later point.
He
in
can
the
choose to
proceedings.
give his opening statement before his case in chief.
I am going to just
Which
take a
can
short
be
break so I can
strategic in
talk some
general.
logistics with the parties to determine whether it makes sense to start with a witness
But
tonight.
it's
Yeah,
also
4 o'clock, a little bit after.
smart due
wait
to
until
him
tomorrow.
only having a
So,
week to
Either way,
prepare
you'll
without
come
his
back
attorneys.
because you'll either hear testimony or I'll read an instruction for you. But at this point, the jury may be excused.
My guess is 4:06 Wisconsin time. No witnesses today. But that opening statement was a good reminder. As much fun as it can be to make fun of sovereign citizens, for all their bluster about show me the victim. We saw the pictures of 6 victims there. And about many, many, many more. And that's not funny. That's just it was powerful and it was hard.
Attorney Upper, your first witness, how long would that
It did
witness
have
be?
me close to
Our
tears.
first witness is Sergeant Warner. I expect his testimony to take 10 to 15 minutes on direct. I would ask that you would hear his testimony this evening or this afternoon, Your Honor. He was supposed to have left town at about noon today to take his daughter on a college visit in Kentucky. He's delayed his departure so he could provide his testimony. And if we can get him in and out, he will leave at 5 o'clock and arrive at midnight at his destination. I have a second witness, if the court would hear me, who's here as well. Her testimony probably would also take about 15 minutes on direct, maybe a little longer. No, Mr. Mitchell says no. She has traveled here from Janesville. Her transportation
20
also
to 30
difficult,
minutes on direct.
and so she's here and ready
Cross
to go.
could
if the
be
court would indulge
a mess.
those 2 witnesses this afternoon.
It certainly seems reasonable. Mr. Brooks, my question to you then is, do you want to come back over for the testimony of those witnesses?
I would prefer to. I'm still kind of
Will you behave?
taken aback by not being able to know exactly how many witnesses are expected to testify, and not being able to.
You've been
turn
provided
in
the
my own
witness list.
Well, Mr. Brooks, you've been given copies of the witness list. The state's offered you a flash drive with all of the exhibits to streamline.
See, I'd be a
what
great
will be
judge.
presented at trial
I'm-
versus what is in discovery. So you've
I'm
had
quicker
ample
on the draw than
opportunity
Judge
to
Darrell is.
review those. I'm happy to bring you back. I need you to pledge to me that you will follow the
Oh, a pledge.
rules of procedure and evidence, that you will only interrupt if you have an objection.
A proper
That
objection.
objection needs to be founded in law. And then you need to pledge to me that you will honor whatever decision I make so that the testimony of these individuals can proceed within the time frame that the prosecution has indicated it will take. You, of course, will have an opportunity to cross-examine them. Are you willing to follow the rules of courtesy and decorum and the rules of procedure and evidence?
From what you explained yesterday, the objections you said have to be like, I think you said like 3 words. Is the way to actually object. So I don't
Well,
recall you.
I can
saying
give you up to a
anything.
sentence.
What I am trying to avoid, sir, are what are called speaking objections. The idea behind that is that you give me just a little bit of information so that I can either make a determination or, if appropriate, send the jury back out so that I can then hear
She's
arguments
saying
from the parties.
objection hearsay.
Some objections really
Objection
are one
foundation.
word, hearsay, maybe 3 words, calls for speculation,
She
things of that
doesn't
nature.
want objection.
So,
This is hearsay because
If you're willing to abide by that procedure, then you can come back to this courtroom.
although it might be objection hearsay due to this part of the rule and this part of the rule.
We give an answer right now to that.
So you're not willing to follow the rules of courtesy and decorum and
Nope.
procedure and evidence?
That's not what I said.
That's why I'm asking the clarification.
No
question, sir.
answer is no.
I was clear in what I said. I don't.
If
think,
you don't answer in the affirmative, it's a no.
make that determination right now.
Let me ask it this way, sir. You may reclaim your right to be present if you are willing to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. Are you able to do that, sir?
I thought I have.
Sir,
It's I think, a fairly simple question. I'm asking you if you are willing to conduct yourself appropriately
I'll shorten it to that. Are you willing to conduct
yourself appropriately, sir?
I have to the best of my ability.
Sir?
Please answer my question directly. Are you willing to conduct yourself appropriately?
Not in the
I have
slightest.
conducted myself appropriately.
I'm not asking about your past behavior. I'm asking if you're willing from this point forward, for the purposes of the
He's incapable of giving
testimony
a
of
straight
two
answer.
witnesses, to conduct yourself appropriately.
I have.
That's not my question.
That's not the answer I'm looking for.
Once again,
I'm not asking if you
he's
have.
reframing.
I'm asking if you're willing going forward to conduct yourself appropriately during the questioning
Sovereign
of these two
citizens only want
witnesses.
to answer
Yes or no?
their version of a question. Answering the judge's question is a no.
Back over here eventually. If
So
I
that's
come
a
back
no.
here.
Mr. Brooks,
I'm further advising you, I'm looking for a direct answer of yes or no, and that your
At some
failure
point,
to
she
give
has
me a
to
yes
take
or
his
no answer
failure to answer
will
as
be
a
considered by
negative
this court
answer.
to be non-responsive. So let me ask you the question one more time. Are you willing to conduct yourself appropriately during the questioning of these two witnesses?
No.
To be 100% honest, I cannot answer that.
All right, then based on that answer, which is non-responsive to the question that I asked, he has not given me a pledge or indication of a willingness to conduct himself appropriately going forward. And based on that, he'll remain where he is. You will remain unmuted.
That's the right
And so
choice.
if you have an objection, you can lodge that objection.
He'll remain unmuted for now.
Within accordance
For now.
or according to the rules of evidence, sir. All right, with that, let's have the jurors brought back in, and we'll start with the taking of testimony.
I wonder if he's thumbed through the rules of evidence in the last week.
I don't think it'll take long if you want to call for him.
Let's
Non-responsive.
It means you didn't respond.
you did not answer yes or no. All right, do we need to
So
back
that's
out?
taken
Do I need, oh, I wanted to see if the camera angle, so have them wait for a sec, please. Sorry. Not going to answer any other questions at this point. The state's setting up a map for use with a witness. I want to make sure that it's
I really
that is
find him
viewable on the witness camera that
vile.
is being transmitted into the courtroom where you are seated. So let me back up.
My distaste for him grows
Zoom out a bit.
with every word he speaks. With
Turn over.
every
You want to look at the screen above? And
look
I think
he
it accurately
makes.
depicts what you're going to go over on that map. Do I need to back out a little bit?
Just a little, yeah, because the top of my.
And his wild gestures.
Just a little.
All right, hold on. I'll go up. Do you think with where that chair is, the witness will?
I would ask the witnesses to have to stand where I am so that everybody can see.
Oh, that would be a good idea. No, you're not muted yet.
Yeah.
Mr. Brooks, if you're asking me to make a judicial determination, I've already rendered a decision about where you're going to be. All right, I'm going to mute you, sir. Now we're moving on to that part of the procedure since you are you're not following the protocol that I've set in place, that you are back to one of these sovereign tactics about, have I made a judicial determination? The record speaks for itself, sir. I'm not going to make a further record on that, nor will I answer the question about, am I making a judicial determination? I've made a decision
And while they're arguing on this,
And
I'm
that
going to
decision, as you know,
take
remain in
what the
the
judge referred to
courtroom.
as a comfort
Once
break.
the jury
I'll be
is
right
brought
back.
back in, I will unmute so that you can lodge objections. But if you interrupt without making an objection and just start talking about a judicial determination, then I'm going to mute you once again. And the procedure for objecting will require that you raise your sign, write it out, and provide it to the bailiff, who will provide it to the court so that I can rule on it. If that slows things down, then so be it. But that's the procedure that I'm going to follow. All right, the jurors can be brought in then. As a reminder, I'm not requiring an all rise even for the jurors. I understand you may do it, but there's a reason why I'm not requiring it, so. Mike, will Pete have the notebooks? Oh, excellent. Thank you. You can start passing them out. Ladies and gentlemen, you may have a seat, and the writing materials will be passed out. Our intent is to have the state call its first two witnesses. And then once that is done, I have an instruction to read, and then we'll break for the day. And I'll consult with the parties before I let you know what time you should report tomorrow. And keep in mind, my time I say we start for court might be different than your report time. All right. All the materials passed out? Very well. Then the state may call its first witness.
Thank you, Judge. State call Sergeant Dave Warner.
Good afternoon, Sergeant. If you would please make your way to the witness stand. When you get there, please remain standing, raise your right hand, and my clerk, Teresa, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat, at least initially, or do you want him to stay standing?
No, actually, you can start out seated, please.
Very well. Sir, would you please state your first and last names for the record and spell each?
Yes. My name is Sergeant David, D-A-V-I-D, Warner, W-A-N-N-E-R.
Thank you. Go ahead, Attorney Opper, your witness.
Thank you. Sir, how are you employed?
I'm a patrol sergeant with the City of Waukesha Police Department,
How long have you worked in law enforcement?
18 years.
And as patrol sergeant, what are your general duties and responsibilities?
I oversee officers across all shifts
I'm back.
that are assigned to the patrol division.
That's the
Want to direct
danger
your
of
attention
sitting
to
here
the date of
guzzling
November 21,
water all
2021. Did you work that day?
Yes.
Were there any events occurring in the city of Waukesha that afternoon?
The Waukesha Christmas Parade was that afternoon.
Has the Christmas parade been held in years prior to prior to 2021?
Yes, every year that I've been employed at the police department, we've had a Christmas parade.
And is it typically that third week in November before Thanksgiving?
Yes, every year that I can remember, it has been.
Okay.
setting a
Is there any
foundation.
planning or preparation that goes into holding a parade in Waukesha?
Yes, there are meetings with the group that's putting on the parade in advance. There's also a group of individuals that prior to the parade, usually the Friday before, will post no parking signs along the parade route. There's a group from our city garage or Department of Public Works. They'll put out barricades at the designated intersections where we request them to put them out.
Showing that Brooks should have been
And
on
what
notice
about,
that it was a
manpower?
closed
What type of
road.
manpower would you devote to an event like this, sir?
It's rather significant, given the large area that a parade like this encompasses, the estimated amount of attendance at the parade, between detectives, police officers, supervisors, reserve officers, community service officers. I would say we have in excess of 30 additional bodies planned that day just to handle the parade itself.
You mentioned the use of individuals such as reserve officers and community service officers, I think you said. Is that correct?
Yes.
Are those sworn law enforcement officers?
They are not sworn, no.
What is their role or function?
The reserve officer group is a group of people who volunteer their time to help with events like parades. They're given training in directing traffic and closing streets down. A community service officer is a paid position. They're part-time employees, usually younger individuals looking to learn more about a career in law enforcement.
And you said also parking attendants would be assisting in this endeavor?
Correct. We're usually looking to get as many extra bodies as we can, and the assistance from our parking agents is usually required for this event as well.
And this would be in addition to the sworn law enforcement officers that are assigned to work the parade.
Correct.
And obviously you still need other officers to patrol the city, correct?
Yes.
Where is the parade held?
The parade takes up a large portion of our downtown area. There's a staging area that the floats before the parade that they're all instructed to assemble in a particular area along White Rock Avenue between Niagara Street and Main Street. And that's about a 3-hour process of getting all the parade participants into that area and lined up accordingly.
It's a big undertaking.
The parade itself runs along Main Street from White Rock westbound to the Veterans Park area, where it makes a turn and then heads up Wisconsin Avenue and ends near the Waukesha Public Library.
Sir, if I could ask you to stand up and refer to the diagram behind you. This is a map that's been marked as State's Exhibit number 1. Do you see that sticker in the bottom right-hand corner?
Yes.
Okay, I'm sorry, it's a little tight up there, but if you could start in the upper right-hand corner of the map, and Your Honor, if we put up the digital copy of the map as well, I know it's hard to see, but then we'd have to do the screen share again.
Had to break down and pull out my phone
that
to look
correct?
at the map.
Yes, that's my understanding.
Okay, I'm gonna ask the paralegal to please put up State's Exhibit number 1 on the digital copy as well. Sorry, we got the wrong one. All right, Madam Clerk, thank you. We're ready here.
As you present that, you know, you can hit that little arrow, that will get rid of those extra things that aren't needed. There you go. Go ahead.
All right, and Ms. Gussie, if you could zoom in on the upper right-hand corner, please. There you go. All right, sir, if you can use the map, the big map in front of you, please, and the jury can follow along with the digital copy if they want. So starting in the upper right-hand corner. Yes. What's up there, please?
That is Frame Park.
And what's at Frame Park?
Frame Park has a lot of, it's got a playground for children. There's a very large baseball diamond. different shelters. There's a formal garden. There's a boat launch. It's a very large park in our city that encompasses a lot of different activities.
They really do have
Is
good
the boat
audio.
launch shown on Exhibit 1?
Yes, right here.
Okay. And the waterway that's shown on the exhibit, what is that waterway?
That is the Fox River.
Now, is the parade route shown on Exhibit 1?
Sorry, Attorney Upper, can you give me 1 second? Mr. Brooks, just a reminder, you're not muted.
Oh,
I'm sorry for the interruption. Go ahead.
I'm sorry too. I thought I was muted. I apologize.
The default
Okay,
is
thank you
mute,
so much.
Go ahead and point
unfortunately.
out the parade route, please.
So the parade route in this map is essentially this purple line. This area here is what I referred to earlier as a staging area. And then actually at this corner right here, westbound is where the parade route would follow down to the corner here. I refer to this as Veterans Park. That's that area there. And then it would turn up Wisconsin Avenue and end around the library right here, which is that green area.
Okay, and we're just putting that up on the digital display too right now. Now, on this map, sir, we've designated several points along the parade route to reflect where various officers were positioned. Is that correct?
Yes.
Could you just briefly walk us through it? I don't need you to name every officer, but just point out the intersections and what was located at each intersection using Exhibit 1.
Sure. I was here at the intersection of Hartwell and White Rock. I had a police SUV, an unmarked police vehicle, trying to maintain the integrity of the route and keeping the road shut down. Here we had various officers. It's kind of a mixed use of barricades, marked police vehicles, police tape, just in order to keep the streets shut down and make sure that there's a visible representation that the streets are not open.
Please keep going down, westbound down Main Street, please.
Sure. So we come to Buckley and East
To
Avenue
interrupt
here.
this, I'd
Both sides of
probably
the intersection
object
shut
that
down with
he's not
barricades.
testifying
We
from
come down
personal
further
knowledge
down
right
West
now.
Main Street to Martin Street.
Although he probably is
The
due
red
to
line here signifies the
planning.
barricade was in place there.
he would have known
At Main
as a
Street and
sergeant
North Barstow
where his
Street,
officers would be.
Again, barricades on both sides of the intersection.
But I'd
there.
still put the objection in just to throw them off.
Gaspar and East Main Street, a barricade. We also had a marked police fleet, as we did at other places where the yellow is signifying that. This is our 5 points area, as we call it, kind of a larger intersection with roads in different directions here. So at this intersection, we had a use of barricades, police tape, police vehicles. It's just a very large intersection to be able to shut down just with one of those things. So it kind of becomes a mixed use of different tools that are available to us. We have Clinton Street and Main Street here. Again, barricades on both sides of the intersections, along with officers. Maple Avenue and East Main Street, barricades and reserve officers. And then we come around toward the Veterans Park area, again, another very large intersection where we had an officer and multiple barricades shutting off the traffic. And then along Wisconsin Avenue here, we had one point at Maple Avenue where we had a CSO along with a barricade. And
Right now, you're pointing at the very bottom edge of the map, correct?
very bottom here.
Okay.
And then from that point east, the parade kind of disassembles with floats going different ways depending upon their size and maneuverability at the end of the parade route.
This map, exhibit number 1, is oriented north, correct?
Yes.
Okay. The items, and I know this is like a vision test for everybody, but on the map, the yellow boxes represent what, please?
The yellow boxes on this map represent police vehicles that were utilized in the parade.
Okay, and what about the blue boxes?
Showing how the
Blue boxes
parade
are
route
names,
was blocked
personnel assigned
from
where
traffic.
you see an RO that would be a reserve officer, PA would be a parking agent, CSO would be our community service officer, OFC would be an officer.
All right. the reserve officers and non-sworn officers, would they be wearing a police uniform or some type of designation?
Yes, they all have,
Hold on. There's an objection. It's overruled. He may answer.
all personnel on the parade route are in uniforms. Additionally, everyone, it's part of our policy that they are required to wear traffic vests, which would have been a yellow and could have been blue and yellow or orange and yellow traffic vest that says police on it.
Okay. I'd like to go back to the area on White Rock where you were located, where the units were staging, correct?
Yes.
Now, can you describe for us where the road was actually shut off by police so that no motorist could actually travel down the road?
Sure. I mean, this actually further north than here, it's off the map, is where we had our first point of shutdown. It was at White Rock Avenue and Niagara Street. We used Niagara Street to divert any traffic that would have come that direction. So then along here, there would have been shut down at Niagara. There's another street called Perkins where it was shut down. And then right here is Baxter Street, where we had the street shut down. Additionally, here along the staging route, North Hartwell Avenue here was shut down on
As a
both
sergeant,
sides of it.
You'd
to ensure no
expect that he's
traffic entered into
been on the
staging
job
area
long
where
enough to
that
testify
space was
quite a
occupied.
bit.
All right, and before
I
I ever
think
sit
he's
down,
making a
there's
good
two other
witness.
areas designated on the map I'd like to ask you about. This is on
At the
the
very least, he's
left,
very well
upper left
spoken
quadrant of
as
the
a
map.
witness.
On the north side of the Fox River, there's something indicated as the Barstow Hill. Do you see that on the map, sir?
Yes, right here by the green line.
What's the Barstow Hill?
The Barstow Hill is just a very steep hill that more or less connects our downtown to a neighborhood, and
They have
there's
steep
a
hills in
thoroughfare of
Wisconsin.
traffic coming and going from the downtown area.
Okay, that's Barstow Road there?
Correct.
Okay. And then just to the right of that, there's something marked as a mobile gas station. Is that correct?
Yes.
Overruled.
And there is a gas station at that intersection, sir?
Yes, there is a mobile gas station at the bottom of the Barstow Hill.
Okay. All right, please have a seat, sir. Sending officers out to their locations along the route here.
At 1 p.m. is when the initial few officers head
First
out,
part of that
to
question
secure
cut
the
out.
staging area. So they're out there from 1 o'clock until about 3:30. Between 3 and 3:30 is when the rest of the personnel assigned to the parade would have arrived at their locations along the route.
All right. And I assume you're in some, Your Honor, we just lost part of the Polycom.
Well, we'll pause. It won't happen otherwise.
And
Good
we can
old technical
take that down for
difficulties.
Now, we don't need the state table displayed at the moment.
Mr. Brooks, we lost you for a second. As soon as we knew it was down, we stopped. We didn't take any additional testimony. I just want to confirm you can see and hear me.
Yeah, I can hear.
And you can
Wow,
see
a
the
direct
4 cameras,
answer.
So the witness as well.
Maybe pigs can
thank you.
fly.
Okay, so, there's somebody that's running the parade as far as lining up the participants and making sure everybody that's walking in the parade is where they're supposed to be, correct?
Correct.
Is there a title for that person?
Boy, I wouldn't know.
Your objection's noted. It's overruled. He may testify about the question asked.
Or is there somebody that you were dealing with directly that was kind of responsible for the units of the parade and you're responsible for the security of the parade?
Yes, there was
Overruled. He may answer.
there is a lady from the Chamber of Commerce who put on the parade.
Not
just
every
prior to the
yes,
parade
no
starting.
answer
I had a face-to-face contact
is
with her to inform
leading.
her that the route was ready for the parade.
Now, how do you know that? How do you know that the route was
Or at
ready to
least
go?
not
Between
Unacceptable leading.
3:30 and 4 o'clock, I had driven the route several times within the parade route on the street that was shut down. It was my duty as the incident commander of the parade to make sure that the officers or personnel assigned to the parade were all in their location, that all the barricades were in place, that there was no holes in the parade route that we missed in the planning, and as a final security sweep of the route just to ensure everything was in place as we had planned for it to be.
Can you estimate how many spectators were present?
Objection.
At what time? of
I'm
the-
sorry, at the start of the parade.
Thousands. Once the parade had started, I was not on the route anymore. I think the last time I drove the route itself would have been just before 4 o'clock as my final lap through.
Okay. And there's spectators on both sides of the road, north and south sides of Main Street,
Correct.
and all the way from Hartwell, all the way down to Veterans Park at the end there near Wisconsin Avenue.
Yes, I'd say the majority of this,
Oh, hold on, there's been an objection.
Go ahead. What's your objection?
That is hearsay. We
That's
can't know
not hearsay.
sure where everybody was at.
The objection is noted. It is overruled based upon the
The
foundation
sergeant's
previously laid by the witness. Go
describing
ahead.
what he
the
witnessed.
spectators are primarily from the intersection of White Rock and Main Street westbound.
So you were satisfied it was appropriately safe to start the parade, is that right, sir?
Yes.
What did you do?
I had face-to-face contact with the organizer of the parade. I indicated to her that I checked the route and from the police side of things that we were ready for the parade to proceed, and let her know that she could begin whenever she was ready.
About what time of day was that?
It was right about 4 p.m.
And you had mentioned the units were staging on White Rock near where you were posted, is that right?
Yes.
And did you see, as the units would enter the parade route, then they all kind of move forward, I'm assuming?
Yes,
Hearsay.
No.
Overruled.
the parade participants are set up on either side of White Rock Avenue, and they're kind of
Once again, a
funneled together into
hearsay is an
almost a zipper
out of
type
court
fashion,
statement
as they enter the parade route.
used to
And
prove
as
the truth of
they
the matter
march
asserted.
forward towards the parade route, then at some
His
point,
hearsay objections have
road
not been
behind them
about
vacant?
statements.
Correct.
and what
that's-
do you do
that's an
when that
important
happens?
We
Component.
try to cause as little disruption in the city. Shutting down White Rock Avenue, it's a very major thoroughfare in the city, and having it shut down for that extended period of time causes some pretty significant traffic problems. So as the road is no longer occupied by parade participants, we try to open up the road from behind them, keeping the back of the parade shut down. Always taking into account, a street for a car to turn off onto. So
Did you remain in that same position near White Rock and Hartwell?
yes,
And do you remember how you had your squad positioned?
Objection, that's hearsay.
No, it's not.
Overruled.
I had my squad
He
positioned
needs
across
to
White
go
Rock
back to
Avenue
his
in
cell
an
tonight and
east-west
read what
fashion,
hearsay is.
Essentially in the middle of the roadway. The road is much wider than the SUV squad I was driving is. I positioned it that way to give a visual representation to motorists that the road wasn't open.
And is your squad marked or unmarked?
It is unmarked.
Objection, irrelevant.
It's relevant. The answer may stand. Make sure if you hear an objection, sir, that you wait until I rule on it too. Thank you.
Are there red and
I
blue
mean, he
lights
had
on your
answered
squad cars?
before the objection.
Objection, irrelevant.
He's going to
Overruled.
object
The
to
answer may stand.
every single question.
Did you have your red and blue lights activated as it was parked across the roadway?
Objection, irrelevant.
Overruled.
Yes.
You remember hearing something about a disturbance near the boat launch?
Yes.
Objection, hearsay.
Are you offering it for the,
Foundational, Your Honor.
or it's not being offered for the truth of the matter asserted? The objection is overruled. He may answer. I believe he answered yes, and it makes.
This means it's
Alright.
not proving that there was a, or what the nature of
What do you remember hearing about an incident at the
the
boat
incident
launch?
was. Just
When I was
that
near my position
it's
on
showing he was
Hartwell
on
and White Rock,
notice
I was speaking
of
with one
an
of our
incident.
reserve officers. We were discussing the proper timing of the opening of the road. And I overheard actually on his police radio that he was wearing
But that was closer to a
squads that were not
proper
assigned to the
hearsay
parade
objection.
being sent to a fight at Frame Park.
I might have
that
even
involved
made it.
knives.
Were you
Understanding
aware
it
of any
would
vehicles
probably
being
be
associated
overruled.
with that fight?
Objection, irrelevant.
Overruled. He may answer.
I did not hear of any vehicles associated.
What do you remember next, sir?
I remember seeing and hearing squads responding to this this fight at Frame Park. And at that time, we were still focused on opening up the roadway, and I made my way back toward my unmarked police vehicle. And I looked to my right or to the north down White Rock Avenue, and I saw a red SUV traveling toward me at a high rate of speed.
What do you mean by a high rate of speed, sir?
Objection, that's hearsay.
No, it's not.
Overruled. He may answer.
I believe the vehicle was traveling in excess of 40 miles per hour.
What's the posted
His
speed limit
direct
there on White Rock Avenue?
observation.
It's a 25 mile per hour zone.
What about Main Street in downtown Waukesha? What's the posted speed limit there, sir?
The speed limit,
Objection, irrelevant.
Overruled. It's relevant.
the speed limit throughout the parade route is 25 miles per hour.
What did you do
And
when
he
you
was
saw
clocked
this,
at 32
red
and
SUV
33.
traveling at a high rate of speed?
Objection, leading the witness.
The objection is noted. It's overruled.
When I saw the red SUV traveling toward me at a high rate of speed, I used both hands and
Leading would have
overhead
been.
like this.
Did you do this?
Attempt to catch the attention of the driver.
But what did you do
Were
when you
dressed in
saw
police uniform, sir?
is not leading?
Yes.
And just put on the record when the witness, so that's clear, placed both hands over his head in what I would describe as a waving kind of back and forth at a diagonal gesture. Thank you. Go ahead.
Did the car
That's good
continue
on
in
the
your
judge's
direction,
part.
or the SUV?
Yes, it did.
What did you observe the path of travel for the SUV to be?
Objection, that's hearsay.
No.
Mr. Brooks, it's not
Stop.
hearsay. Your objection is overruled. You may answer.
Read
Could you
what
state the
hearsay
question one more time?
is.
Sure, where did you see the SUV go? Better question.
Objection, irrelevant.
Overruled.
Where the
The
SUV went
entered the parade route.
is the most
I
relevant
want you to
question.
describe what you remember seeing as it passed your location, please.
Objection.
As I was waving my hands overhead, I was approximately 6 feet.
That was sarcasm, by the way.
From where the SUV was driving.
I will tell you if I have real objections.
As the driver passed essentially in front of me by about 6 feet, I could see the operator of the vehicle and just a dazed, straight, focused look straight ahead, not looking at anyone.
Did the driver appear to respond to your efforts to stop the vehicle?
There was absolutely no response.
Did you notice the
Now
car
ask-
slow down in any fashion?
Can you identify
No,
the
in
driver?
fact-
Hearsay.
It's not hearsay. It's overruled. He may answer.
As the SUV passed me, I looked over the hood of, or the top of the
This
police
cross-examination is
vehicle
going
that
to
I
be a
had
mess.
positioned on the road there, fully expecting that as it passed, that I would see the car slam on its brakes as it realized it had entered the parade route, figuring it was a lost motorist. I didn't see that happen. It continued into the parade route at a high rate of speed.
What did you do?
Upon seeing that, I got on my radio in an attempt to notify other personnel assigned to the parade route. I stated that a red SUV had just blown by me.
Do you remember using those exact words, sir?
Objection, that's irrelevant.
No, it's
Overruled.
not.
He may answer.
I don't know if I said a red or maroon SUV, but I remember saying that it had blown by me.
It's relevant because he's put other people on notice of what's happened.
Were there parade units still on White Rock attempting to get onto the parade route at that point?
Yes.
Objection.
Were you able to see the vehicle clearly as it
Hold on,
went?
He brought
I'm
the
sorry.
objection after the
Objected, it's
answer.
overruled. Go ahead.
Not that it
From
wouldn't
where
have
you
been
were standing
overruled
there,
anyway,
were
but
you able to turn and watch
you need
the
to bring your
SUV as it
objections
traveled
in a
past you
timely
down
manner.
White Rock
It's
towards Main
waived if
Street?
the question's answered already.
Overruled.
Just ask that.
I only watched it for a short period of time before returning to my squad car, knowing that some sort of police action was going to need to be taken.
What did you do once you got to your squad?
I got in my squad car. It was bombarded with the most terrible.
This is hard. Like I said, even those who were not physically harmed are victims. You can't charge a crime for the victimization of the sergeant, but he's a victim. This was probably the most traumatic event of his life. But
It's the most terrible thing I ever heard.
But it's probably not
Sounds.
relevant,
Yes.
says Mr. Brooks.
You didn't see anything at that point as far as people getting hit?
No.
I want to show you a video clip, sir. This is State's Exhibit number 2. Madam Clerk, if you could please turn on the State's table. Yep, I'll tell you. Okay.
Just show it to the witness.
I'll show it to you first. So Sergeant Warner, if you look at the screen in front of you, we're gonna play a video clip. It's pretty short.
This
in
is laying the
duration.
foundation
I want you to watch it first.
in order
before we
to
show it to the jury. I'm gonna
get
ask you
the
some
video
questions.
admitted.
Okay.
Did you see that clip, sir?
Yes,
Is that a video clip you've seen before?
I have seen that. Yes.
Okay. Do you believe that's a true and accurate representation of the SUV traveling on White Rock Avenue?
I don't know if we're going to
near
see
the
this on
start of the
our
parade at Main Street?
screens
Move for admission and permission.
or
to
what it
admission.
is specifically, but this might be a good time for a trigger
Any
warning.
objection, Mr. Brooks?
This could be
Can you repeat that?
bad.
I'm sorry.
The state just moved admission of Exhibit 2.
No, I object to that. Keep it.
All right. The
Object.
objection's noted. It's
Keep it.
overruled. Exhibit 2,
That's-
ladies and gentlemen of the
That's
jury.
a
is
new
received.
objection to me.
Permission to publish is granted.
Keep it.
Thank you. Please hit play. Sergeant Warner, is that consistent with the vehicle you saw traveling away from you past the parade floats that were about to enter the route?
Yes.
And is that consistent with the approximate speed you saw it traveling?
Sounds
Yes.
like it's not in the crowd yet.
After you became aware that something terrible was happening on the parade route, your incident commander, what do you do?
I drove in my police vehicle down toward the area that I just heard repeated over and over on the radio where the casualties had taken place. And that would have been at Main and Gaspar. And once I got to that position, I parked my vehicle as it was impossible to drive any further.
Was there a call made for assistance?
Yes, I don't know who said it, but an officer used a code over the police radio, basically requesting police assistance from any officer in the county that would be listening.
Main and
Did
Gaspar is
multiple officers
right
respond?
there at the beginning
Yes.
of the
From within
parade,
Waukesha County?
right after the staging area.
Overruled.
Waukesha County and far beyond.
Thank you, sir. I don't have any other questions at this time.
Mr. Brooks, do you have any questions for this witness?
But I hope the cross-examination's gentle.
Good afternoon, officer. First off,
Good afternoon.
I say this is very emotional, so I'm gonna try my best not to keep you up there any longer than
I
you
wouldn't
would
have
like
brought
to
that
be.
up if I were him.
My first question is, I noticed that you are in uniform today. Is it fair to say that if you weren't here testifying, that you would have been on duty today? Is it fair to ask that or say that?
I
have been
don't
at
see
work
the
today.
relevance of.
So did you feel the testimony that you would be given at trial today warranted you to be in uniform?
Objection, relevance, Your Honor.
Sustained.
He's on the
You
job.
do not need to answer that, sir.
He's on the job.
Next question, Mr. Brooks.
On the job. He wears his uniform.
You said you've been in duty for 18 years, correct?
Yes.
So if he's taking his daughter on a college visit
In any
today,
of those 18 years,
he started when she
have
was
you
an
ever,
infant.
come across or had any interaction with the plaintiff in this matter?
Objection,
It's
vague.
it.
Sustained. You do not need to answer that, sir.
I mean, he has at the
Next question,
parade.
Mr. Brooks.
How long have you known the plaintiff?
Objection.
Oh,
Vague
wait.
and
The
irrelevant.
plaintiff.
Sustained. You do not need to answer that, sir.
The
Next
plaintiff
question,
is the
Mr.
state of
Brooks.
Wisconsin.
Do you see the plaintiff in court today?
This is sovereign
Vague
citizen
and irrelevant.
nonsense.
Next question.
Do you have any knowledge of the plaintiff?
Objection.
Sustained.
He's going to ask this of every single
Have you ever even seen
witness.
the plaintiff in this matter?
Same
objection.
objection.
Sustained.
I want to go to the clip that was just shown.
He's not
Like,
doing
shown
himself
to the
any
witness
favors.
again and published to the jury.
I'm sure would he prefer for it to be so again?
I just wanted to know if that's what you were asking. You can certainly question him about it, and if need be, it can be shown again.
Okay, can you show the witness the video?
Not
clip?
just the witness. You're showing the jury.
All right, I can tell from my monitor and the witness monitor, it is up, but it's not being projected to the courtroom other than that. And you can go ahead and play it.
All right, your question, sir.
In that clip, is it fair to say that you can see that there are people walking in the street and on the sidewalk? Would that be fair to say?
That tends to happen at parades.
Yes, I could see that in the video clip.
Do
You still
see
have a
anybody
duty
being
not to
targeted
hit those
or
people.
being in a panic to get away from the vehicle?
No.
That was before you entered the parade
Do you
route.
see the said driver of that vehicle intentionally trying to hit anyone in that video?
That's a
No.
factual conclusion. That's for the jury to decide.
So again, I would ask
The sergeant doesn't determine intent.
were you brought here today to testify on behalf of the plaintiff?
Objection has been answered.
Sustained. He already answered that he was, why he's here.
Again, I'll ask just one more time for the record. Do
Again,
you see the
asked
plaintiff
and
in court
answered.
today?
Objection.
Sustained. Do you have any other questions, Mr. Brooks?
Do you know of the plaintiff at all whatsoever?
Objection.
Sustained.
This is
No further questions.
All right,
sovereign
thank you.
citizen
Please redirect.
abuse.
No.
All right, thank you, Sergeant. You may step down. Is he released from his subpoena?
Yes,
At least it
please.
was
All right,
short.
thank you. He's released.
Really quick on the record, if I may.
But I think this
We're
has
gonna call the next witness.
set a precedence for how the trial is going to go.
Do you have we have the jury in the courtroom. Do you have a question, sir?
I will have
I wouldn't.
oral tennis motion I would like to be put on the record.
A tennis motion.
If you have a motion, you'll have to wait until after the next witness is called. Write it down, submit it on paper, and I'll review whether it's appropriate for this court to address. All right, the state may call the next witness.
The state calls Corey Runkle.
All right. Good afternoon, Ms. Runkle. If you would please make your way to the witness stand. When you get there, please remain standing. Raise your right hand. My clerk, Teresa.
I'm going to
will swear you
mention
in.
until
Is the
this
mat
year,
to
I
stay up
had
at
never
this point?
heard the surname Runkle,
It doesn't need to, it also doesn't need to come.
but this is the second person I've
Well, I
heard
just,
of this
use,
year with the surname.
over here.
The first, of course, being Ian Runkle from the YouTube channel Runkle of the Bailey, a Canadian lawyer who does pretty good work.
All right, and my clerk Teresa's over here. If you would raise your right hand, she'll swear you in.
Do you solemnly swear?
You've
that
gotta
the
love the
testimony you're
Third
about to give
Amendment
shall be the truth,
audits.
The whole truth and nothing but the truth, so help you God? I solemnly swear.
Thank you, ma'am. Please have a seat. We'll get that settled. And then the first thing I will ask you to do, excuse me, is to state
You've been quiet
and
for a
spell
while,
your
John.
first and
Were-
last names for the record.
did you hear the opening?
My name is Corey Runkle, and it's spelled Kori.
And if you did,
Run.
did you find it as
Thank you. Go ahead.
powerful and
Thank you.
just
Good
difficult
afternoon,
as
Ms.
I did?
Runkle. Do you know a person named Erica Patterson?
Yes,
How do you know that person?
from the shelter,
What shelter are you talking about?
women's shelter,
What city is the women's shelter in?
Waukesha.
And when did you meet Erica Patterson?
She's definitely not as practiced a witness as the sergeant
October, I
was.
think.
You are
Which
not
is not
used
a
to
criticism.
testifying in court, right?
Not really.
I'm going to ask you to scoot a little bit forward.
Why
The
don't
nice
you
lady in
take
front of
that
you is,
Microphone a little bit, a little closer. I think that'll help.
we just have to make sure that everybody can hear, especially the court reporter in front of you, because she's writing everything down. okay?
That's one word
Okay.
for it.
So can you
I
answer,
felt
when did you meet
Sick
Erica
to my
Patterson?
stomach,
Either October or November.
Ju- close
Of
to
what year?
tears. It was bad.
21 this year.
2021?
Yeah.
Okay.
That was last year.
Did you meet her at the women's shelter that you're
Yeah.
talking about? Okay. What was your living arrangements at the shelter?
Okay, it wasn't this year. It was last year, I think.
2021.
Yeah.
And what were your living arrangements at the women's shelter?
We were bunking together.
You and Erica?
Yeah.
While you were bunking together with Erica at the women's shelter, did Erica ever talk about a boyfriend of hers?
I think I'm understanding
It
why
wasn't her
the
boyfriend.
prosecutor wanted to get her
Okay.
in
Did she ever talk
today,
about a man?
talking
Yeah.
about
And
her
what-
ride,
Did she ever provide the name of that man?
Yeah.
because I'm
What was it?
assuming
Darrell
it's kind of a
Brooks.
big deal
Okay.
for her.
Were you with
Transportation.
Erica on the afternoon of November 21st,
Or
2021?
access to transportation.
Yes, until I split up with her.
Okay. Can you tell us where you were with Erica before you split up with her?
I forgot what park it was, but we were at like the park where the dragonfly was, except for we were at the docks.
Is that in Waukesha?
Yeah,
And the docks, are you talking about a river?
yeah.
So the park by the river?
The
Yeah.
only
Yeah.
defense
What were you
is
doing with
lack of
Erica in the
intent,
park?
which
Hanging
is
out.
going to be difficult.
Was anybody with you?
Yeah.
But it's the difference
Kyle.
between manslaughter and murder.
And you mentioned that you split up with Erica at some point. Is
Because
that right?
identification is a
remember
slam
why?
dunk.
To go hang out with Nick.
They know it was him.
Do you know Nick's last name?
Kirby.
Erica didn't go with you.
But negligence versus
So what happened after you split up with Erica?
willful disregard
She met
or
up with Darrell
specific
that?
intent
because she was on the phone with him and
is still
they
at
said
issue.
that they were going to meet up.
Now, before that day, November 21st, had you ever met Darrell Brooks?
No.
You'd only heard his name from Erica?
Yeah.
Oh, so this is
After you split up,
her
with
friend
Erica
is
and she
the
went to hang out with Darrell.
ex-girlfriend.
did Erica ever contact you or Nick after that point?
Yeah.
How did that contact take place? Was it, again, did she like see you or did she call you? How
No,
did that
she
happen?
called me on my cell phone.
And what was the nature of that conversation?
That he was beating her up and he was following her.
That's not hearsay
Okay.
because it's
What
not.
did you do when you learned this
What-
information from
It's
Erica?
not
Uh,
her words.
me
It's
and Nick
what the
started
nature
running
of the
on to where
conversation
she
was.
told us she was
Where was that?
by the school. I
Okay.
forgot what school it was, but it was by the school.
Did you find her?
Yeah.
Do you remember where you found her?
Right in front of the school.
I
Do
wonder
you
if he's
remember what was
less
happening when you
combative
found her?
Uh,
as far as objections
was
because
swerving
she's not
into
a
her.
police officer.
When you say he, who are you talking
oh,
about?
Darrell.
Darrell, the person?
Yeah.
Okay. Did you hear Darrell saying anything to Erica at that time?
He was yelling at her to get back in the car.
Did she?
No. She tried, but I pulled her away.
Good.
Before you testified today, you reviewed a couple of surveillance videos. Is that right?
Yeah.
That's a hero.
No, not today, but a while ago.
A while ago.
That's a
Okay.
hero. Pulling her
I'd
away.
like to put Exhibit 3 up on the screen for the witness for identification.
It takes bravery. She may not be the best witness. At least as far as she may not be the best at testifying, which is a skill. I'm not criticizing her at all. She may not be the best witness, but she's a good person. A good friend.
So, Ms. Runkle, we're going to play a few moments from this video. I want you to watch and see if it's the same video that you've reviewed previously. Okay, so we're just going to play about 10 seconds here.
Once again, authenticating the display so that it
I
can be
could just tell
admitted.
that's her walking up.
Okay, let's pause there. So you viewed this video. Is it an accurate depiction of how the events unfolded in front of the school you're talking about?
Yeah.
I move Exhibit 3 into evidence and ask to publish.
Any objection, Mr. Brooks?
Yeah,
Of course.
my objection would be, you've only played 5 seconds of the video, whereas the other 5, you just said 10 seconds that you would
But
play. I'm curious
they're
to see the rest of the
authenticating.
video.
Your objection is noted. It's overruled. This is for foundation to establish it's what the witness is going to testify about. She's testified.
And then they'll play
it's a
it
fair and
for the
accurate
jury
depiction of
to
what
show the
the
whole
events
clip.
that unfolded in her presence. And
She just needed to
will
identify
receive
it.
Exhibit 3. Permission to publish is granted.
All right, we're going to hit play from the beginning.
Oh, they are showing this one.
There's his car.
Let's hit a pause.
Okay.
Wait for his
Let's hit
questions.
pause. We're at 16 seconds. We saw a person wearing a blue shirt walking
You're not
from the left. Do
testifying
you know
in
who that person
narrative.
is?
Erica.
Erica Patterson.
Yeah.
And when you said there's his car, what car?
Once
were you
again,
referring
not
to?
criticizing
The
And
SUV.
do you know
at
who was
all.
driving that car?
Darrell.
Darrell Brooks?
Yeah.
Okay. And again, this would have been the first time you ever saw Darrell Brooks, is that
Yeah.
correct? Okay. We're going to resume from that point, but wait until I pause again to speak again, okay?
I'm sorry.
That's okay. So we'll play from 16
Testifying is not natural. It's an art. If anything, it's on the prosecutors. It's their job, or a victim coordinator, witness coordinator, to not coach on what they should testify about, but on the mechanics of testifying. But once again, I think she's doing a fine job. It's a difficult thing to do. She's doing a fine job. And this youngest prosecutor, the 7 years experience, is doing a good job too. Let me say again, I really thought he did a good job on his opening. He's an absolute rock star. I've seen some of that. That I think that was more on SVU that I saw it. Of course, the way it was portrayed, there was one case at a time, and they held their hand through it in a very protracted manner. But I think that was one of the less problematic aspects of the show as far as realism. And it's such an important thing. Here in Utah, there was a horrific shooting that happened.
Let's pause there.
Right before I entered
Pause
high
at 2 minutes
school.
and 44 seconds. During that clip, we
One
saw the
person
A-red
killed
SUV
another
towards the top of
person
the screen. Is that right?
grievously
And
wounded.
did you recognize
And she
that vehicle?
became an attorney.
Yeah, that was Darrell's.
And she
Okay.
was the
We
witness
see now at this
coordinator,
stoppage
the
point,
victim
we can see
coordinator,
2 people on the upper right-hand
when I
corner.
was
Do you know
doing
who
my
those people are?
internship at the U.S.
Me and
Attorney's
Nick.
Office.
Do you know which one you are?
Just a remarkable
The
person.
one with the green gloves.
So left or right?
I
Or
think
50
As we're
cases
the one
at
up in
once.
front.
And then there's a person with a white hood. Do you know
Yeah,
who that is?
that's Nick.
Okay, so you're the other one on the left?
Yeah,
All right. And you saw Erica?
yeah.
All right, let's resume playing at 2 minutes and 44 seconds.
Oops. Meant to hit mute, but hit the camera button. Looks like some commotion.
Let's pause there. Pause to 3 minutes and 19 seconds. Who's the person in the gray hooded sweatshirt?
That's Darrell.
The objections overruled.
It really does depend on what
Right,
types
let me
of
stand.
cases,
That's Darrell.
because this case
How far
is
away would you say
worth
your
1,000
face was from Darrell's face at this point in the video?
speeding
I was chesting up.
cases.
Chesting up. So
Yeah.
I guess that's pretty self-explanatory. Do you see Darrell Brooks?
Which is
either in the
also
courtroom
me
or on
giving
any
a far too
monitors
low
in the
number.
courtroom right now?
Yeah.
Your Honor, and actually for this point, I would ask that the court order the defendant to remove his mask.
Mr. Brooks, your order to remove your mask.
That's to identify him. Positive ID.
No, I'm not gonna do that.
Mr. Brooks, we talked about this at a prior hearing. For purposes of identification, your order to unmask.
Thank you, sir.
Oh, put it back
So
on.
now
Put
I'll
it back
re-ask that
on.
Question. Mr. Uncle, do you see Darrell, the person you're talking about in the video?
You can tell it's
either in the
getting later
courtroom
in
or
the
on a
day,
monitor in
but
the courtroom?
Yes.
Can you
the
tell
sun's
us where?
getting low
Uh,
out that window right behind my screen.
in orange.
On the monitor in front of you?
Yeah.
I'd ask the record to reflect that the witnesses identified the defendant.
The record will so reflect.
Ooh, that looks
Thank you,
menacing.
Mr. Brooks, you can remask.
Let's hit play and resume
was
at 3 minutes and 19
mad.
seconds.
Can't believe the homeowner or business owner or whoever didn't have the courtesy to frame the camera where this would occur. I mean, they didn't have any foresight whatsoever.
All right, we've reached the end. Mr. Uncle, can you tell us what was happening in that last portion of the video we just watched?
That's almost the end of her
Well,
direct, I'm guessing.
Erica, me, and Nick showed up in the camera, that's when I ran after Erica from getting ran over, and then she tried to jump in the car with him. And then I ended up chesting up to him. And then we ended up,
I don't know. I
Alright.
could have done that.
so yeah,
How would you describe the level of your volume during that interaction?
like, what do you mean?
Were you yelling?
I'd say yeah,
Was Mr. Brooks yelling?
yeah.
Was anybody else
I
in,
can't
in that
imagine
video,
him
either Nick or
yelling.
Erica, were they yelling?
Erica was telling me to stop.
Okay. And what happened after the physical confrontation with Mr. Brooks?
Nick pulled me away,
And then what happened?
and then Brooks walked off
Did you see where he went?
into his car.
The red SUV in the video we
Yeah.
just watched? Was there anybody
Wait-
else in the
wait
SUV
for
at
him
that
to
point that you
finish.
saw?
No.
And what happened next?
Again, no criticism.
After that, it was like he headed out.
Okay. Did Mr. Brooks say anything to you or Erica or Nick as he was leaving?
He told Erica he was. Oh,
The basis for your objection, you said objection, right?
Is hearsay and irrelevant.
Nope.
Is it being offered for the truth of the matter asserted? From the
Well, it's
state?
a statement by a party opponent, so it's not hearsay.
Oh, it's his statement, sorry. I think I misheard what she said. All right. The objection is overruled. If it's, she may testify as to.
All
words
of
that you
his statements can
spoke
come
on
in.
this occasion. Go ahead.
he told Erica that he was gonna find her and he's gonna kill her.
The rules of hearsay, there's multiple pages. And there's
Could we pull up
things that are
transcript
hearsay
files of witness
exceptions,
statements?
and then things that you'd think are hearsay that it says this is not hearsay. So not an exception, it's just not hearsay. I can't remember what a statement of a party opponent is, whether it's not hearsay or an exception. Although they're
Okay, so while we're
functionally
waiting
the
on
same.
Did you at any point come into contact with police or a police officer after Mr. Brooks left the scene that we just watched?
I forgot what that guy was at, the little stoppers, like where it stopped everybody. But we came into contact
Barricades?
with him, and then he called the police officer, and then we had contact with the police officer.
Okay. At any point while Mr. Brooks was still present for the scuffle, did you or anybody else in your group call the police?
No.
You need to turn on the state table, please, for preview mode.
I will confirm it's in front of mine and the witnesses monitor or on our monitor.
All right.
All right, Ms. Runkle, I'm
An
showing you on
opposing
your
party
monitor a
statement
photograph
is
that's been marked as State Exhibit
specifically
number 5.
not
Do you
hearsay.
recognize that photograph?
So it's not an acceptance.
Yes.
It's
Who's in that
not
photograph?
hearsay.
Erica?
Erica Patterson? Is that an accurate representation of how Erica looked the night of November 21st?
Assuming it
so
meets
after the Waukesha Christmas parade?
Yes.
certain
Move
other
Exhibit 5
conditions.
into evidence and ask to publish.
Any objection?
Yep, on the grounds of, that is hearsay.
The objection's noted. It's overruled. Exhibit 5 is received. Permission. to
I
publish
really
is
hope he
granted.
reads what hearsay is tonight. This is going to get tedious.
Were you with Erica Patterson the day before the parade, so November 20th?
Yes.
Did she have a swollen left eye on November 20th?
No.
Showing it was made
I want to go back to
on
the
the
issue
day of the
uh,
parade.
police and whether or not you had contact with them. Can you describe in a little bit more detail what exactly happened with law enforcement after the defendant left the scene that we just watched?
I'm not sure where we walked, but like I think we walked straight down to the parade. I'm not sure, but we stopped at these like stoppers where there was this I don't know what he's called. It's not a cop, but he was like a guard, and we ended up telling him that what happened, that
The
Erica
word of the
almost got
day is
ran over.
objection.
I had to pull him.
I'm not going to do the Pee
pull
Wee
her away
Herman
from
thing,
the
though.
car. And he ended up calling the cops. He told us, hold on, let me call the cops. And a cop came and we started talking to him.
Okay, but you don't, or do you remember the name of the officer that you spoke with?
I do not.
It's probably not important. Although I'm sure the prosecutor knows and
That's all the
will
questions I
possibly
have for
be
this
calling
witness.
him.
All right, Mr. Brooks, do you have any questions for this witness?
I sure do. So, my first question would be, you seem to be unclear about when you met Erica. Would you
That's not super.
say it was roughly October
relevant.
or November because you wasn't sure which one?
Roughly in between.
Roughly in between.
Yeah.
So October?
I know it was
So-
before Christmas.
Do you,
The important part is, did she know her?
well,
On
you
the
just
day
said
of
that
the
you had
incident.
never seen her quote unquote boyfriend or whoever she was referring to as that before the Christmas parade. Is that correct?
The Christmas parade was November, right?
He's asking you if you had seen.
Not before, but the Christmas parade was November. I'm just asking, right? Okay, so no.
Did she, do you want her to restate her answer? She answered, she confirmed your question.
I wanted to be direct.
Okay, no, I have not.
So you just testified that you can identify who was driving the said vehicle as soon as you saw the video played. If you've never seen
She can
the driver
identify
before that day,
that it
how
was
would you even know
you.
who it was?
That's the important part.
I'll object. That is not a clear question. This is just going to confuse the witness. It's confused me.
It's,
Also stated, Mr. Brooks, rephrase the question, please.
he's not doing himself any
Uh,
favors here.
Would you play the video again, the first 10 seconds? I'm guessing that it was.
Exhibit 3.
Exhibit 3. You want us to look, you want the first 10 seconds? of
Well, I
the
won't
video?
criticize her for not being the perfect witness.
Witness. the
I
first
will
couple of
criticize
seconds
him
of the
as an attorney,
All right, it's up.
since he chose to be an attorney. She was subpoenaed.
Now, you just said, you just testified.
Hold on, it's playing. You want it to stop now?
Stop.
Okay,
You
Play the
just,
first 13 seconds for the witness.
thank you.
you just testified that as soon as you saw the vehicle come into the camera view, you said, "Oh, there's his car." How would you know
She would
whose
know
car it
that
was
it's
if
the
you've never
car
seen this
she
person
saw,
before that day?
and that she saw you get out of the car and try to drag
Yeah.
Go ahead and answer.
your girlfriend into the car, and then got
Because
in
I was
the
told
car
that
and
she was
drove
going to
off.
meet up with Darrell Brooks.
She saw you.
So you were told this
She saw
directly from Erica.
you.
Yes.
Did at any time she ever tell you what kind of car he had and what kind of car he would be meeting up with her
She
with? quote
saw
unquote?
you get
No.
out of the car.
So how can you identify that it was the said person's car
Because
if
she
you
saw
had no knowledge of
you.
what vehicle this said person would be driving, or who the person even was, or who what the person even looked like? How would you know?
Because I was told it was Darrell Brooks.
And so you were told that it was this name.
This is only whether or
but you
not
were
it's your
able to
name, which
identify the vehicle
you're
and
going
the person
into
on
the sovereign
first day
citizen.
that you
Well,
ever saw.
I'm me, but I'm not my
That's
name. So
answered.
that Darrell Brooks that did that, that's not
Let him
me,
finish his
even
question.
though I'm the one she saw get out of the car.
Again, as soon as the car came into camera
If he
view,
says
he's
again,
immediately said
I'm going to
on
just
the
say,
record,
objection,
just a few minutes
asked
ago,
and
"Oh,
answered.
there's his car." Who was who is his? Who were you referring to?
Darrell
Yours.
Brooks.
And you would be able to know that that was quote unquote Darrell Brooks just by seeing the car come into the view of the camera?
Now I'll object based on an asked and answered question.
Sustained. Mr. Brooks, are you trying to ask her whether at the moment in time she first saw the SUV, did she know who was driving? That would be a
Which-
relevant question.
It would
Did
be
you know who
relevant,
was driving the
potentially,
SUV that
but
you
it's
saw
inconsequential.
when you saw it?
Not in court, but when you first saw it on that
It's
date.
inconsequential.
Yes, because I
'Cause
don't see
what-
why Erica would be talking
what
to
happened
anybody
was-
else and getting yelled at.
What's
like
relevant
that.
is
But
what
did you
happened
know
after
at
the
that
car
moment
pulled
who
up.
was driving the car?
Yes.
And how would you know that? You just said that you had no knowledge of the vehicle that whoever Erica was meeting up with would be driving. So how would you know that?
Objection asked and answered and argumentative.
Her answer previously, Mr. Brooks, was she's basing that on what someone told her, not based on what she saw at that point. That's at least how I took it.
So Erica
He-
told you the vehicle and how the vehicle
This
was
really is cringeworthy. This is not endearing him to the
Understand the
jury,
Say that again.
and I'm sure they can see how,
Mr. Brooks?
Erica.
whether or
Well,
not
I'm
she
sorry.
knew
No, that's okay.
it was
State
going
your
to be
question,
him
sir.
pulling up,
So
or which car he would be
let's back
pulling
up a
up
little
in,
bit.
is irrelevant.
Erica told you that she
it's
was meeting up
inconsequential.
with this Darrell Brooks correct?
She
That's what you
saw-
said, right?
Correct.
She can identify that it was
And
you
did she
that
at
did
any
the
time
act.
tell you what vehicle this person would be driving and how the vehicle looked?
That doesn't matter.
She did not.
So the first time you saw the vehicle, did you know who was driving the vehicle?
Yes, when she told me. When she told
What
me,
he's asking you though, is did you know based on personal observation,
oh no,
not
not
based on what
personal
someone told you?
observation.
Of course,
Wait,
he could
wait,
be
wait.
more clear in his
So
question.
personal observation. Oh no, never mind. Okay, yeah.
It's almost
Let's
like
just
the
make sure the
judge
record's clear what your
has been
answer
an
is.
attorney and knows how to
It's based
question a
on
witness.
what I was told when I met her up with her.
So it was told.
If she's
That's
told
established.
Darrell Brooks is going to
Established what was
be
told. So next
coming,
question.
and then someone pulls
I
up
was going
and
to
gets
a
out of the
different
car and
question. I
assaults
didn't
her
get to it.
and tries to drag her into the car and gets back into the car and drives away. That's what
So,
matters. That's
You were
what she's
told
testifying
after
about.
the vehicle drove away and you and Erica were alone? Is that when you were told?
He is so aggravating.
Yes.
So it'd be fair to say that before you were told this, after the vehicle drove away, you did not know who was driving the vehicle, correct?
Except
Is
she
that fair
can
to say?
positively identify you. Your
Oh, I
name
had a
didn't matter.
suspicion
She can
it was
identify
Darrell.
You
you.
had a suspicion or did you know?
She can
I had a
identify
suspicion.
the
Until I
face
asked
she
her.
saw.
Objection. Argumentative.
Yeah, so we've kind of been a little bit circular here, so the objection is sustained. I think we need to be clear, Mr. Brooks, when you ask your questions about what point in time. It's one thing to talk about when she first sees the vehicle because there's been no contact between her and the vehicle, but it's a different point in time when it's later. So you need to make clear
I
at what point
really,
in time you're referring
really
to so that your
dislike
question
Mr.
is
Brooks.
clear.
Got you. You,
And when I refer
Identify
to him as Mr. Brooks,
the,
sometimes
Allegedly
I would
Brooks.
refer to someone as Mr.
Be
or
fair to
Mrs.
say.
or Ms. out of
Yes.
respect. With
and
him, it's because I have no
the
respect.
alleged defendant that you identified was the same
It's with absolute
person that you
contempt.
saw driving the vehicle that day.
Yes.
The video also
If I'm
shows
prosecuting, I get up for redirect
that,
and I ask,
well, let me back up.
you didn't know
Matter
the
of fact,
name
let
of
me
the
ask you
person who
different.
pulled up
You
beforehand.
made reference to hanging out
But,
with Erica in a park,
and
correct?
she'd say no.
Yes.
With maybe one other person
Second question,
Yeah.
present?
can you identify
Yes.
the face of the person you
Um,
saw?
Hanging
Get
out,
out of
what
the
were
car.
you guys actually
Yes.
doing?
It's him. Although she
Thinking?
already did in the direct,
So
so it doesn't
would
matter.
it be
But
fair to say that because of alcohol being involved, that there may have been a misinterpretation of what you saw? Or
No.
what you thought you saw?
Objection calls for speculation.
The question, the way it's asked, calls for speculation. If you could please rephrase it.
Oh, I actually different.
were you
How-
drunk enough
how-
that you wouldn't recognize? No.
How much were you drinking? Was it a few
Okay, that's a
beers,
compound
a
question.
bottle,
How much were you drinking?
Half a
something to that
pint.
effect? Half a pint.
You
Do you
can't ask
remember what you were drinking?
multi-part questions.
Vodka.
Do you remember if Erica was drinking?
She was.
And you said that
This
you
is getting
separated at one
into
point to go hang with another person. I
Impeachment.
can't remember the name, but would that be fair to say that you separated from Erica to go hang out with another person?
I did say that.
This has been a
Was
little
that
bit better
person
on
also
Brooks's
drinking
part.
that day?
No.
Did that person overhear any conversation between you and Erica?
How would she know?
No.
That calls for speculation.
Would that be the same person that was saw in the video?
Unless
Yes.
was that
would
person
be-
present for any of your conversations? But did that person hear? She doesn't know what that person heard.
Is that fair to say?
Yes.
And is it true that you did give a statement about what you saw and heard that day?
Yes.
Fair to say?
Oh, is he
would it
going to
be fair
read
to
her
say that
statement?
in this statement that you gave,
Ask her about parts of her
you never
statement?
mentioned the person that you saw driving make any threats? Would that be fair to say?
Did she testify about threats?
I never mentioned.
Well, I have the.
I
the
didn't hear
statement
her
right here in
testify
front of me.
about threats. Just
Would it be fair to say that the statement that you gave that day,
that he tried to get her
that you
into
did
the
not say
SUV
in your
angrily,
statement that you heard any threats being made or
to paraphrase
yelled
it?
towards Erica? Would that be fair to say?
Possibly.
She probably doesn't remember
So do
her
you remember
exact statement, what
giving a
is or
statement?
isn't in it.
I remember giving a statement.
Do you remember what you said in your statement?
I do.
I
So I'm gonna
I
ask you again, 'cause I
respond
just asked.
generally,
I have your statement in front of me.
and she doesn't have
did
her
not
statement
mention-
in front of her.
Any threats being yelled or made towards Erica? Would that be fair to say?
I did mention some.
What exactly did you mention?
That you were yelling at her,
That's not a threat, though.
saying that you were gonna
To be fair,
kill her and to get in
that's
the
a threat.
car.
And that's in your statement.
Yes.
Would you like me to read your statement to you?
Yes.
You sure?
Yeah, sure.
So I'll object based on the procedure that the defendant is employing at this point.
Sure.
Argumentative,
Mr. Brooks,
too.
there is a procedure. I can have the state bring up her statement, I hope electronically, to show her. It would,
That would
and
be
then
fine, Your Honor.
all right.
Bring it up for her to see.
you'll want to direct her to what part. You can ask her to review it, ask her if that refreshes her recollection, and then you can ask her a question.
And once
Or you
again,
can show her
even if she
that
doesn't
and
have
ask a direct
a
question about it would be
specific
another way.
mention of
Okay, this is
a
not it.
threat in the
No,
statement,
they'll get it up. It just takes a moment.
that doesn't mean it
Okay, I'm sorry.
didn't happen. Although it's up to the jury to decide who they believe. But sometimes in the heat of the moment, and giving a statement is in the heat of the moment compared to testifying on the stand 11 months later.
So are we sure we can't get the front? Because we tested that.
It's
It should have worked. We sure we can't get the front table?
It's been a long day. I'm losing my train of thought.
I have it selected
But
right now, and
it not being in her statement doesn't mean it didn't happen. Because
No.
unless it's caught on camera, she can't give a complete reenactment of the event as her statement. It's just not going to happen. And I'm sure the jury understands that. Good old technical difficulties.
We have a lot of new technology in this courtroom, and it's great when it works. But it's a lot to get used to.
Sometimes a good old paper copy is
Actually,
nice.
Are we still on the record right now, or we are?
You're on the
Yeah,
record
we just had that
until
stretch break, but we're still on the record why they.
Okay, I was gonna say something to the bailiff and I didn't want to be disrespectful by.
Do you want me to mute you for a second so you can?
Oh,
say
no,
something?
no, it's fine, it's
Okay.
fine. When will I be allowed to come back into the court so I can see everything?
You have earned your right to come back, sir. I mean, I can bring you back if you want to finish your questioning here.
I do.
All right, we'll take a short break for you to do that. All right, I'll have to excuse the jury for a moment. We'll be in recess as far as the cameras are concerned.
What are the bets? Is he going to behave? Although I guess the floor is his to share with the witness at the moment. So when he's cross-examining, it's a little harder to accuse him of misbehavior. Although I'm sure he could still accomplish it. Him behaving is the baseline for surprise. Misbehavior is not. Misbehavior is the expectation. Which is unfortunate, but I think there's a reason why he's facing eternity in prison, and I believe part of the background I read, he's faced criminal charges something like 16 times over the last 22 or 23 years. And I'm a forgiving person. At some point, you have to say enough is enough. I don't know the breakdown of those 16 charges. How many are felonies? How many are misdemeanors? How many are traffic tickets? But it's not hard to behave. I mean, I'm 38 years old. I had a speeding ticket at 16. Since then, I've been pulled over twice for equipment violations. Warnings. It's not hard to behave. And it's like I'm not a perfect driver. I speed a little. I try to keep it reasonable and within what traffic is doing. But in the course of 22 years being pulled over 3 times, ticketed once, it I just I don't understand 16 criminal incidents over the course of 23 years. It, it just does not make any sense to me. But it definitely is understandable that he's just pathologically unable to behave. And I mean, his misbehavior we've seen has been largely of the sovereign citizen variety, but even if he weren't a sovereign citizen, I don't think he'd be behaving. It's just misbehavior is his default. He like I said earlier, the judge put on the record that he was diagnosed as having a personality disorder. I would not be at all surprised if that's oppositional defiance disorder. That's the one I was trying to think of earlier. Because to me, a lawyer, not a psychiatrist or psychologist, it makes sense. It it just makes sense. And it's frustrating. He's been in the courtroom next door. How long does it take to walk from one courtroom to the other? I mean, are they taking him across town? Which that's a great song by Jimi Hendrix. It's one of my favorites is Crosstown Traffic. Great guitar on it, but it's also very good use of the technology that was available at the time, the fading in and out. One of my old bosses had his stereo set up appropriately, and he says it was really cool listening to that song because it was a 3D immersive experience, and but it did take the right setup. But even listening to it on headphones, you can see what he was describing. It's I realize it's irrelevant to this trial, but that is one of the better Jimi Hendrix songs, in my opinion. I imagine that jury's getting hungry. It's 4:43 here, 5:43 there. It's getting awfully close to the point where the court's going to be obligated to give them dinner. Although, unlike some trials I've seen where the jury agreed to stay until 8 o'clock or 8:30, that's when they really have to provide a dinner break. If getting out at 6, it's dinner time, but the jury would probably be more annoyed by
Then before we bring out
dinner
the
break.
jury, if we need to talk procedure
I guess
or
that
Attorney
makes
Wichow,
sense.
if there was something you wanted to address.
Take the jury out during the transfer.
I think there may have been some misunderstanding on the nature of this statement in question. This witness provided a statement to a police detective who then wrote a police report summarizing the statement. So the proper method at this point for the defendant would be to confront her by orally quoting from that, asking if she said or didn't say these things. To show her this statement isn't we're not refreshing her recollection. She didn't write this.
I see. So I didn't know that, but that certainly makes a lot of
That
sense.
is good.
Mr. Brooks, did you hear
Argument
what
on the
Attorney Wichow just said
prosecutor's
about
part.
the procedure?
Is it a way to verify that is in fact procedure? Just to be clear for the record.
If you were an attorney or had an
Yeah.
attorney,
I had referenced
you'd know
earlier
how
that
it
I thought
works.
you were trying, we might be showing her the statement to help refresh her recollection, but I don't have any of the statements in front of me and I wasn't aware.
Because that would be
that it's,
inappropriate for the judge to
the police
have it
report
until
that
it's in
may be
evidence.
referenced is written by someone
the
other than
document
this
itself
witness. She wrote a statement apparently, but the
is
police
not
report is a
Evidence
summary of her
until it's
statement.
admitted as evidence.
So
how it that kind of makes it problematic though. You could probably see what I'm getting at, Your Honor, by if it's a summary of what she said.
do you have the statement of what?
Which
you
means
have
it's
written
not a
statement of
complete
hers?
record,
Yes, I'm trying to get
word
back to
for
it.
word of what she
I got
said.
a lot of stuff coming over.
I know.
So impeaching her on it
Once he finds the
She can
statement,
just say,
I suggest that Mr. Brooks
the officer must not have written
read
down what I
directly from the
said.
statement, the portions that he's asking the witness about, and ask her if she did or didn't say those things he's reading.
Does the state have
Whereas
it
the
available to put on the
absence
monitor
of
if he's having
something she
difficulty
says
finding his copy?
That she said,
Let's do that, please.
she said isn't a great
What
Beatles
was
song.
that? The last part, I'm sorry.
But
It'll be on the
it's
monitor in
not
front
proof
of
that
you.
she didn't say it,
Oh, we can.
not
yeah,
being
there you
in
go.
the
If you
police
can't
summary.
find, this is this.
I wouldn't be questioning her about that on cross-examination. It would be if she said something that was inconsistent with what was in the
Why don't you
police
read that?
report.
To yourself and see if that helps you formulate a question.
But that would only be if it's a positive difference. Like if the police report said, Mr. Brooks was calm and collected and brought us ice cream cones and then got back in his car and drove off. And then she testifies, he was angry and making death threats. That's a difference. Whereas
you need
he
to
got
scroll
out,
down a little bit.
was yelling and screaming. In the police report, if it said he got out yelling and screaming, tried to get her in the car, and then drove off.
That's all I need.
That's not
Okay. Do you want any part of this shown
conflicting.
to the witness?
Whereas the ice cream cones would be.
Yeah, I want to go to that top part that I read first.
Oh, actually, I think we were talking about, he doesn't need to refresh. I don't think it's been established he would need to refresh her recollection yet. She's testified from her memory. So you can use what's in this statement, sir, to formulate questions on cross-examination. And you can use leading questions. So at this point, I don't need to show it to her, but you can ask questions. We'll bring the jury back out and you can continue.
Would this be left up for me to see though? Wow.
We can leave it up.
We can leave it up.
Okay.
Is the part that's up sufficient, or do you need to scroll up? Does the state need to scroll up a little bit for you?
I would only need this part that's on my screen now,
Okay.
and then you whoever's stroll down a little bit past that to the second part.
Scroll.
Up.
It's a
How about that?
C, not a T.
You should be able to see both
You're not
parts now.
strolling through the document. You stroll
Starts
through
with
a
in
bar.
summary near the top,
Yeah.
and then that's page 2 of 5, and then down below, presumably
I
it says
will
3
be
of 5,
petty
but
about him. At some point, I'll start being petty about him saying
I'd like to bring the jury out, so let me know
instead
when
of
you're ready.
ask.
Okay, I'm ready.
All right, let's have the jury brought back in. Mr. Brooks.
But
you're
that's a
gonna-
common enough
Good job, Ed.
occurrence from other
Coming up with
people.
questions and
attentive.
following the process, and I appreciate you asking to come back over here.
Whereas stroll versus scroll is not. So I will be petty on that one.
Hot.
Oh, you'll take off your mask to drink, but when ordered so that you can be identified. Nope, nope, nope. You can't see me if I can't see you. La 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 la. He acts like a 2-year-old, so I'll talk about him as if he's a 2-year-old. Someone needs to be careful with that microphone. And I assume that's him leaning over a microphone, but that's brutal. Here comes the jury.
All right, thank you, everyone. Please be seated. All right. Mr. Brooks, when you're ready, please continue with your cross-exam.
Okay. I'll give everybody time to settle back in for a few seconds.
Or you can go. Or psych yourself up, or it's irrelevant.
So, Miss, is it Runkle?
It is.
You should know your
you
the
stated
witness's
earlier,
name.
that when you were hanging out with Erica at the park that you were drinking, right?
I did.
And you also stated that you guys separated and you went to go hang out with someone else.
With Nick. Yes.
With Nick. You did state that Nick wasn't drinking, right?
Yes.
So I want to ask
X.
earlier when I asked, well, I think you
He's
were asked
really
by,
getting my petty up.
Attorney Whitchild if you heard any yelling or anything being yelled at Eric, or I'll forget how you phrased the question, but did you hear any yelling or anything directed towards you guys? And do you remember what you said?
I heard that you were yelling at Erica, telling her to get in the car, and that you were gonna kill her. That was you were gonna kill her was after the fact that you headed out, but that's probably not what you're asking. The fact of you were yelling at her, telling her to get in the car, was the time when you were around.
This really isn't helping
Oh,
him.
sorry,
He's
Brooks
giving
was
her by keeping at
Brooks
this,
or you?
he's
You
giving
said-
her
you said
more
you and you
opportunities
said
Brooks.
to testify that he said
But you did
he's
state
going to kill her.
that
He's going to kill her.
you had
He's
never
going to kill her.
seen Brooks
You should have dropped
before
this.
November 21st of 2021. Would that be
Right.
fair to say?
Right.
Asked and answered.
And you also did say that you had only heard of him through Erica, correct?
Right.
And then she
At
saw
any time,
you.
did you ever observe any phone conversations
At
or
the scene.
interactions between Erica and Brooks?
Am I allowed to answer that?
He's just
And notice
you
he's
whether
saying
you have not the
Brooks.
content of any of those.
I
Not
have.
me, or not the defendant, not
Would it be fair to say that
whoever
you
was
knew,
there. He's
a
saying
lot of details about their
Brooks,
relationship? Would that be fair to say?
because that's the
I did.
sovereign citizen. The
Um,
name versus the person.
what specifically did you know before November 21st, 2021?
That she was dating a guy named
Sure,
Brooks.
you want to ask that question. Think about some of the pretrial rulings I've made.
Motions in
rephrase that?
limine.
Okay, good idea.
I'm sorry.
Things
I'm
have been
new.
excluded.
So
And it was excluded
in your
by
statement
the defense.
that I'm looking at right here on the screen, it says
So he was
it
opening
is
the
Runkle,
door.
right?
Yes.
I don't want to mispronounce your name.
If it had been
It says,
excluded by the
Runkle
prosecution, they would have
further
just
stated
objected.
that she
It was
heard
object. It was
Brooks
his attorneys that got
telling
it
Erica he was going to
excluded.
smash her face in and that he was going to kill her.
Yes.
That
The judge really helped him there. I don't know
I'm
what
sorry.
it was, but he
is that what you heard?
was opening the door.
Yes.
So you didn't hear what you just testified to hearing,
No.
or did you hear what I just read to you
I heard that after you were leaving.
after?
Not that
She was
what you just
informed
read.
it
I
was
heard that
Brooks
after you were leaving.
after you left.
You do know that this
But
is your
she saw
statement that I'm
you.
reading from, right?
I do.
We've established that, and this is argumentative.
Sustained. Rephrase.
I'm trying to figure out which one did you hear.
Objection, vague.
Did you hear the I'm going to smash your face in, or did you hear what you previously said?
So
Well, I heard when you were sitting
she
there
heard
arguing with
threats.
her, I heard that.
She heard
Who is
threats.
the you you're referring to?
Oh, I'm sorry. Brooks said that when he was arguing with Erica.
And you claim that it says right here, but through knowing Patterson, she did know that Brooks was Erica Patterson's boyfriend. Did she ever tell you that Brooks was her boyfriend?
She said you were, or I'm sorry. She said Brooks was her ex.
Don't play into his game.
I'm a little confused by the statement and then the
Don't
testimony.
play into his game.
That's not a question.
Brooks versus you versus.
Sustained. Mr. Brooks, you need to formulate a question for the witness.
Did you
okay?
ever hear, man, this is coming from your statement, Runkle stated that after a short dispute between her, Kirby, I guess that would be referring to Nick.
Yes.
After a short dispute between her, Kirby, and Brooks, she saw Brooks get back into the red SUV and heard him saying something to the effect of, I don't swear, so F you, effing these, you're dead. Did you at any time hear anything like that?
Yes.
So
that
when
is
you
in
just
the
testified,
police statement.
why did that part of your statement never come up? Why did you never say that?
Because it probably wasn't brought up at that time, but it's in my memory.
So what all exactly did you hear?
I heard what you
Hold
were
on,
saying.
we've heard
That's awfully vague.
you say at this time, like the question's not clear to you, like what time frame, and who are we talking about?
When, because in the video it's clear that
Hold on. Go back
In the
to question. I
video,
didn't
there
mean
was
for
no
you to not
audio.
Ask it. I just want to make sure I understand.
It's not clear what was said from the video.
Specifically who you're asking this witness about statements that were made.
I'm asking about who she said was the individual driving the vehicle.
You.
That's different than
She
what you just asked. So if
identified
you wanna
you.
change and
Because
go
you
to that,
just
that's
gave,
fine.
you just
She identified
clarified
you.
it.
She didn't identify Brooks. She identified you.
What exactly
That's why
did
you took your
hear
mask down, because
coming
she
from
saw
the individual
you.
who was driving the vehicle?
I'm sorry.
The name of the individual she saw is
Exactly.
irrelevant. She saw
At
you.
the point that I guess I would refer back to the video at that point that we saw on the video.
This is
So we'll play
painful.
the video. There's lots of points. That was many
this is-
minutes long.
Right.
This is so painful.
I'm not. I think it was
Can you describe what part of the video you want?
the
her
part
to
of the
talk about?
video. The part of the video when that she testified to, where she said she had the green gloves, and
So
she was
in the
standing.
beginning
She was
of the
standing
video?
no, it was like towards the middle. She was standing in the street, and she said she had the green gloves because I think somebody asked her which one was she.
Right.
It's
And she
6
said the one
o'clock
with the
in
green gloves.
Wisconsin
I
now.
remember that.
At that point,
This
did you
started at
observe
7:30.
anything being
Well,
said out of-
8:30
out
this
of
morning, Wisconsin
said
time.
vehicle? Did you hear anything
8:30
being
to
yelled
6.
or
This is
screamed
a
or
long
anything
day.
like that at that point?
Well, before I showed up, I heard yelling.
You heard yelling before you showed up.
Yeah, because like before I showed up into the video.
So how far were you down the street that you were able to hear what
Within
was
yelling
being said?
distance.
Objection.
Not
Calls for effect, not in evidence. She didn't say what she heard. She didn't say she could understand what was said.
She heard yelling. She didn't hear. She didn't say, I heard you yell
She can
this.
answer the question. I'm going to overrule it. I understand what the state is saying, but I think he's trying to
Not that it
establish
matters.
where she was at that point in time. So go ahead and answer.
No, okay. I was right where you pulled up the second time.
Are you sure you know what I was asking?
It was not entirely clear to maybe all of us, but I was trying to give you some leeway. So
I knew you understood where I was going with that. Were you at
Your
a,
question
let me
wasn't
say it
very
like this, were
clear.
you at a distance before you came into that
How
video?
far
Like,
away were you?
approximately how far away were you from the vehicle and from Erica before you heard anything being yelled or screamed, as you said?
I was at a distance.
So would it be fair to
Okay,
say
that's
that it would be
vague.
hard to hear the conversation that was being had?
Not really. Brooks was yelling pretty loud.
So you were able
Don't play
to
his game.
hear the
Say
gist of the
you
conversation
were
from the
yelling
distance
pretty
that you were
loud.
at,
Yes.
even with a parade going on and a street full of people, you were able to hear
This was
from
a
distance,
different
which you just
street.
said you were at a distance, you were able to hear the gist of the conversation.
The parade was nowhere close.
answer the question. Were you able to hear?
Oh, yes, sorry.
You were able to hear, even
Asked and
testifying that
answered.
you were drinking vodka.
Yes.
Did she pour the vodka in her ear?
What else did you hear?
At what point and by
Asked
whom?
and
At the same
answered.
point, what did you hear from Erica at that point?
Objection.
I
That's
don't remember.
hearsay.
But you
Erica's
remember
not a
hearing
party
something
opponent.
from the driver of the vehicle who was inside of the car.
Yep.
But you don't remember what you heard from Erica, who was outside of the car and would be more easier to hear.
Okay. Thank you for being specific at that. I
You're
remember
welcome.
Erica
Questioning
sitting
with
there telling me
specificity is
that
very important.
she wanted to go.
So she was telling you that from you being at a distance.
No, she was right next to me. That was when she was walking towards. She said, "Come on, let's go."
At what point was that? Because you just testified that you were at a distance.
A distance from
I'm also going to object to
you.
the manner in which this defendant is asking this witness.
She was
these
a
questions.
distance
He's intentionally
from
misleading.
you.
He's trying to confuse her.
Mr. Brooks, the purpose of cross-examination is to ask questions that are relevant, test her credibility, other things like that. It gets to be a little confusing, at times maybe a little argumentative. I don't have all the reports in front of me, so I can't say whether it's misleading or not.
A
But
good
ask a
attorney
direct question. You're able to
will
ask
take
leading
into
questions
account
so that she can
the
answer
jury.
directly. Be as specific as you can, time, place, circumstances.
And
It's
he's not
helpful
coming across
for
good.
all.
I mean, the video is very clear.
The jury is not
Well, you can't
liking
testify
him.
right now, right? You can't make an argument about the video. So your opinion about it right now, that's not
I wanna-
appropriate.
I want to.
Keep going.
He's
For
mad.
the record, the objection was sustained.
You made a reference to being a reference to chesting up with the driver of the vehicle.
That is
What was said at that
slang,
point between
so-
you and who you were chesting up with?
Well,
She already identified that it was
go
you
back to that.
she was chesting up.
I was sitting there saying that you shouldn't be hitting a woman. No, Brooks should not be hitting a woman.
Don't play his
And
game.
Brooks was saying
Don't
that
play his game.
Erica Patterson is not a woman.
Are you sure that's what you heard at that moment when you were chesting up?
I have
in
a
your
lot
words?
I want to say about
You
that
sure that's what you
last
heard?
comment, but I'm not
What
going
then
to
happened from that point?
because it wouldn't be kind to
Then we started
either of
brawling
them.
it out. Oh, me and Brooks started brawling it out.
Rolling
What do
it
you mean by
out.
brawling it out?
Or,
No, threw a couple punches.
oh, I didn't hear that.
I threw a punch. Brooks smacked me.
That didn't come out on
Hmm.
direct. Makes him sound worse.
So
He
did you
smacked
put that
her.
in a report that you made, or the summary of the report that you gave to, I think it was Attorney Wichita said a detective?
Objection, there's no evidence. This witness prepared a report or a summary.
Sustained.
Once again,
Did you
the
report that
report
in your
isn't her
report?
complete record. A good cross-examination would be if she said,
it's in my memory, but
he didn't hit
I
me.
hope I did.
And then she comes out on testimony and says, oh yeah, he hit me. Then you impeach her with her statements that
Would it be fair to
he
say
didn't hit,
that if you had just brawled with someone
but it's not being
and talked to a
present
detective that you
isn't
would
good
report it?
impeachment,
Would that be fair to say?
especially when she didn't prepare the report.
Can you say that again?
Would it be fair to say that if you had just had a brawl with someone
I really don't like
and
the
you
forms
talked
of this
to
question. Would it be
police
fair to say?
directly after the brawl that
Those
you
are
would
weasel
report it, would that be
words.
fair to say?
From a weasel, to be fair.
I was
But
Yeah.
it doesn't make him
I know you're
sound
asking a question,
more
but-
polite,
Hold on,
more
you need to
reasonable,
ask- You do need
which
to
I
ask-
think is what he's
Okay.
You do
going
need to
for.
answer his question. It called for a yes or no answer.
Okay, it's not in the report. I specifically said,
Hold
I-
on, I have a question
Oh,
though,
I'm
okay?
sorry.
So that's okay. Ask your next question.
Would it be fair to say by the video footage that there was no brawl or punches thrown by either party? Would that be fair to say?
there was.
Can we show the witness the video again?
Are you asking her whether the video shows a brawl?
Would it be fair to say that the video shows a brawl in which you just said that punches were thrown?
Didn't she
That'd be fair to
say he
Okay, so
stopped
what's a brawl to you?
twice?
You can't.
Oh, I'm sorry.
I know.
Okay,
I think
well,
hold on, Mr. Brooks, are you trying to ask whether are you gonna confirm with her that she saw the video and then on that video, you cannot see a brawl between her
And it is
Mr.
a
Brooks?
very
Is that what you're trying to get
small
at?
video.
A version of that, yes, but I was
From
You
a
gotta ask the
distance.
questions,
I was
though, to
gonna
get to
say-
it.
Hard to tell
Can the
exactly
video
what
be shown to
happened.
her again?
Ask your questions, sir.
In the video that you saw, would it be fair to say that a brawl was not depicted on that video? Would that be fair to say?
She didn't say it was a brawl.
I don't know.
Well,
if
I guess she did.
What's depicted?
Can you see it in the video? Is that what you mean?
Yes,
That's what I mean.
yes, I could see. it.
Although I wouldn't
You can see the brawl?
classify
Yeah, it's,
a punch and a
no,
slap as
I
a
won't
brawl.
say it's a brawl. It's just a couple, it's just like a
It's a
push,
scuffle.
looks like a push, but it was a smack. And I got up and, yeah,
You got up, so you
I
were
got up and swung.
you were knocked to the ground.
No,
So where did you get up
from being pushed and smacked.
So
She
you fell to the
gathered
ground.
herself.
I didn't fall to the
Asked and
ground.
answered.
Sustained. Next question, sir.
So would it be fair
This
to
is
say
the problem with.
that in the video it
imprecise
shows you
language.
being knocked to the ground?
She said she wasn't knocked to the ground.
I was not knocked to the ground. I staggered back.
Would it be? I got kind of
Good old technology gremlins.
You and me both.
I,
People need to make sure their phones and other electronics are not audible.
would it be fair to say that the video does not show you being knocked to the ground?
She
at
already
any
said she
point?
wasn't knocked to the ground.
Would that
Asked
be
and
a
answered.
fair assessment?
So I'll object it to relevance because the witness never testified that she was knocked to the ground. So this is not a question aimed at her credibility.
She just said she got knocked to the
No,
ground.
she
She did
didn't.
not.
She said she
She
staggered
said she
back.
got up. I'm sorry. She said she got up, which would constitute
And she
being.
clarified she
If you're not knocked
she
to the ground or
staggered back.
down,
War
you can't
words
get up.
here, Mr. Brooks.
I'm sorry. I'm sorry.
It's okay. No, she was clear. I think she clarified what it meant by getting up, and it might mean
She's
something
stuck in
different
a
to you than it
feedback
does
loop.
to her. But we need to keep going.
So can I ask what is getting up? What does getting up mean to you?
Stagger back.
Recovering
So
from
it
staggering
would
back.
be fair to ask you then,
Acts.
does the video show you staggering back?
It does.
Does it show you being, as you called it, smacked?
It does.
Can we show her the video again?
Go ahead. Play the video.
If that's what it
Jury or to
shows,
her?
showing it to
All
That's when we publish it.
I think it's an exhibit, sir, and let's publish it. Okay.
and if he's wanting to just show
Your
her
Honor,
and not
would
the
it be
jury,
too much to ask if we went straight to that part of the video?
it does him no good to say,
I don't know.
well, did you
I'm
see a
guessing
scuffle
this might
there?
be it right here.
It's coming up.
And she says,
Let's just watch.
yes,
We'll ask questions.
if the jury doesn't see it again.
We're playing from 3 minutes and 9 seconds on exhibit 3.
Yep. Yep, that was a scuffle. It's hard to see because it's right on the very, very edge of the video, but there were hands.
You can.
That was so
For the
dumb of
stopping the
him.
video, please.
3 minutes and 47 seconds.
That just bolstered her credibility, hurt his,
All right.
and
Any questions over there,
he
based
came
on that?
across as
question
an
would be,
ass.
You just viewed the video again. That'd be fair to say.
Yeah.
At any time in that video, were you in fact smacked and staggered back?
Yeah.
Can I tell the exact time?
If you know, yes, go ahead.
At 3:23.
Can we see 323?
Once again, it was asked and answered.
Go ahead.
He has asked this so many times. It's inappropriate.
We'll start it a little bit before, so make sure to capture it. You should be able to
But
see it.
every time he asks and she says, yes,
24.
Okay.
you smacked me, you pushed me, whatever.
We went from about 319 to 327.
He's just giving her another opportunity to say,
My
yes,
question again
you
would
were
be the same
violent
question.
towards me.
You just saw it again.
Same question. Asked and answered.
In the portion of the video you just saw, would it be fair to say
Except it would be dumb for
Your
the
part.
prosecution to object,
your interpretation
except to get him to move
that you
on.
were in
Because
fact
once again,
smacked and
Gives her
staggered
another
back?
opportunity to say yes.
Yes.
And this hurts him every time she says
Well,
yes.
Are you sure you weren't over exaggerating that?
No.
It looked like a push.
So you hit her.
And
Would you say
You
again what
put
happened
hands on
directly
her.
after that?
That's the important part.
Directly after the smack,
Directly after what you say is a smack.
staggered back.
No, directly after the whole
Directly after, she staggered back.
incident.
I call it get up, but I came
She-
back.
She
Came
gathered
backwards.
herself.
Swung.
It's imprecise
Would it be
language,
fair to
but
say that the video doesn't show any of that you just said? Would that be fair?
no.
It shows it somewhere.
Like right
So
after
would it be fair that you're
323.
saying your interpretation of what you just saw would constitute a brawl, as you say, or brawling it out, as you say?
Hold on, Mr.
Brooks, I've given you a lot of leeway on this topic. What's the relevance of all of this at this point? I think you made your point about
thought
what happened and what didn't, and what's in the video and what's
Was
not.
he
and the
charged
jury
with
can
hitting
ultimately
her?
Decide that. You can argue it later
Or
on.
just
I'm
with
sorry, I
hitting
thought
the
this
girlfriend?
statement
Where are we going?
Ex-girlfriend.
Object to that. If they saw an objection, I'm a
What?
little confused about that.
Wait, you're objecting to your
I
own?
need the questioning to kind of circle back to what's relevant for the trial.
Well, I thought it was relevant because of what the video is actually depicting.
And that video is going to speak for itself. It's been an exhibit.
Yes, it
And
does.
so you've asked a lot of questions about it. So let's move on. Under 906.11, that's my authority. I'm telling you to move forward.
Okay,
Next line of
Did you
questioning.
hear anything
I
after
think
the,
Brooks is
as you say,
dumb.
brawling out? Did you hear anything coming from the vehicle?
He is
Was
not a
anything
smart
said to you
man.
directly coming from the vehicle at that point?
Do you understand the question?
Would it be after you leave? Oh wait, Brooks leaves?
Don't play his
Or
game.
when
I was
Brooks gets
clearing
in?
what I just asked after the brawling it out.
But you asked directed at her, and then you said anything from the vehicle. So that's a compound question. So you need to be specific.
Did you hear anything after the brawling it out, as you say? Did you hear anything directed towards you?
Directed towards me? No.
Did you hear anything directed towards Nick?
I remember something being said.
Do you recall what was said?
Sometimes.
I do not.
Did you hear anything directed towards
At this point,
Eric?
I'm about to stop thinking.
Yes.
What did you hear directed towards Erica?
I'm gonna kill you.
At what time?
I'm gonna strangle you. I'm gonna.
Right after the brawling it out, as you say. Did you hear anything directed specifically towards Erica?
Not till he left. No, not till Brooks left.
Would you say that again?
Okay,
Not
that
till
doesn't
Brooks
make.
left.
So did you or did you not hear anything directed towards Erica after the brawling it out, as you say?
Oh, okay, no.
So it was all before
So
the
can you pull
violence.
statement up again.
Go ahead. The state would do that once again. Just to the preview.
This should have taken about 5 minutes. The estimate of a month for the trial
I'm reading directly from the statement
is not going to
where it
be
says,
accurate.
It may or may not be a statement, so you need to be accurate. I know you're referring to
the
police
summary,
report.
the summary of the statement. I'm reading directly from the summary of the statement where it says, Runkle stated that after a short dispute between her, Kirby, and Brooks, she saw Brooks get back into the red SUV and heard him saying something to
And
the
once
effect
again,
of
she
"F you
identified
effing
you."
bees, you're dead," as he was leaving.
So I'll check on 2 grounds. 1, asked and answered, and 2, this could confuse the witness because it's not. She used the F and the B.
She's gonna make him
Sustained.
swear.
It was something on the back end of that I didn't get to.
I'm not sure what you mean by that, sir, but
It was-
you've already asked that question before, so the objection is sustained.
I actually don't recall asking a question directly to that part of the summary.
I do. You read through that previously.
Do
Yep.
you remember what the question was so that I don't
Multiple
re-ask the same
times.
question?
Mr. Brooks, move
Asking
on.
the same question using different words is still asked and answered. Or maybe I should say
Did you
asked
ever
and
hear
answered.
something to the effect of F you F and B's, you're dead?
Yes,
I did.
she answered it already.
At what point did you hear that?
While Brooks was leaving.
So that would it be fair to say that you heard that after the brawling
Yes.
gets out?
You shook your head. Can you say
Yes.
it? Thank you.
That's a little confusing. So
Mr. Brooks, that's not a question. You're
I'm
attempting to
about
testify.
to ask a question.
You
If I
can't
can
do
get
that.
to it,
Ask your
You
question.
can't editorialize.
But you also can't mischaracterize the testimony or the evidence up to this point.
what do you mean?
You can't editorialize. You
In your
can't say
questions,
that's
you
misleading.
Can't mischaracterize prior testimony or evidence. You have to be accurate. So
I'm trying to be, but
The
it's
jury gets to decide if it was
What's your next
misleading,
question,
not
sir?
you.
hard.
And it wasn't misleading or
Just a quick second.
hard to understand. She was very clear. She heard it
unless you have a
As
different
she
topic,
testified
It
anything-
is,
hold
it
on.
is.
multiple
Anything
times.
related to this, what's in the summary, the questions regarding what she heard or didn't hear around this time, we've gone through that. You've gone through it.
On and on ad nauseum.
90611,
It's
you
been
need to move
done.
on and ask a new line of questions.
I was trying to, if I can get to it.
Go ahead.
They should make him buy the jury dinner on his 11 cents an hour jail
This
salary.
part of the summary that I'm looking at now says Runkle stated that she did see pictures of Brooks following the Christmas parade incident via
So
social
she made
media,
a positive
and
identification.
Runkle confirmed that was Brooks was the I don't know, it looks kind of.
So she made a positive ID, like she did in court.
Going through, okay. I couldn't read it.
I'll object. I don't think there's a question there.
Right.
I didn't get to it yet.
Well, then I'll object to the ongoing commentary with lack of any questioning.
And I'll sustain that objection.
I like this young attorney.
Well, I do have a question. You said that you had known Erica roughly since you were roaming up at the women's shelter. Would that be fair to say?
Yeah, we established since October.
Do you have any idea why she would refer to you as Corey Gray?
Because I go by that.
So how close would you say you guys were?
Close.
Close enough they were
like,
hanging
hung all
out.
the time, every day.
They lived with
Yes.
each other.
Hung out every day. Sorry.
Once again, this
And
doesn't disprove what she
do
saw
you
with
know
her
of
own eyes by someone
any
she
time before
identified as
uh,
you.
November the 21st of 2021? Do you know of any time before that Erica mentioned to you anything about the relationship that she had with Brooks
He's maybe
outside of
opening
what
the
you
door to
learned
something.
that day?
I think
Can you say that again?
he's opening the
At
door,
any time before November 21st of 2021,
not
Erica
knowing what
ever
was in
confide
the
any
exclusion
information
motion.
to you before that day?
She did.
What was the nature of the information?
He's walking a dangerous
It's not
line.
allowed to be brought up.
I think she's referring to a pretrial ruling that she's aware of.
Yep.
So you want to rethink asking that question, sir? Otherwise, I'm going to allow her to answer it.
What pretrial,
I'm not gonna say-
no, I'm not.
That
are
would
we both
prejudice.
privy to the same pretrial procedure. There was a pretrial ruling about.
He's getting help from the prosecutor.
Do you want her to answer that question or do you want to move on?
I want to move on.
All right, I'll
If the
strike that
prosecution
question
has
from the
had
record. The jury
asked
will
that
disregard the
question,
That was asked.
his former attorneys would have objected, but he can answer it and open the door. The judge and even the witness, Miss
So
Runkle,
I would want to ask, was there any
are helping
during
him. And
the brawling out point? Was there any interaction between the driver of the vehicle and Nick?
There was.
the
Do you
driver of the
remember
vehicle.
what the nature of that interaction or exchange was between those two?
I don't know. I just remember jumping in front.
Do you recall any threats being made towards Nick or from Nick towards the driver of the vehicle?
Oh, I do.
Overruled, she may answer.
I do.
Do you remember what was said specifically?
Not specifically, but I remember
It's hard to
Brooks getting
remember
mad
word for
because
word almost
Nick
a year later.
was coming to Erica's rescue. Right along with Corey. Me.
Do you recall any knife being involved in any of that situation
No
during
knife.
that exchange whatsoever?
No knife.
Were you aware that that was why police was responding to that incident?
I did not.
Did you at any time have a knife during that incident?
I did not.
Do you know if Nick had a knife during that incident?
He did not.
Do you know if Erica had a knife do you know if Erica had a knife during that incident?
She did not.
At least not that you saw.
As far as your memory, do you recall reporting that a knife was involved in that incident?
I do not.
Do you recall if Nick reported a knife being involved?
That would be a question to ask Nick.
It's possible.
Do you recall Erica reporting that a knife?
That would be a question for
I do
Erica.
not.
Or for the officer that took the report. Because the police officer
drinking a half pint
properly
of vodka
would
that
have
day.
separated
Was
them
that the only thing
to
you had to drink that day?
question them individually. So she shouldn't know what
Would
the
it be fair to say
others
that you were
told the
tipsy?
police officer.
Yes.
Would it be fair to say that you may even have been intoxicated?
No.
Half a pint she probably was, but
For any reason,
it is a
that day-
subjective thing, the way he's asking her.
acknowledging that you were drinking, would that have impaired your thinking of the situation in any way?
No.
So would it be fair to say that you were of clear and sober mind during that whole incident after drinking a half pint of vodka?
Yes.
So there, to the best of your memory, there wouldn't be any reason why you may have left something out or maybe not been clear about anything that happened during that specific incident.
possibly left some things out.
It's hard to
Do you remember what they might have been?
include every single thing.
No.
Do you know the plaintiff?
Objection for previous reasons.
Sustained.
Have you ever seen the plaintiff?
Objection.
Sustained.
He's grasping at straws now. And she wouldn't even know.
Have you ever
What
had
he's
any
asking.
interaction with the plaintiff?
Objection.
Sustained.
No further questions, Your Honor.
Thank you.
Finally.
Very, very briefly, Your Honor.
Go ahead.
Ms. Runkle, you met with Detective David Van Els to provide a statement on November 22nd of 2021. Do you remember that?
Yes.
That's accurate?
Yes.
Okay. Do you remember telling Detective Van Els, when he was asking you about this incident, that when you arrived, you heard Darrell Brooks telling Erica Patterson that he was going to, quote, smash her face in and that he was going to kill her, end quote?
Pounding the point
Yes.
home.
Okay. Do you remember telling Detective Van Els that as you saw Brooks get back into the red SUV, you heard him say something to the effect of, quote, fuck you, fucking bitches, you're dead, end quote?
Always
you.
take the opportunity to
During your
swear in court
cross-examination,
if you can do
you
it without
repeatedly
contempt.
referred to
That's by direct
a person
quotes.
as Brooks. The person depicted in the video, Exhibit 3, the person that you chested up to, is that person in the courtroom?
He is.
Can you point him out for us and just very clearly tell us where he's sitting, what he's wearing?
You want me to point?
Yes, please.
That-
Alright, he's
Isn't this what I said I'd do on
I asked that to
redirect?
reflect the witnesses
I'd ask the
identified
witness,
the defendant,
can you
It will.
and I have no further questions.
positively identify
Thank you.
who was in the
Thank you,
video?
everybody step down.
All those games about Brooks versus you were ridiculous. Because she
All
could
right, ladies and gentlemen of the
she
jury.
could
this will be a
positively identify.
Excellent stopping point for us this evening. Thank you for your patience.
It's an hour and a half
this
past an
evening,
excellent
I
stopping
do need to
point.
go through one instruction with you. Do not begin your deliberations and discussion of the case until all the evidence is presented and I have instructed you on the law. Do not discuss this case among yourselves
These are
or
standard.
with anyone
She's
else
going to give
until your
it
final
Every
deliberations in
time
the
the
jury
jury
room.
goes to lunch
This
and
order
every
is
time
not
they go home
limited
for
to
the day.
face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them.
This can
For their
happen in
part, the
the
parties,
courthouse
lawyers, interpreters,
hallways and
interpreters,
elevators
and witnesses will not contact or
bathrooms.
speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene, either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the
Law
internet, or other
books.
reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics, application, or tools with communication capabilities to share any information about this case. For example, do not communicate by telephone, blog post, email, text
She
message,
said blog
instant
post a
message,
lot
social
clearer
media post,
this
or in
afternoon.
any other way
I heard
on
block
or off
post
the
this
computer.
morning.
Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After the trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has any reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, you are excused. I will provide information to Pete and Mike shortly as to what time we will start back up tomorrow. Thank you. All rise for the jurors.
Notice he had his mask off there. Just fine. It's just for identification. Nope. Even though he was in the other courtroom for the identification. It's his rules. It's his game.
Mr. Brooks, I want to commend you for a couple of things. Number one, asking to come back into the courtroom. I really appreciate that. I appreciate you being here. I think it runs
This is the judicial
much smoother when you
participation
are here,
trophy.
assuming you follow all the rules, which you have done a very good job at this afternoon. I also
Scratch
want
his
to
ears.
commend
Good boy.
you
Good boy.
on cooperating with the process even before you were brought over here. You were respectful. But you also made appropriate objections.
Well.
You asked questions on cross-examination. Despite not wanting to unmask at first, you did do that, and I appreciate that. You asked some cogent, relevant questions, some of which
Once
went
again, she's
directly
dotting
to
the I's,
credibility
crossing the
of
T's,
the witness. I would
making a
add, you might
full
not always
record.
artfully ask the questions, but I think you're making some solid points. I would encourage you to keep prepping, to have questions written out based on the materials that you have. I really appreciate that you came back over and that you've been following the rules. I also want to encourage you, sir, to, if you choose, to wear your suit or other street clothes. It is your choice. I will let you make that choice.
It does help.
But I encourage you to consider that. I don't think there's anything we need to address other than perhaps timing.
That's
we
why
went
I
a little
stayed.
bit late here tonight, so I think I'm going to have the jurors report. I tell them we're going to bring them into the courtroom at 9. That usually means a little bit earlier with their protocol. We'll still start at 8:30 to address any housekeeping items
That's
at
too
that
early.
point in time. Is there anything the state wants to address right now or any record you want to make?
No, Your Honor, thank you.
Mr. Brooks, anything you want to address right now or any record you want to make?
No, just thank you for giving me a chance to come back in. And I appreciate it.
If you behave, you can stay
It
in
works well when
for
you're
the
here,
whole
sir.
trial.
I hope we
Just
continue
say
this.
something very, very quick. I was waiting for my COVID results to come back before I feel comfortable getting back dressed up. So I kind of just prefer to just stay in the orange right now.
Do
That's
your
your choice.
street
They
clothes
said I should
impact
be having the results. Hopefully,
that
by the time I
somehow?
get back, I might know something.
Or do you
If
just
I'll
not
know
want
something
to
tomorrow morning. So
infect the clothes?
that would be a big influence on.
Okay, fair enough.
That
The other
thought
thing is
process
I
makes
had
no
not been
sense.
utilizing an all rise. Sometimes you stand, sometimes you don't. It is something I'd like to go back to, especially as it relates to the jurors. It's out of respect for them So I will be doing an all rise for when the jurors
She can waive
enter and
rising
exit.
for herself,
Um,
but it is
and just given
appropriate
some
for
of
the
our
jury.
logistics, I'm not looking for an all rise for when I enter at all. So my bailiffs are aware of that. But that's it for today. Good night, everyone. We'll see everyone at 8:30 tomorrow morning.
And with that, I don't have much else to say either, except I'm tired. It's been a long day and it's going to be a long month. So, thanks for those of you who hung out. It was an interesting day. Certainly, the last couple hours have been more interesting, I think, than the morning was. But um, I'll head out, get some dinner myself, and hopefully see you bright and early tomorrow morning. So, couldn't have said it better myself. So, thanks for hanging out with me. See you tomorrow.